hate this noise. It's horrible. Ladies and gentlemen, please take your seats.
Buongiorno a tutti, io parlerò in italiano, ma un brevissimo.
Good morning. I will be speaking in Italian, but mine are just welcoming words. I would like to thank all the audience. A warm welcome on behalf of Ateneo Veneto. The President, Adela Magaraja, unfortunately cannot be here today with us. And she would also like to welcome you very warmly, as she was very much interested in this, in the topic of this conference. When Katharina Hüls-Valenti and Pierre Valentin first contacted the Ateneo for the organization of this conference, I very much supported and enthusiastically supported our patronage to this event, because fighting us side by side with important institutions such as the Foundation for Jewish Cultural Heritage in Italy, the Embassy of Israel in Rome, and the General Consulate of the Federal Republic of Germany in Milan was a great opportunity. So a lot of enthusiasm, as I said. Ateneo Veneto has always been at the forefront in initiatives that promote culture, just the causes, the promotion of justice, human rights. The theme of today's conference faces very delicate issues and will definitely offer a number of reflections that will be very useful in order to be able to proceed and to achieve justice. The artwork, which has been plundered by the Nazi fascists to their legitimate owners in the terrible years of the totalitarian regimes in the Second World War, are material evidence of barbaric acts against millions of innocent people. The recovery of these objects that indeed represent a form of memory, their restitution to the legitimate owners, is an act of justice, which may seem little compared to the genocide. However, it is indeed very important for attention to be attached by collectors and by all those who work in the artwork market with reference to the origin of objects that were plundered in order for them to be properly identified and given back. Today's conference invites us to reflect upon issues of legal nature, very often complex issues that have not been sufficiently faced here in Italy, nor have they been effectively faced here in Italy, and which are associated to issues associated to justice. It is important to discuss this transparently and civilly to set the basis for justice to be made. So thank you very much on behalf of the Ateneo to the organizers of this conference. We are very much honored to host it here. To the speakers and to the participants, we would like to wish fruitful proceedings and hopefully positive results will be achieved thanks to today's event. Thank you.
Grazie mille, Professor Carinci.
Thank you, Professor Carinci.
My name is Katharina Hüls-Valenti. I'm currently concluding my PhD in art history at the University of Mainz with a thesis on the art acquisitions of the Special Commission Linz and its dealer network in Italy. Alongside my PhD, I have started working as an independent provenance researcher. Given that I have literally immersed myself in the Italian archives over the past years, I have been able to assist museums and individuals in sourcing relevant documents about artworks that at some stage between 1933 and 1945 have passed through or ended up in Italy. During my research in Italy, I have often noticed a troubling unawareness of the topic of Nazi-looted art, which is why I felt compelled to work on this issue. Hence, I am extremely pleased that we have made this conference happen and that we are overwhelmed by the great response we received for this event. We had over 1,500 registrations online, and we are now about less than 100 in the room. A warm welcome to everyone. A special welcome to our speakers who joined us today from different European countries and also from the US to share with us their knowledge and insights. We are very excited about your contributions and look forward to stimulating discussions. Of course, a great thank you to the Ateneo Veneto for having welcomed the idea of this project with great enthusiasm and for hosting us today in this unique setting. We want to express our deepest gratitude to our sponsors, the law firm Boyce Schiller Flexner in Milan and the US, and Constantine Cannon in London, the multi-family office Stonehenge Fleming, and the H office, a museum and exhibition provider with strong connections to Venice. And of course to our patrons, the Fondazione per i Beni Culturali Ebraici in Italia, the General Consulate of the Federal Republic of Germany in Milan, and the Cultural Affairs Office of the Embassy of Israel in Rome. We are very thankful for your support.
My name is Pierre Valentin. I'm an art lawyer based in London. I also have a home in Venice, and I must say I'm feeling more Venetian than British or even Belgian, the country where I was born. So I'm thrilled to be here with you today in this beautiful room in the city I love. I've been working in the field of restitution since the 1990s when I was in House Counsel at Sotheby's, and since then I've been supporting, on the one hand, families looking to recover art taken from them and collectors who inadvertently find themselves in possession of Nazi-looted art, helping them to find solutions to their conflicts. Our objective when deciding to organize this conference was to shine a brighter light on Nazi-looted art and to encourage investment and research in the field. Italy was amongst the 44 countries that agreed to comply with the 11 principles on Nazi-confiscated art adopted at the Washington Conference in 1998. The question we asked ourselves was, could Italy do more to remedy the terrible losses inflicted by the Nazis in the years 1933 to 1945? There's no doubt in my mind that there are public and private collectors in Italy who would like to do more, but they don't know how. The purpose of today's conference is to offer solutions. That is why we have assembled an international group of experts who live and breathe the subject. They're here to share their considerable practical experience with us all. Our focus will be on private collections rather than museum collections. When a private collector decides to carry out research into the provenance of artworks in his or her collection, his or her objectives and motivations will be quite different from those of a public institution. For example, privacy and confidentiality can be non-negotiable for private collectors. We will address that important topic later today. The first three presentations will set the scene by reminding us what happened in the years 1933 to 1945. We will also find out why, for so many years after the Second World War, no one talked about Nazi-looted art, and why, since the late 1990s, it has become such an important topic. These presentations will be followed by panel discussions, and just after lunch, we shall look at a real-life example, the audit of the Cerruti collection in Turin. I think that this conference is even more topical given the horrors being inflicted by the Russian army in the Ukraine. Naturally, one can't compare what's happening today with the genocide of the Jewish people and other groups targeted by the Nazis. However, when I see cities destroyed by the Russian army and pain on people's face, I'm more than ever convinced that unless you remedy the mistakes of the past, you're bound to repeat them. That is why the topic of today's conference is so critically important. Before we start with the first presentation, I'd like to set a few ground rules for today. The conference is in English. Our lovely translators are at the back of the room and doing a great job. If you want to hear the conference in Italian, I'm not quite sure what you do actually, if you are in the room, but no doubt we will find out. If you are at home or not with us, there are two streams, one in English and the other in Italian. You can select the stream in the language you prefer. If you are in the room, please wear a mask. The speakers will not wear a mask whilst they speak, but as soon as they stop speaking, the mask will be on once again. The restrooms are to your left. You need to exit through this door to the left, and at the end of the corridor, you will find them. In the interest of time, when introducing the speakers, we will simply give their name and title. For more information on the speakers, please consult the program. There will be a coffee break at 10:45, lunch at 12:45, and a tea break at 4 o'clock this afternoon, served upstairs. There are two rooms, and ideally we'd like half of you in one room, the other half in the other room. We will invite questions from the floor. If you have a question, please raise your hand, wait for the microphone to be handed over to you. Please stand up, say your name, and ask the question. Please, one question at a time, and let's make the questions not too long so that everyone has the opportunity to ask a question. Unfortunately, if you're not in the room, for technical reasons, we are not able to invite you to ask a question. And finally, please check that your mobile phone is off. It's now a great pleasure to invite Katharina to introduce our first speaker.
Thank you, Pierre. I'm now delighted to introduce.
Sono felice di presentare il primo relatore della giornata, è Mike Hopp, professore per le ricerche tecniche all'Università Tecnica di Berlino, e ci parlerà della storia tedesca durante il regime nazista, concentrandosi sul furto di opere d'arte e la deprivazione di proprietà per la popolazione ebraica. Grazie, Katharina. Grazie per questo invito a questa conferenza così importante. Sono felice di essere qui oggi. Gentili ospiti, pubblico che ci ascolta da casa in streaming, avete un'opera d'arte o un oggetto d'antiquariato, un dipinto, un secrétaire, una poltrona? L'avete ereditata o forse l'avete comprata sul mercato? Vi siete mai fatti domande sulla sua storia e cercato di rintracciare le sue origini? A volte gli oggetti raccontano storie, ci possono dare delle tracce, delle indicazioni sul loro passato, con dettagli come timbri, etichette, abbreviazioni, numeri, cancellazioni. Gli oggetti hanno segni, hanno ferite, hanno cicatrici. Avete mai comprato un quaderno o in un negozio di libri usati? Controllate le dediche, i messaggi, le note. tutto quello che sta tra le righe. Gli oggetti ci possono parlare e possono dirci la loro storia. La storia dei vostri oggetti potrebbe essere collegata all'argomento di cui vi parlerò oggi, la storia tedesca tra il 1933 e il 1945, una storia di potere, di dittatura, di regime totalitario, una storia di deprivazione dei diritti, di persecuzione, espropriazione per coloro che per motivi politici, razziali o altri motivi non rientravano nella norma del regime. Una storia di brutalità, una storia di omicidi dell'omicidio di più di 6 milioni di persone che secondo la definizione nazista erano di discendenza ebraica. Una storia di occupazione e guerra, di violenza, di furto e distruzione. La storia del vostro pezzo d'antiquariato potrebbe essere la storia di un trasferimento da un luogo all'altro, un trasporto ad esempio da Parigi a Berlino nell'autunno del 1933, imballato da uno dei 30 donne, 82 uomini, ufficiali e impiegati che avevano questo compito hanno avuto questo compito fino a luglio del 1945 per i territori occupati dai tedeschi. Poi caricato su uno dei 26.984 trasporti merci su 674 treni, con un totale di 1.790.000 metri cubi di merci trasportate. Questa è la fonte di queste cifre. Avrebbero potuto essere distribuiti in Germania, gli oggetti potrebbero raccontarci storia. Ascoltiamo, è probabile che provenga da uno dei 69.000 circa appartamenti che furono lasciati in Francia, Belgio, Paesi Bassi da ebrei arrestati, deportati o emigrati. Fornisco queste cifre perché i numeri rappresentano dei parametri obiettivi e affidabili per definire questo evento storico epocale, la sua ingiustizia, un parametro per misurare la dimensione di un crimine senza misura, ora tangibile e visibile. In modo neutrale, queste cifre e questi numeri documentano realtà del passato che rimangono ancora incomprensibili ed è per questo che sono fondamentali per la nostra comprensione, per il nostro studio e per la nostra discussione su questa ingiustizia storica. Le cifre citate si trovano nel materiale allegato al cosiddetto Mobile Action o operazione mobilio, Furniture Operation, durante il processo ai criminali di guerra. La biblioteca di Stanford li fornisce anche online a chiunque li richieda. Sono cifre che sono scioccanti. Tuttavia, nonostante il loro essere asciutte e oggettive, non chiariscono del tutto le cose. Sono soltanto una piccola parte di quello che in breve oggi viene definito il furto nazista di proprietà privata, che ancora è inquantificabile in cifre. Il numero di appartamenti svuotati, di metri cubi di merci trasferite non ci permette di arrivare alla vera ampiezza, il valore materiale e immateriale degli oggetti che rimangono ancora negli appartamenti di chi che rimasero negli appartamenti di chi emigrò e furono ad esempio rubati e portati in Germania. Ci dicono ancora meno sul destino dei proprietari.
Stigmatization, disenfranchisement, and expropriation that forced the people persecuted by the Nazis for racist, political, or other reasons to liquidate, sell, or leave behind their real estate and possessions. The innumerable objects that today we subsume as Nazi-looted art reflect how, beginning in 1933, the first Aryanizations took place, meaning sales or transfers of companies and private assets that took place under the pressure of the increasing persecution and stigmatization. Perfidious mechanisms such as boycotts, professional bans, or fiscal harassment aimed at successively depriving the Jewish part of the population, in particular of their livelihoods, and inducing them to liquidate their final securities to sell real estate, stock assets, or luxury items, including arts and antiques, for example. The civilian population participated alongside the authorities and in turn benefited from the so-called Judenauktionen, which you can see here, or other measures that made entire companies, real estate, luxury goods, or simply household items affordable. What you can see here is an incomplete selection of German laws and decrees passed between 1933 and 1945, which regulated the systematic deprivation not only of art and cultural property, but also of any assets in general. Contrary to the popular belief, the so-called Reichsfluchtsteuer, Reich Flight Tax, was not an invention by the National Socialist Party, but was massively instrumentalized against Jews, Jewish emigrants, and successively increased year by year, so that the generated income amounted to 342 million Reichsmark in 1938 alone. The Nuremberg laws passed by the regime in 1935, a law for the protection of German blood, and the Reich citizenship law, retroactively legalized the early boycott and extortion measures, whereas the distinction between Aryans, full Jews, and half Jews prepared further deprivation of rights. More and more professions were banned, including also art dealers, as can be seen here in the example of the Munich art dealer Walter Lemmle, who in 1935 was forced to liquidate or Aryanize his business within 4 weeks. Along with 40 other Jewish art dealers, Walter Lemmle had to successively sell or auction his warehouse. Forced sales like these are very difficult to trace. Unlike in this case, where we have a documentation, they are usually hardly documented at all, and relevant private archives are often inaccessible, lost, or destroyed. With the so-called Anschluss, the annexation of Austria in April 1938, the registration of the property of Jews became obligatory, as you can see here, marked in red, appraised by officially appointed Aryan experts and controlled by the tax authorities, who transferred deposits and proceeds to blocked bank accounts to which the persecuted or emigrated people had no longer any access. Culturally valuable objects could only be exported with the permission and against payment fees that were several times the equivalent value. After an assassination attempt on a German legation secretary, another levy was introduced as a collective punishment, which, in conjunction with the payment of other fees and taxes, meant a further reduction of individuals' assets by up to 80%. The amount of cash that could be taken out of the country was limited to 10 Reichsmark. In November 1941, an ordinance to the Reich citizenship law stipulated that crossing the Reich border, even in the context of a deportation, automatically resulted in the loss of citizenship, which meant the forfeiture of all private assets, including the blocked bank accounts, to the state. It was not only the Nazi officials and authorities that contributed to the gradual radicalization and ultimately brutalization of the processes surrounding the art theft. Many collaborating or competing forces and interests encountered each other. Academics, museum directors, curators, archivists, and library staff participated, as well as various players in the art market, but also private collectors. As experts, mediators, and distributors, they played a part in the mass transfer and theft of cultural property. And within this radicalization and brutalization of robbery and plunder, it was exactly these perfidious networks and mechanisms that became increasingly efficient in the occupied Eastern and Western territories. For example, when it came to track down the property of previously emigrated or deported Jews, processes often characterized by violence, torture, and extortion. The Einsatzstab Reichsleiter Rosenberg, responsible for the Möbelaktion that I mentioned earlier, was the largest looting organization in Nazi Germany. As an official party organ, it confiscated art and cultural property, but also books, archival documents, files, maps, teaching materials, research reports, photographs, sound recordings, and films, officially for the purpose of enemy research. Its looting operations started in 1939 as German troops began occupying European territories and continued throughout the war. The photos you can see here, which I have chosen rather randomly, are from Paris, Amsterdam, Tallinn, or Kiev. Alfred Rosenberg was Hitler's commissioner for intellectual and ideological education, and from 1934 on, he planned to establish a university for future Nazi leaders. For this purpose, he started with the early gathering of materials from confiscated holdings of libraries and archives. After the German attack on the Netherlands and Belgium and the invasion of France by German troops, the German ambassador in Paris instructed the Wehrmacht to secure approximately 1,500 artworks and cultural assets from private, predominantly Jewish collections in June 1940. Despite concerns over its legality, Rosenberg demanded that the seized cultural goods should be removed to Germany as soon as possible and founded the IAA, Einsatzstab Reichsleiter Rosenberg, in summer 1940 to send employees to Paris to examine holdings of synagogues, associations, and lodges, as well as confiscated documents of Jews who had fled the country. In early September, he demanded additional authorization to seize objects from collections that remained, in quotation marks, ownerless, or assets of the so-called enemy powers. Rosenberg's mission was then extended to northern France, Belgium, and the Netherlands. The confiscated objects were stored in the Musée du Jeu de Paume in Paris. And in November 1940, Rosenberg wrote a message to Hitler emphasizing that the ERR had already collected cultural assets worth of 500 million Reichsmarks and mentioned further ownerless possessions left behind by immigrants in the ports of La Rochelle, Bordeaux, and Deauville. Ultimately, Hitler extended his so-called Führervorbehalt, a degree guaranteeing him the right of the first access to confiscated cultural property, to the occupied Western and later also occupied Eastern territories. Although the Vichy government protested and denounced the confiscations as a violation of the Hague's land warfare regulations of 1907, Hitler issued an order to transport 25 railway transports full of cultural assets to Bavaria in December 1941. Already in late April 1941, and after the surrender of Yugoslav and Greek forces, Rosenberg had extended the ERR's activities to include the Balkans. In military operation zones in Greece, he confiscated the holdings of synagogues, schools, associations, and other institutions. Liaison offices for the Yugoslav territories were set up in Belgrade, the Italian-occupied part of Croatia, and Zagreb. Another office was established in occupied Denmark. In August 1941, Rosenberg was finally appointed as Reichsminister of the occupied Eastern Territories for continuing the ERR's activities without any restrictions in the Soviet Union as well. He installed a task force in the so-called Ostland, which meant Estonia, Latvia, Lithuania, and Belarus, to confiscate cultural assets in these territories too. In October 1941, he assigned Erich Koch as Reich Kommissar for Ukraine with similar instructions. At the beginning of March 1942, a last extension of the Führer decree confirmed Rosenberg's all-over-encompassing right to confiscate, quote, cultural assets that were owned by Jews that were ownerless or whose origin could not be conclusively determined, end of quote. Growing ruthlessness characterized the actions in the occupied Eastern Territories, where the ERR was permitted to work under military administration. Competitions and struggles with the SS, the Sonderkommando Künsberg and the Sonderkommando Jahnkun in charge of archaeological excavations led to increasingly uncontrolled and brutal operations. Jewish staff of libraries, archives, and museums were forced to help compile inventories and load objects for the transport before many of them were subsequently murdered in mass shootings. Archival materials, books, and cultural assets were gathered as truck or train cargo. Today, the contents and whereabouts of many of these transports cannot be precised, traced, or quantified, despite Soviet efforts to document the damage, as many objects that were not intended for the transport to Germany were often destroyed on the spot. After Germany's defeat at Stalingrad and its withdrawal from Ukraine in 1943, a growing power of transport of cultural goods went to Poland and Czechoslovakia or remained in the evacuated territories. Sober statistical reports were written with completely disregard of the events of the war. The figures in these reports cannot even be considered as approximations, as they merely reflect what was inventoried, not what was looted, sold, or destroyed. As a result, there's still no central documentation of all that was stolen. Against this backdrop, it once again becomes clear why any attempt to quantify the Nazi looting of cultural property, which is inextricably linked to the Nazis' racial ideology, to the Holocaust and the murder of European Jews, to the eradication of Jewish culture and identity, and to a brutal war of extermination, must fail. As a consequence of the Washington Principles in 1998, the research of so-called Nazi-confiscated assets has been anchored in the first place in museums in Germany and Austria. A long overdue and important step, no question. But by evaluating the achievements of the last 20 years of provenance research, we have to seriously question whether this will be a sustainable research concept for the future, especially since it hardly allows for international cooperation and networks so far, and thus does not fully explore its potentials. Provenance research is also directly linked to the question of cultural heritage. And in the light of the recent and terrible news from the Ukraine, this question cannot further be limited to national borders and cannot be developed isolated from each other. A reason why I'm very pleased to be invited to speak at this important conference today and to taking up the questions, why are we still looking for Nazi-looted art? Because we have this unique opportunity today to do so, because we have to do it for tomorrow, for future generations. Not only in Germany, not only in Italy, but all over Europe and even worldwide. Thank you very much.
Thank you very much, Mike Hopp. I think that was very interesting. I'm now introducing Daria Brasca. She will walk us through the Italian history, and she is a research fellow at the University of Udine. Welcome, Daria.
Wow. Hello, good morning. On 18 September 1938, in a crowded Piazza d'Italia square in Trieste, Italian Prime Minister Benito Mussolini announced the anti-Semitic provision aimed to exclude the Italian foreign Jews to Italian society. From that event, the fascist regime issues numerous laws that restrict the rights of Italian foreign Jews on Italian ground. Already in August 1938, the so-called racial census began to be carried on. The census recorded approximately 58,412 Jews, Italian and foreign, living in the country, and around 47,000 of them ascribed to a Jewish community. This census was the first act aimed to obtain useful information for the anti-Semitic campaign ongoing. Information such as the family ties, the job occupation, and the place of residence. The census list, here you can see one of the Prefecture of Udine. The census list were important tools to set up the confiscation processes of the Jewish property in the following years. The 1938-1939 corpus of anti-Semitic measures is well represented by this cartoon published on the anti-Semitic magazine La Difesa della Razza. The Jews in Italy could not provide military service, I'm starting from the left to the right, could not be tutor, own a factory considered strategic for the nation, be landlord, had not Jewish servants. They could not enroll the PNF, the National Fascist Party, worked for public offices, corporations, insurances, and banks. All the foreign Jews were expulsed from the Italian territory. The Italian nationality given after 1919 were revoked, and very important, the Jewish student and professor were banned from school of any grades. Between 1938 and 1943, Italian fascist regimes approved numerous laws and roughly 180 relatives, decrees, and circulars that serve to restrict the family, the livelihood, and property of Italian Jews. Regarding the Jewish property, on 9 February 1939, the fascist regime set up the Office for the Management and Liquidation of Real Estate, Ente di Gestione e Liquidazione Immobiliare, better known as EGELI. Within the Ministry of Finance, we was in charge of acquiring, managing, and then selling the Jewish property during the war. In its task, EGELI was allowed to delegate the management and the sale of the confiscated asset to a number of national credit institutions. Here you have a list, the credit institutions involved were 19 in all the country, with a view of a maximization of its result. In the slide, you can see some of these credit institutions, just the most important, let's say, appointed, and the corresponding region where they were operated as a EGELI delegated. The Istituto di Credito Fondiario delle Venezie, a bank that is not more existing, was appointed as EGELI's delegated for Venice, the Veneto provinces, plus Udine, Pordenone, Trieste, Pula, and Rijeka. If you want to take a look about the EGELI documentation, you can find in the website of the Intesa Banca San Paolo of Milan some example of that documentation. The archive is open to the public. They opened in 2020. Instead, the documentation referred to Piemonte and Liguria is available to the researcher and is conserved in Torino, so in the San Paolo Bank in Torino, that today is together with Banca Intesa San Paolo. If in a first phase, EGELI managed the confiscation property, such as lands, real estate, and factory, if their value exceeded a certain threshold amount, following the Royal Legislative Decree 1728 issued in 1938. Then EGELI was in charge of managing immovable assets confiscated by the local branches of the Ministry of Finance and Interior, such as the Tax Revenue Office, the Prefecture, and the State Treasury Technical Department. Ufficio Tecnico Erariale is in Italian. Between 1939 and September 1943, the confiscation measures were only slowly implemented. Regarding the Jewish owner cultural property, from 1938 and 1943, many circulars were issued by the Ministry of National Education, General Direction of Fine Arts, about the export of Jewish owner artworks from the country. The Ministry of National Education argued the export offices within the superintendencies, the local branches of the Ministry of National Education, to verify the export declaration, to discourage the export of antiquity, increasing the evaluation of the artwork, and, as consequence, the export tax related. To verify the economical value declared for the exported contemporary artwork. This happened because the export offices of the north of Italy, especially the export offices of Milan, Turin, and Venice, recorded a high number of export declarations of contemporary painting between 1939 and 1942. That the contemporary painting and contemporary artworks were not included in the protection law of the National Cultural Heritage Law 1089, issued in 1939, better known as the Bottai Law. So it was, if you want to export at that time a contemporary painting, you just have to declare it to the export office. At the same time, the Minister of Finance argued the custom to deeply check the Jewish legacies and crates, looking for valuable assets not previously declared, such as cash, jewelry, and artistic objects. Throughout the war, Italy's fascist regimes enforced the anti-Semitic legislation. After Italy signed the Armistice Agreement on 8 September 1943, Italian Social Republic, RSI, was quickly established. Between 1943 and 1945, all Jewish assets in the Italian Social Republic were confiscated, and many Jews were arrested and deported to concentration camps. In this year, specific provisions were issued for the confiscation of culture or artistic significance from Jews and Jewish community. For our discourse, it is important to take into consideration one circular issued by the Ministry of National Education and one legislative decree. The 1st September 1943, the Ministry of National Education signed the Circular 665 to the superintendencies on the confiscation of the Jewish owned artworks, or the artworks owned by the Jewish community, so the well-known Judaica, in which the owner were obliged to report the artworks owner to the local superintendency, to the head of the provinces, so means to the prefecture, and to the municipalities. In this way, local offices of different ministries, Ministry of Interior, Finance, and National Education, had information of valuable Jewish assets, facilitated illegal removals and misappropriation. The circular clearly states its intention to gain a precise knowledge of the nature of the work of art, to description and indication of the place where they were kept, which naturally helped in including the works of art in the confiscation orders. The circular specified that seizure regards all types of art. In fact, the Italian term opere d'arte was used in a generic way, artworks, and included protected artworks, books, and antiquities by the Bottai Law, figurative arts, such as painting, sculpture, prints, drawings, applied art, and all the artistic objects that could not be considered daily life objects. In this way, the Minister of National Education could try to apply his authority over that of the other ministries in the managing of any object having an artistic appearance. Let's go through an example to better understand it. What you can see in the slides is an amazing 18th century Villa Lattes in Istriana, a small town in the province of Treviso. The villa was bought in 1842 by Abramo Lattes, a Venetian pioneer in the silk industry in Veneto, who settled his activity in Treviso. His great-grandson, the well-known lawyer of Treviso, Bruno Lattes, is the man seated that is playing a viola. Enlarge the villa and enrich it with an eclectic collection of curiosités, including Oriental objects, French porcelain, furniture, music instruments, prints and paintings, and one of the larger collections of automata and carillon existing in Europe. Today, Villa Lattes is open to the public because it was donated in 1853 by Bruno Lattes to the municipality of Treviso, and the collection is partially displayed in the villa, in the City Hall, Theatre, and Museum of Treviso. In 1938, Bruno Lattes fled Italy to Swiss, where he remains since the end of the war. But before to leave the country, he appointed his lawyer as trustees of all this property and affair. In late December 1943, the Venice Superintendency firmly requested a list of the artistic objects displayed in Villa Lattes to the Prefecture of Treviso. The superintendent specified in its request many times that the list has to contain all the objects with an artistic appearance. The list, filled out by the local civil officer, comprised around 200 objects. These objects not included the most valuable objects that were already hidden in Lattes' farmer's house. At the end, the superintendent appointed the Lattes lawyer as trustee of the artistic collection. On 4 January 1944, the legislative decree number 2 ordered the confiscation of all the Jewish property, inclusive of that which was previously exempted, and the movable asset, such as bank and box accounts, and any type of objects, including artistic objects, books, and music instruments. In fact, nothing in the legislative decree indicates that the cultural heritage, declared or not, should be banned different than other goods. In fact, once the heads of the provinces say the properties, an inventory was drafted by the municipality offices under the police surveillance, and then the items listed were managed by a jailer. The superintendency, only through the Circular 65, managed a dialogue locally with the jailer, the head of provinces, and the prefecture to prevent the dispersion of the Jewish cultural heritage and their selling. Surely, the Circular 665 was not the property juridical tool, as could be a law, to impose a different management, and its discretionality application was occasionally applied. But in the case in which the superintendency succeeded in establishing itself, the Jewish cultural heritage was preserved. This is the case of the Salom collection displayed in Casa Salom on the Canal Grande in Venice. The collection, assembled in the 19th century by the famous Venetian art collector Giuseppe Salon, was composed of 4 landscape and battles by Salvatore Rosa and 14 Pietro Longhin's paintings, or attributed to him today, depicting Venetian scene, among which is the famous music lesson and the elephant, for example. Although the Longhin and Rosa paintings were protected by the Bataille law, many were the valuable artworks composed in the Salom collection. All the Longhin collection of the 14 Longhin paintings were sold in 1981 by the Salom heir to the Banca Intesa San Paolo, and today are displayed in Leoni Montanari Palace in Venezia. After the war, the painting returned in late 1945, and after the war, these paintings were then displayed in Villa Mansi in Lucca, because the Mansi family and the Salom family were related. In November 1943, the Countess Adele Salom informed the Venice superintendents that she's transferred her art collection from her Venetian palace to their villas in the Padua countryside to avoid possible war damages. Few art objects were protected in Villa Salom in Conselve, while the main part of the collection was hidden in Villa Roberti in Brugine. The 16th century villa, decored by Paolo Veronese, was bought by Giuseppe Salom in 1861. In early December, the superintendents the Venice superintendent asked to the Padua prefecture to verify where exactly the Salom collection was located and which measures were taken to protect it. Despite the fact that the superintendents wrote several times to the Padua prefecture, only in May 1944, it answered that the Salom collection was already being confiscated in January 1944, together with all the other Salom properties. From May to October 1944, the correspondences between the Venice superintendents, Padua prefecture, revenue office, Esegeli was prolific. Superintendent Moschini was determined to have the custody of the Salom collection, ensuring a safe place for the Longhi and Rosa paintings. At the end, Moschini succeeded to impose his authority and transfer the Salom collection to the Galleria dell'Accademia. We have to say that, in general, the confiscation process was characterized by a not uniform application in the country. The overlapping of competencies regarding the management of cultural Jewish property could not be avoided. The presence of so many players, they had to reach an agreement and a coordination of both the national, the Minister of Finance, National Education, Interior, and Egeli, and at the local level, the superintendency, the various delegated credit institutions of the Egeli, the head of the provinces, and the revenue offices, caused the management of the cultural property confiscated from the Jews in various parts of Italy to be extremely heterogeneous. When there was not the superintendent's involvement, the management of the artworks on the part of the local authority, mainly the head of provinces and the prefecture, was characterized mostly by not recorded processes of appropriation. In addition to that, many profiteers, second-hand art dealers, sellers, and common people were involved in this illegal and valuable trade of the Jewish cultural property. This is particularly true for the city of Florence and Trieste, where several Jewish collections were completely spoliated. Just a case overall, the extensive and uninterrupted seizure carried out against the Baron Levi art and library collection, and I want to add also coin collection, displayed in his Florentine palace and in his castle villa in Reggello, exemplify the fascist spoliation perpetrated against a wealthy Jewish banking family related to the Viennese Rothschild and to the Venetian Levi. The Baron Levi collection, a perfect example of the international test of the Italian Jewish bourgeoisie, was partially confiscated by the Florentine prefecture in early January 1944, and partially was looted, and then auctioned in Florence and sold maybe in Milan by prefecture officers involved in these profitable illegal art trades. Let's say that in Florence, more than in other Italian cities, the power of single individuals prevailed over legality. Today, of this outstanding collection, and of many others, remain only the description in the historical city chronicles. The process of restitution of the Jewish artworks in Italy is far to be considered concluded. Thank you.
Thank you, Daria. So I think we have time for questions. Maybe this part of the Italian history might be lesser known to some of us. So if you have anything to ask, Daria is here for a couple of minutes.
Yeah. Yes, hello, my name is Imke Gier, I'm a lawyer from Berlin. Could you just, because I'm not so familiar with the Italian history and what happened in the 1937 and 38, could you just explain a little bit more in detail how the foreign Jews were made to leave Italy, or what happened there, and what you said, 37 or 38? Can you say a little bit more about that?
Do you want to have to know more about foreign Jews?
Yeah.
Okay. Okay. About this, what's happened to the church? Some of them expatriated, were obliged to leave the country. Many of them remain in the country, either somewhere or was able absolutely to remain. The problem it was about the property, because also that property was managed. The big problem is when we talk about foreign Jewish is if they had no nationality, and it's depending of which was really their nationality, that property were confiscated not following the Jewish the anti-racial provision, but following the war law, the martial law. That is another corpus of provision that were issued by the fascism regime. So it means that different laws that were applied in the management of this property means also then different restitution process in the after war. Always Ejeli was the one in charge to manage that asset, that it was pretty huge. Because if we take in consideration about the property of Jewish, foreign Jews, I think about Villa Finelli in Florence when the owner was a French citizen, Jewish French citizen. All the collection was confiscated, but following the martial law. And in that case, it's like in other cases, if, for example, in Florence and its provinces, the process of control was not so strong, let's say. So what is interesting to notice that I think that the export offices registered so many exportation of artworks between 1939 and 1942, especially of modern paintings and applied art also. And this is interesting because shows us how many artworks were then exported from the country, and all this art was part of foreign Jewish collection, let's say. Small collection maybe, but they were part of foreign Jewish collection.
Okay. So thank you again, Daria. And I'm now pleased to welcome Bianca Gaudenzi. She is currently a research fellow at the German Historical Institute in Rome. And now that we have concluded the historic overviews of the Nazi and fascist era, she will now tackle the post-war years up to the Washington Principles. Thank you, Gaudenzi.
Oh, I can take this off. Nice. Yeah, good morning, everyone. First of all, I'd like to really thank the organizers and the Ateneo Veneto for really managing the impossible. Well done, Katharina and Pierre, and also Katharina von Sprenger, who's been emailing all of us throughout these months. Really big thank you. And for the kind introduction, of course. Okay, so after Maike and Daria's great presentations, what I'm going to do in these 20 minutes is basically take you on a quick ride through Italian history from the end of the Second World War to the 1998 Washington Principles, which, as Pierre reminded us, were signed by Italy together with other 43 countries, in order to illustrate how and why Italy still struggles to a certain extent, not only to make amends, but sometimes even to recognize the involvement of large sectors of the public administration and Italian society at large in the persecution and expropriation of their fellow Jewish citizens. Now, the massive difficulties faced by Holocaust survivors and their relatives in the attempt to claim back their homes and belongings emerged already in the immediate aftermath of the Second World War, as summarized by the magazine Die Allgemeine Jüdische Illustrierte in June 1951 in one of its bitterly accurate cartoons. And I hope you can see it here. I put the English translations on the side as well. Now, despite being based on the German example, I chose this cartoon because I actually find it very well suited to describe the Italian case as well. In that, yeah, I'm a bit shorter than the others, sorry. In that it gives a very good sense of the incredibly frustrating and kind of Kafkian bureaucratic maze that any survivor, as it says here, had to suffer through, sometimes even with no apparent successful outcome or ending whatsoever. You can see at the middle, they just get lost in a sea of paragraphs, basically. It's interesting also that in Italian, the board game has the same name as in German. It's this non t'arrabbiare, it's very popular even nowadays. Well, at least it was when I was a kid. Okay, so in the Italian case, for instance, claimants were requested to pay storage taxes or even rent arrears and back taxes on the properties that had been confiscated to them by the fascist states. Many also found themselves having to deal with the same functionaries who had been in charge of plundering their homes only a couple of years earlier, and who were often very far from willing to remedy the discriminations that they had inflicted upon them with such alacrity. Now, the result of this was a prolonged and extremely strenuous quest for restitution, which, despite the actual significant volume of property returned in the 40s and 50s, engendered an acute sense of frustration, discrimination, and even second expropriation, as Sophie Lilly has said, for many years to come. Now, before we delve in a bit more into the question of the partial restitution of Jewish property, I'd like to draw your attention to one of the particularities of the Italian case, and also the French to a certain extent, which has been nurturing the rhetoric of cultural restitution for decades in this country, and still partly hinders the process of coming to terms with the past, namely the issue of state collections, which were given total priority to in the immediate aftermath of the Second World War. And here I've just given you a few examples. Now, between 1945 and 1950, many public events and press campaigns were organized to celebrate the return of several unique state collections, such as the Uffizi, for example, which had been removed or looted during the Nazi occupation. And here, the top left, for example, you can see what's been dubbed as the return of beauty, the return of the Florentine galleries in all pomp and circumstance, returned in July 1945 by the US Army. I've also included some examples from the two different exhibitions, national exhibitions that were organized in 1947 and 1950. And here in the middle, you see the controversial Rodolfo Siviero, the head of the Retrieval Office, very theatrically posing in front of Tiziano's Danae, which had been looted by the Göring division in 1943. Now, these events, and the exhibitions in particular, were conceived with the barely concealed aim of putting on display the pillaged national heritage of Italy as a means of not only manufacturing a certain sense of national cohesion after the divisions of fascism and civil war, but especially to reinforce the victim myth. Now, the view of the good Italians, so-called, as mere victims of Nazism, in order to whitewash any responsibility or even mention of fascist crimes, which included first and foremost Italy's role in the persecution of its Jewish citizens and also its ruthless colonial practices. Now, such collective amnesia was to strengthen itself, actually, over the following decades through a process that Ilaria Pavan has described as reinforcing the new public's legitimacy through forgetting. Okay, so at this point, I'd like to point out that none of these official publications contained any reference to Jewish collections, more specifically, and nor to fascist active participation in their plundering, not one. In fact, the restitution of Jewish assets generally took place in a sort of silent vacuum, I would say, and was often implemented, as I said, with great difficulty. One of the main obstacles was the Egeli, that Daria has already told us about, which had been in charge of confiscating all the material, and now, unfortunately, was entrusted with its restitution. So, as Daria very well illustrated, the EGELI had proved extremely effective in carrying out extensive confiscations. We count over 8,000 confiscation decrees only in the territory of the Italian Social Republic, so Salò Republic, with measures that had been designed to humiliate, so not only expropriate, Jewish citizens. Even, for example, seized bank accounts with only 1 lira 20 to indigent elder ladies or completely valueless objects that were then sent to be destroyed. As testified by the reams and reams of lists that were published in the Gazzetta Nazionale, as Daria has already shown. Now, you can see 2 examples also here on the left. And this, the lists contained such poor items sometimes that even the fascist education ministry at some point took issue with it and said, please don't publish these lists anymore because they actually contradict our anti-Semitic propaganda so blatantly, then please stop this. So you can imagine. Okay, so according to the Anselmi Commission, which was set up in 1998 to investigate the spoliation of Jewish citizens, I'll tell you a bit more about that later, a substantial part, but not all, real estate and businesses confiscated were returned. Usually the ones that were returned were the ones that the EGELI hadn't had time to sell. And even in that case, they usually were emptied of any goods, furniture, or even personal belongings, or heavily damaged by bombing. And here you can see some examples of the more straightforward files, restitution files on the right. Like in some cases that Daria mentioned, the properties that were seized were then given back relatively straightforwardly at the end of the war. According to an official balance summary dated 9 June 1945 of the EGELI, which you see here published again by Shalom magazine 1997, the grand total of movable and unmovable assets appropriated by the EGELI summed up to around 726 million liras at the time, which in 1997 corresponded to around 309 billion liras. So you can imagine now with euros. Now of these, home and businesses came up to around 46 million liras, while the remaining 680 millions in gold, cash, jewelry, furniture, and goods were, as I said, only very partly returned. And here, again, in this case, the ones that had managed to escape forced sales, improvised looting raids, mandated destruction, war damage, or, and this is important, which wouldn't sit in a ministerial storage room for decades, as we will see. Now, even in the rare instances in which the question of Jewish property did become a public issue and was covered in the press, its treatment was rather exemplary of the peculiar course taken by post-war Italy in elaborating, or rather not, its anti-Jewish persecutions, and that is by minimizing or transferring all blame onto their former Axis allies. This was the case of Leo G., who lived in Milan and was forced to flee to Switzerland, as many were, for racial reasons, according to the press, who, upon his return to Milan, discovered that his collection of antique books and pre-Columbian statuettes had disappeared. And I put an example here of the copy of the back Bible that he had at home, and that disappeared. Now, according to his own inquiries, some of the books had quickly resurfaced in the catalog of an antique bookshop just a few steps down from his own home. Now, it's a really complicated and long story, so I'm going to summarize this. The investigation that ensued eventually led the police, first to the antiquary, of course, then to the magazine stand and so on and so forth, finally to Leo's porter, which who, after being interrogated many, many times, finally claimed to have received a parcel with the books by a certain Luigi, who had raided the flat, apparently, and was identified by him only as a member of the SS. Because obviously Luigi is a typical name, right, for a Waffen-SS. So, not much is known of how the story ended, unfortunately. One of the manuscripts had already been sold to an identified British collector and was never retrieved. Meanwhile, and we come to the right side of the slide instead, the entire contents of his home in Varese, including 2 antique Chinese bronze vases and a box of antique books, had instead been seized by the Ughelli in December 1944 and made it to the storage rooms of the bank Cariplo. So even in this relatively straightforward case, it took Leo more than 18 months to get his property back, as testified by the over 140 pages included in his dossier at the Intesa San Paolo archive that Daria was telling us about. During these months, Ughelli functionaries exasperated Leo with their absurd requests for taxes and paperwork, to the point that in October 1945, he wrote the following telegram, and I'm quoting here: "I do not recognize any of the authorities mentioned in your letters. I only recognize the specific event of a plunder and theft executed by bandits at my expenses." Now, if Leo's experience well exemplifies the vexations endured by many rightful owners at the hands of the Ughelli and other state agencies, the looting of his Milan home is equally important, as it testifies to the local, even personal, right, and often improvised character of many of the plundering actions carried out during Solo. More importantly, it shows how plundering was often presented as a German enterprise, even when it blatantly was not. Okay, so individuals were unfortunately not the only ones to struggle. Even in the case of communal property, which had been retrieved already, bureaucratic difficulties and even outright indifference, not to say worst, sometimes prevented their restitution to the communities, as in the case of the silverware of Milan's synagogue, which had been looted by the Nazis in November 1943. Now, the 4 pieces of silverware that you see here had become subject of contention already in 1946, actually, when they landed in the deposits of the Arar, that is the post-war company for the buyout and alienation of residual war material. Very similar fate was, a very similar case was actually the one of Alessandro Basevi's silverware, which also landed in the Arar deposits, and which, despite the owner's repeated claims, were eventually even auctioned away, and he had to buy some of them back. Okay, so thanks to the protests of the Union of Jewish Communities, in this case, it went differently, thankfully, but not entirely. So the union underlined not only, and I'm quoting here, the undignified fact that these objects were deemed war booty, but also their grave profanation as sacred objects of the Jewish faith. And so finally, in 1948, the silverware were sent to the retrieval office at the Education Ministry, where they would remain for almost 4 decades, however. It was only in 1984, in fact, that the ceremonial objects resurfaced an exhibit in honor of the recently deceased Siviero. Despite the many protests and the fact that the catalogue clearly named Milan's Jewish community as the original owner of the pieces, and you see here in the middle one of the examples from the catalogue, the ministerial committee entrusted with their allocation chose to hand the silverware over to Milan's Sovrintendenza, so the local heritage board, prompting the Jewish community to lodge an appeal, obviously. The ministry impudently tried to defend its stance by referring back to the 1950 law on artworks sold or given voluntarily by fascist art dealers or bigwigs to their Nazi allies, which obviously wasn't the case. But in an unprecedented move, the TAR, that is the Administrative Court of Latium, thankfully upheld the appeal, underlying how these objects had evidently been forcibly removed and fell consequently within the scope of the 1948 law on the return of assets removed by the Germans, thereby sanctioning the restitution in June 1991. And so the silverware finally returned to Milan with relatively little pomp and circumstance and not a word in the national press. This notwithstanding, the victory of the Milanese community marked the beginning of a phase of partial awakening, more or less, after decades of oblivion, that thanks to the relentless engagement of the local Jewish communities and the Union, together with international Jewish agencies such as the World Jewish Congress, a significant generational change, as well as a series of events such as the insurance and bank account scandals of the mid-90s, for example, would eventually lead to new legislation in 1997 and the establishment of the Anselmi Commission. While this phase was to be remarkably brief, it led to the first significant changes since early Republican legislation, as I've tried to summarize here. Now, we all consciously refrained from giving you really long, detailed lists of all the laws, but I thought this will give you at least a sense of how the whole story evolved, basically, also from a legal point of view. Now, besides the 1948 and 1950 laws that I already mentioned, the restitution of Jewish property had up to this point been mostly regulated by a series of decrees that had been passed both during and immediately after the end of World War II. Now, unlike occupied Germany, where Allied legislation sanctioned the restitution of all looted property, included that in the hands of third-party acquirers, which you might remember from the cartoon at the beginning, protested quite a bit about this. Between 1944 and 1947, Italy reinstated civil and property rights, which had been stripped by the racial laws in 1938, to go back to the question before, and also sanctioned the immediate restitution of Jewish property, but, and this is crucial, considered third-party acquisitions in good faith, unless explicitly stolen for personal gain. And this is the law of 1946. Now, the urge to pacify the country and Cold War considerations surely weighted massively on this decision, but they were only part of the equation. To add insult to injury, in 1960, the Legal Council of State sanctioned that all property that had remained unclaimed or that had not been claimed by the Union according to the 1947 law would become property of the state. It was only at the end of the Cold War that this collective amnesia, or rather this voluntary suppression of fascist expropriations and their only very partial restitution, finally started showing the first cracks in its facade. Even though we'll talk about it more today, it's actually still very popular nowadays. Now, prompted by another contentious case, that of 5 crates, the so-called bisacce, of personal objects looted in Trieste and eventually deposited in the Central Treasury, in the summer of 1997, Italy passed law number 233, unanimously and in record time, which in Italy is a very, very rare feat indeed. And this law sanctioned the restitution of all objects still in custody of the Italian state. So it represented a really important step. I've also included one of the passages, the second article here. Okay. While this law is still rather flawed, for instance, it requires objects to be of clear Jewish provenance, as you can see here from the text, so it makes it quite tricky sometimes. It nowadays constitutes the legal backbone of restitution legislation here in Italy, together, of course, with the Washington Principles of 1998, which, as many of you know, are non-binding, however. So the 1997 law is really important. To remedy these flaws, the following year, the presidency of the Council of Ministers, so the Prime Minister, established the Restitution Commission I've been telling you about, which was entrusted with the task of inquiring into the acquisition of Jewish property and its subsequent restitution. And here I've also, I'm sorry, I didn't know the screen would be so far away. I'd also include a list of the Washington Principles in case some of you are not entirely familiar with them. Okay, so I'm not going to go into detail on the work of the Restitution Commission because it was huge, but I'd like to draw your attention to two main points. As you can see from these press clippings, the Commission results were often reduced to the issue, still relevant, but anyway, of the 8,000 confiscation decrees, with very few articles focusing on the question of failed or partial restitution, even though the Commission gathered a staggering amount of documentation on the matter. You can only see an article by Michele Sarfatti, the historian who is also a member of the Restitution Commission, here on the bottom right. As its chair, Tina Anselmi, remarked shortly after the failure on the part of Berlusconi's new government to even publicize the final report of the Commission, which is usually mandatory, actually, Italy lacked the political will as well as the stability, to follow through on the Commission's recommendations. First and foremost, the establishment of a restitution body similar to the ones which are now active in many European countries, including France, Italy, Germany, Netherlands, UK, and I could go on and on and on. We still don't have that in Italy. That said, I'd also like to wrap this, to leave you with a hopeful note. In the summer of 2020, the Ministry of Culture established a working group for the restitution of Jewish-owned cultural property, which brings together experts from the Union, Jewish communities, the Heritage Protection Police, and some of Italy's main archives and libraries. I've also recently been asked to be a member. We are currently still waiting for any sort of funding, actually. But your tips and recommendations are most welcome, so please spread the word and let people know that this is there now. Okay, so to wrap it all up, I'd like to draw your attention to 4 main points. Especially between the aftermath of the war and the late 60s, the rhetoric of cultural restitution represented an extremely useful means of staging a clean cut with the fascist past, while at the same time placing all blame onto Nazi Germany, to exculpate the state apparatus and the Italians who had actively taken part in the expropriation and persecution of their fellow Jewish citizens and neighbors. For decades, the rights of legitimate owners or their heirs were thereby not only forgotten, but sometimes even once again violated. Even when restitution to Jewish citizens or communities did take place, in fact, the process sometimes turned into yet another instance of discrimination or loss, human more than material, or in the best case scenario, provide an alibi that reduced the process of restitution to a simple financial transaction devoid of social and political meaning. It was only after the end of the Cold War that countries like Italy, but also Austria, France, would take the first steps towards a more comprehensive processing of their own involvement in the persecution of Jewish citizens. But we still have a long way to go. Thank you.
Thank you, Bianca. We still have 10 minutes, actually, for questions. So go ahead.
Hello, my name is Olaf Osman. I just have a question to the EGELI authority, or 2 questions actually. One is, are these files accessible? Are they public? Are they digitalized? And the second one is, I heard from a couple of cases where this authority granted a small compensation after the war, as they denied the existence of the item and just paid a small sum. And as far as I understood, several of these families still think that this payment is blocking claims for restitution today. Can you say something about this?
Yeah, thank you. Two really good questions. Yes. Okay, so for the Egeli, some of the material is quite widespread, let's put it like this. One of the main sources for us researchers is the archive that Daria was talking about, so this Intesa San Paolo in Milan, which has been doing a fantastic job of putting a lot of material even online, or they send it to you by email, and they've really done a great job. And there was one of the banks which was entrusted with the confiscation and keeping of property by the Egeli, so it's one of the best sources. I also worked, and I find very helpful, the holdings of the Anselmi Commission, which are in Rome at the Central Archives, and they have copied, they have had a lot of material by Egeli, or kind of the Jewish issue office materials sent to them during their work, and they are now all kept. It's about 125 big files that they are kept in Rome and are accessible. They haven't been digitized yet, and that would take a long time. But a project led by Christian Vormeister and Donata Levi, also with Daria, they have kind of cataloged the entire material, and they've done a great job with that. So there are different ways. It's not centralized. It really helps to know which city you like or which case you like to look at, and then work your way through it, basically, because that's one of the peculiarities of the Italian case, is that it's very scattered to a certain extent, right? It's not as centralized as some other cities, countries. And I forgot your second question, sorry. Yes. That is true, actually. In some cases, I mean, I've been working through the archive of the UCE, of the Union of Jewish Communities, and I found a lot of correspondence with different families where, in some cases, they were given kind of small financial compensation, and that's usually then nowadays used to say, well, actually, you were already compensated for the looting and confiscation of your property. So, yeah. But I mean, obviously, that's not grounds anymore, especially with the 1997 laws. So they have the way, there is a way, actually, there's an opportunity now to be able to go back to those claims in case.
Yes, I have a question. You mentioned that today, or in 2020, a commission was founded. But I have a question. There must be some other commission, some restitution commission that already exists, because we pursued a claim for a family for a sculpture that was in storage with the Uffizien. And then the matter was passed on to a restitution committee, and we were successful, but we never really understood what is the restitution committee. Is that a commission that normally, or committee that normally pursues Italian claims abroad? Or,
yes.
I mean, they decided on this claim, and we were very happy, but we never understood what this commission was.
Yeah, that's a great point. That is actually why I referred back to the case, like to the rhetoric has been there for so long. That's the case. So the restitution, there is a big restitution commission in place and active in Italy, but it usually focuses on antiques or artworks that were looted or removed from Italy then, and they claimed them back. But obviously it should go both ways. So in case there, or like with Brera, like different cases, then that's the restitution commission that decides on them. The working group is a kind of subcommittee of that. So it's a consultative body. That means it cannot actually decide on restitution on the spot, but it usually then tells the restitution commission what they should return or not. So that's how it works, more or less. I hope that was helpful, but. Okay.
Sorry, Bianca, may I have one thing about compensation?
Please.
Sorry, Bianca, I just want to add one thing about compensation in the post-war. After the war, many were the requests to award damages that were submitted to the superintendents by Jewish family. And all of them were accepted by the superintendent. And then the superintendent evaluation was then transmitted to the Revenue Office, and then at the end to the Minister of Finance, that it was the last decision. But it's pretty interesting to notice that the superintendent accepts every type of request for compensation, also if it was a lot of painting attributed to the Italian master, old master, also if they were not Italian.master. So they accept every type of request. And in many cases, especially in Florence, they increase the money request. So this is something that has to be taken in consideration.
Yeah.
Thank you again, Bianca Gaudenzi. Okay, I think we are ready now for a quick coffee break. We are actually really good in time, so I suggest that we meet again here at 11. It says 11:05 in the program, but we have a good 20 minutes for a coffee break. And for the online audience, the live stream will resume at 11. Thank you.
È acceso? Sì. Welcome back. It's a great pleasure to introduce our first panel of the day. The topic of this panel is negotiated solutions or litigation, how restitution has been dealt with since 1998. And our moderator is Avvocato Eleonora Chielli, who lives and practices law in Venice. I will hand over to Eleonora, who will introduce her panelists. Thank you.
Buongiorno a tutti. Now I will turn into English out of respect for the panelists and the audience. First of all, I would like to thank you very much, the organizers, Pierre Valentin and Katharina Hüls-Valenti, for involving me in this exceptional event, and both as a lawyer and as a Venetian, I appreciate this amazing job. By the way, hosted in the oldest cultural institute in Venice. Today, we will have a great opportunity to hear how the Washington principles evolved and has been applied in different countries. Because as we have seen, they were a common response and need to restitute awful crimes, but as they're not binding, the application of the Washington principles has been heterogeneous and various. So we will see four of the leading countries in this field, the ones who were first involved in the appliance. And we will see also two different perspectives. We have two eminent scholars, art and history scholars, and two legal experts, a judge and a lawyer. So I will start to introduce them very briefly, but you can find their bios attached in the program. They are Tony Baumgarten, Judge and Deputy Chairman of UK Spoliation Advisory Panel. Then we will have Professor Christian Fuhrmeister from the Central Institute for Kunstgeschichte München. Sorry for my clumsy German. Thank you. And also Professor of Art History at the Ludwig-Maximilian-Universität in Munich. Then Mrs. Sabine Leutfeller, who is an expert in the Department of Restitution at the Jewish community in Vienna. And then Mr. Nicholas O'Donnell, who is a top leading lawyer in the Sullivan LLP firm based in US. So I will start giving the word to Tony Baumgarten, please.
Thank you, Eleonora. I've been asked to say a few words about the British experience in negotiated solutions or litigation. You heard a little bit about the United Kingdom panel, the Spoliation Advisory Panel, mentioned by Bianca in her talk, and I shall talk a little bit about the panel and its experiences very shortly. But there are a number of ways in which to resolve disputes under English law. Litigation through the courts remains the predominant mechanism for resolution of disputes. Mediation is also actively encouraged, and arbitration perhaps is less of a feature because it requires parties to agree to submit to it. There are other methods like early neutral evaluation, but litigation, mediation, and arbitration are the main three. There have been few publicly reported disputes about Nazi-looted art in Britain because very little looted cultural property found its way to the United Kingdom, certainly in public collections in the aftermath of the Nazis' rise to power and following the war. Even so, there remains two main hurdles to litigation for claimants. The primary hurdle for claims involving art and cultural property, whether within a British institution or in private hands, remains the time bars imposed by the Limitation Act in 1980 and its predecessor, the 1939 Limitation Act. Allied to that is the application by English law of the lex situs rule, which says that the law governing the transfer of title to property is dependent upon and varies with the location of property for the purposes of conflicts of law. Now, quite often, the transfer of title took place in England, so the Limitation Acts will apply. But when an object has passed through a number of different jurisdictions, English courts have to determine the limitation period on the basis of the lex causae, the law applicable to the dispute, or the lex fori, which is the law of the court hearing the dispute. Now, the position is governed now by the Foreign Limitation Periods Act, an act passed back in 1984. Discussion of that is probably well beyond this brief introduction, so I'll confine what I say to the position under the English Limitation Acts. Now, under those acts, at law, legal title is often impregnable, since any claim is time-barred under sections 2 and 3. Those sections require any action to be brought within 6 years of the original conversion. And then Section 3 extinguishes an owner's right to sue, even against a thief, under the 1939 Act. So where claims involved an object in a public collection, there's a secondary hurdle. Restitution is often debarred by statute law in England. So, to take, for example, Section 3 of the British Museum Act, that provides that objects vested in the trustees of the museum as part of the museum's collections can't be disposed of by the trustees, otherwise than under Sections 5 or 9 of that Act. Now, those sections, Sections 5 and 9, limit disposal to duplicates, printed material, or where the trustees deem the object to be unfit to remain in the collection. Now, obviously, these laws create a barrier to restitution. They are the two primary hurdles where English law governs the substantive dispute. Now, you've heard mention of the Washington Principles. They remain principles rather than binding obligations on the countries that signed up to them. They don't have the legal effect of a treaty between nations. There's no responsibility on the signatories to transpose the principles into their own domestic law. The real risk, of course, in not following them is the risk of becoming an international pariah. The Washington Principles seek to provide a solution for a moral problem and to provide redress to victims within our living memory. That redress is the return to their rightful owners of cultural objects confiscated by the Nazis outside of legal norms that would now scupper those claims. The 1998 principles recognise the limitation problem in Principle 8, which says this: if the pre-war owners of art that is found to have been confiscated by the Nazis and not subsequently restituted, or their heirs can be identified, steps should be taken expeditiously to achieve a just and fair solution, recognising this may vary according to the facts and circumstances surrounding a specific case. So in 2001, the United Kingdom acted in accordance with those obligations by establishing the UK Spoliation Advisory Panel. In its terms of reference, the Spoliation Advisory Panel is charged, quotes, to consider claims from anyone or more of their heirs who lost possession of a cultural object during the Nazi era, 1933 to 1945, where such an object is A, now in the possession of a UK national collection, or B, in the possession of another UK museum or gallery established for the public benefit. The terms of reference also provide that a panel may also be designated to advise about any claim for an item in a private collection at the joint request of the claimant and the owner. Now, it's obvious these terms of references are very wide, and all that's required to trigger the panel's jurisdiction is for someone to have lost possession during the Nazi era. It's also unqualified by any requirement of Nazi connection, other than that the loss must have occurred during the 1933 to 1945 Nazi era. So in the Benny-Venton missile case, the spoliation panel found that it was likely that the missile was spoliated amongst the scenes of chaos during the Allied bombing of Benevento in 1943, and was then sold by a Naples bookseller to a British soldier in 1944. Now, although the panel used the term spoliated in reference to the loss, there was no direct evidence as to how the missile was lost, no evidence that at any time material to its loss that it was acquired by the Nazis or their collaborators. But the loss must have occurred during the Nazi era to trigger the panel's jurisdiction. So that is between 1933 and 1945. So in a case that went to the United States, one that you may have read about, Matisse's portrait of Greta Moll, the panel found it didn't have jurisdiction in that particular claim because the painting was lost in 1947 rather than within the period of time required by the panel's rules. Recommendations by the panel are not legally binding on the claimant or the institution. It is, in effect, a means of alternate dispute resolution. So far as the secondary hurdle goes, in 2009, Parliament, the United Kingdom Parliament, passed an act that allowed the responsible Secretary of State to deviate from the previous prohibitions on deaccessioning. Now, that act has means that the primary remedy now given is restitution rather than compensation. The claims process is for objects only in UK national collections, apart from, of course, a reference where there may be an item held by a private collector. As I said, the terms of reference do allow us to offer non-binding advice on claims for objects in private collections where both the claimant and the private owner agree. We've not yet had anyone take us up on that yet, which is perhaps surprising given our advice costs nothing to seek. The panel is made up of a broad church of people. There are lawyers, there are tradespeople, there are philosophers. You can read the panel's report on the gov.uk website, and you can see in those reports how we've gone about questions of legal title and assessing the moral strength of a claim. Now, some legal commentators have tried to distill a consistent pattern of reasoning and outcome across our reports, but I think that's a difficult task given so many of the claims turn on their own particular facts. So that's a brief summary of the United Kingdom position. I'll hand now back to Eleonora.
Thank you very much, Tony, for this very interesting and wide overview on the British experience. Now, Professor Hüls-Valenti will tell us how Germany dealt with this issue and first cursus of the appliance of Washington principles in that country. Thank you.
Yes, thank you very much, and also thank the organizer for organizing this. This is a major event. There are going to be no visuals because my short paper doesn't need them. Speaking from the perspective of an art historian focusing on the 20th century, my contribution will not and cannot elucidate the legal conundrum of litigation, arbitration, and appeal. Rather, I'm going to present a rather plain assessment of what the descendants of the perpetrator nation, Germany, did and did not do since 1998 in coming to terms with Nazi-looted art. My aim is to be brief and fair, and also maybe in passing answer Pierre Valentin's question how to do this. German legal experts, solicitors, lawyers, attorneys, prosecutors, and ministers of justice have failed to provide a law. All time limits are barred. Alles ist verjährt. We have but the soft law of moral reasoning. Speaking as an eyewitness, let me start with a paradox. While the Washington Principles on Nazi-confiscated art were proclaimed in the context of a conference on Holocaust-era assets, it did not generate much immediate reaction in Germany. Different from Austria, and we're going to hear more about this in a second, different from Austria that issued a law, Kunstrückgabegesetz, on December 4, 1998, the day after the Washington Conference, Germany reacted in a somewhat administrative way. A year later, in December 1999, a joint declaration or common statement of the 16 federal states was issued, followed by guidelines, Handreichung, in 2001, how to implement the statement. Neither museums nor universities, neither private collectors nor art dealers took much notice. A few isolated efforts to investigate specific objects took place, and a handful of researchers founded the Arbeitskreis Provenienzforschung. Concurrently, in 2003, the Independent Advisory Commission on the Return of Cultural Property seized as a result of Nazi persecution, especially Jewish property, unquote, was formed with 8 members. However, while some restitutions took place, provenance research was not on the agenda. In order to change this on the occasion of 10 years of Washington Principles in 2008, Minister of Culture Bernd Neumann set up a funding scheme and allocated €1 million annually to help museums to research their collections. Rather slowly, a process of raising awareness started, and the dimensions of the task at hand became visible and took shape. Nonetheless, looted art remained a topic for a small but growing number of specialists. This changed drastically when news broke in early November 2013 that Cornelius Gurlitt, 81-year-old son of Hildebrand Gurlitt, housed a sizable group of artworks in his Munich apartment. An international public media outcry ensued. For months, Nazi-looted art was part of the headlines of the title pages of many newspapers and television reports. The international attention propelled the topic to a top priority. Reacting to both criticism and to decades of ignorance, the German Lost Art Foundation, Stiftung Deutsches Zentrum Kulturgutverluste, was founded in 2015 in Magdeburg. More and more funding was and is being made available for research projects. This is important to point out, since many institutions had neither staff nor competences to address these issues. At the same time, after Minister of Culture Monika Grütters had initially refuted the idea of Jewish members in the Advisory Commission, arguing that they would be biased, voreingenommen, a reform of the Advisory Commission took place in 2016, enlarging the group to 10 members. Until 2019, 15 recommendations were issued. Since no restitution law is in sight, the Commission will continue to compensate that very absence. Parallel to the establishment of the Lost Art Foundation, plans to establish specific professorships were launched, but only partly implemented and soon abolished, like in Hamburg. In the early 2020s, the current state of affairs in Germany can perhaps best be described as medium or average or ambivalent. The overwhelming majority of research that is being carried out is realized in the form of temporary projects. After the end of the project, the researcher moves on, and so does the expertise, since not all work is reported and only few reports are fully published. To continuously build on previous findings and achievements is, unfortunately, rather an exception and not the rule. Administrative concerns often obstruct fundamental research, and the full potential of the digital humanities is very hard to realize, since databases have usually been excluded from funding. Very few cultural heritage institutions fully reveal all data regarding their collections, and not even objects on permanent display feature all relevant data. On the other hand, there is a new generation of young researchers eager to uncover the traces of looted art and confiscated objects, both in collections and in the market, which is important. And we witness a few bilateral or transnational projects that analyze the transfer of artifacts in a broader comparative perspective, and they have been mentioned this morning already. This somewhat ambivalent assessment contradicts the latest reports by the Claims Conference on Holocaust-era looted art, a current worldwide overview from 2014. While Germany is classified among, quote, countries that have made major progress towards implementing the Washington Principles and the Terrorism Declaration, along with Austria, Czech Republic, and the Netherlands, Italy, in this 2014 report, is seen as belonging to the countries that do not appear to have made significant progress, along with, and then a number of other countries, Belarus, Hungary, Serbia, and so forth. While this straightforward juxtaposition is partly outdated, I believe, we have to acknowledge fundamentally different approaches, methods, frameworks, and conditions. My own conclusion, coming to an end, looking back at the development in Germany since 1998, can be summarized in 5 bullet points. First, proactive or progressive steps are not being taken because of insight or academic research, but only in reaction to international agreements or pressure. Second, where the nature of the task is obviously permanent, the more so since also socialist dispossessions and colonial translocations require attention in addition to our Nazi looting, the workload is, and that's the contradiction, still considered temporal or ephemeral, to be achieved in the form of projects without long-term perspectives. Third, research into looting requires many more transnational projects, as National Socialist Germany and Fascist Italy jointly occupied almost the whole European continent. And Michael Hopp showed this morning. Consequently, research and research funding needs to transgress national borders, simply said. 4, the quintessentially fundamental challenge of coming to terms with the effects of asymmetrical power relations is a genuine task of many disciplines, notably in the humanities, and I have the feeling that we have barely started to tackle this challenge. 5th and final, following Sophie Schönberger, a most welcome effect of a law would be its necessary public discussion. In addition to legal and moral considerations, the ethical dimension could then be foregrounded. Thank you.
Thank you very much, Professor Fuhrmeister. Now it's the turn of a third speaker, Sabine Leutfelder from the Restitution Department of Jewish Community in Vienna will give us an overview of how the procedure is starting in Austria. We had a little bit of a glance in the film, The Woman in Gold, but I'm sure Sabine will deepen and will give us a wider overview. Thank you.
Thank you. Thank you for the invitation and for the possibility to present the Austrian situation. Immediately after the end of World War II, restitution acts that provided for the return of stolen property were passed by the Austrian parliament. Nevertheless, plenty of seized objects, and amongst them looted artworks, remained in collections and museums. Thank you. And, of course, in private hands. At the beginning of 1998, 2 works by Egon Schiele from the Leopold collection were confiscated by the New York authorities at the MoMA. These 2 paintings, Portrait of Wally and Dead City 3, had been expropriated from their owners during the National Socialist era. Subsequently, this legal case elicited a long-term change in the approach to the issue of Nazi-looted art, not only in Austria, but also internationally. This new approach reached its first climax in the Washington Conference on Holocaust-era Assets in December 1998, and by recognizing the so-called Washington Principles. In the wake of the events surrounding the confiscation of the 2 Schiele paintings from the Leopold collection, the Austrian Federal Ministry for Culture nominated a commission for provenance research. Its goal was to systematically clarify the origin of the holdings in the Austrian Federal Museums and collections. And as a milestone, the Federal Act on the Restitution of Art from Austrian Federal Museums and Collections, the so-called Federal Law Gazette 141 from 1998, was also passed in December 1998, and it was amended in the year 2011. Since then, the aim of this artwork restitution legislation is to carry out the restitution of works of art and cultural objects from the Austrian Federal Museums and Collections, which were seized under the National Socialist regime. Since 1999, the city of Vienna and most of Austria's federal provinces, with the exception of Tyrol, have passed corresponding legal framework provisions and have commissioned experts to carry out provenance research in their collections. Also, museums that do not apply with the law have also made restitutions on a voluntary basis. PG, the Lenters Museum in Linz, who is holding the former collection of Wolfgang Gurlitt. Since the mid-1990s, the Jewish community Vienna, short IKG Vienna, with its Department for Restitution Affairs, has dedicated itself to the issues of supporting Holocaust survivors, compensation and restitution of assets seized during the NS era. Employees of the IKG are cooperating tightly with the Commission for Provenance Research and with the Austrian Federal Museum for Arts and Culture. We are non-voting members at the Vienna Restitution Commission for the collections of the city of Vienna. The Federal Ministry of Arts and Culture, as the competent authority, regularly approaches the IKG, as do various provincial museums and collections, with requests to identify the legal successors in art restitution cases. Doing this work had a pragmatic underpinning, as the search for the legal successors in restitution cases is not regulated in the Art Restitution Act of 1998. Now to some crucial aspects for restitution in public Austrian collections. First, restitution is carried out ex officio. That means, therefore, it's not necessary to submit application, and there are no possibilities for legal claims, as well as no parties to the proceedings. Second, the Commission for Provenance Research, with its researchers in the federal museums, has been tasked with systematically sorting through the holdings and for confiscated works of art from 1933 to the present day. Apart from applied research, members of the Commission for Provenance Research also make a significant contribution to fundamental research. Digitization, publications and specific research projects, including international networking, help expand knowledge of asset confiscations as a result of Nazi persecution. The current heads of the Commission for Provenance Research, Dr. Pia Schellenberger from the Federal Ministry of Arts, Culture, Civil Service and Sport, who is also here with us in the audience, and Professor Birgit Kirchmeier from the University of Linz, have intensified provenance research and are enabling and supporting new projects. And the Office of the Commission is also a contact and coordination point, holds research findings and manages the relevant files from the archives of the Federal Monuments Authority. Third, now, how does the procedure work? Case reports created by the provenance researchers at the museums are submitted to the Office of the Commission for a review. These reports then form the basis for the so-called Art Restitution Advisory Board, set up by the Federal Ministry of Culture and to make a legal assessment. The Advisory Board is made up of 7 members and consists of experts in art history, and representatives of the federal ministries. As a rule, the competent minister follows the board's decisions. The decisions are published. Fourth, once the decision to restitute a work of art has been made, the legal successors of the former owners must be established. Usually, the competent ministry contacts the Jewish community with a request for help in identifying the legal successors. These extensive and very complex investigations are carried out, as well as the contacting of those entitled to receive restituted works. And this culminates in a documentation of legal successorship, which is then submitted to the federal ministry and the Attorney General, respectively. The entitled heirs, who often live in different countries, are subsequently accompanied and supported through the entire restitution procedure by the Jewish community, Vienna. To draw a conclusion, with the measures stipulated by the legislation, Austria has taken a pioneering role in an international comparison. It can be named as the best practice example worldwide. To date, the Republic of Austria has decided in about 500 cases regarding about 300 persons or collectors. More than 600 legal successors were found, mainly with the support of the Jewish community, Vienna. Some 1,000 objects, including works of art, famous paintings from Schiele, Klimt, old masterpieces, as well as books, documents, technical items, a vehicle, or natural history objects, and so on, were handed over in kind to the rightful heirs. And still, there are unsolved cases. These cases get more complicated, allegedly unsolvable, and the concerning items are often not of great value. In the last almost 25 years, provenance research has become a matter of course, not only through the legal determination for public collections, but also serious auction houses and some art traders conduct provenance research in Austria, not only as a fig leaf, but with due diligence and with fair solutions. After many years, a solution also for the Leopold Museum private foundation that was the catalyst for the Art Restitution Act was found. Although the Art Restitution Act does not apply with the Leopold Museum as a private foundation, the foundation seeks to comply with the Washington principles, and this works more or less good. Austria is internationally considered to be the showpiece. Nevertheless, there is, of course, also here potential for improvement. And to conclude with a clear statement, there is still a lot of work to do, and the process of coming to terms with the past needs to go on. Thank you.
Thank you very much for this interesting presentation. Now, Dulcis in Fundo, we have Nicholas O'Donnell, who, as a top leading lawyer in this field, will tell us about the American experience. Thank you.
Thank you very much. It's wonderful to be here with all of you and to see so many familiar faces after so long. As mentioned, and with apologies, I'm an American lawyer. You know, somewhat in contrast to the very interesting perspectives we've heard about already today, there's been quite a lot of litigation in the United States, and that is a function of some differences in our legal system that I'm going to try very briefly to address because there's too much to go over quickly. But again, by way of backdrop, the question ultimately is, what are we talking about? What are the concepts we're talking about that are in play? There is, of course, the question of outright confiscation, but more often the disputes that come to the point of litigation concern scenarios in which there is a disagreement about whether a sale was fair or forced or otherwise, and things like Military Government Law 59, which is lengthy here and I won't read out loud, inform those kinds of analyses, right? Where did the object change hands? Who were the parties? Was it an area occupied by the German government at the time? And throughout all of this, you'll hear, I think, both in the remarks we've heard so far, how do we look at the question of uncertainty? You know, Tony talked about if you look at a transfer where you don't know exactly what happened, what do we make of that? And there are lots of competing views, I suppose, about how that ought to play out. But in the United States, we have a common law system. The Washington Principles, as have been discussed and will be discussed throughout today, are not binding. They are not a treaty of the United States or any other country. And they are inherently subjective. What is a fair and just solution? We'll have a whole panel on that later today. But the question of whether a solution is fair or just is often in the eye of the beholder, and to the dissatisfied party, the options remaining are to give up or to assert what legal rights you may or may not have. And in the United States, we're not talking about museums a lot today, but the guidance of museum associations played a big role actually before the Washington Conference, in the summer before that. Again, as to who has to take the initiative, what kind of transparency ought there be. But once we get to that point, in the United States, we don't have a lot of art that's owned by public institutions. Most art is held in private collections. Most art in museums are themselves administered and owned by private foundations or charitable corporations. So the government's power to direct or dictate things is essentially non-existent as a matter of compulsion. And the question then is, what is the ability of the government to do something by way of leadership? In that respect, I think my country has failed miserably. We have no Minister of Culture, which is not a function of this subject, but on the topic of restitution, there is a lot of talk about how important fairness and justice are, and very little action. And when push comes to shove, the government of the United States will often do exactly the wrong thing. In a case that I argued before the Supreme Court 16 months ago, the United States took the view that the persecution of Jews in 1935 in Germany was a purely internal affair of no concern to international law. I found that outrageous. I still find that outrageous. It makes me angry. But that's what we do. What we focus on instead in the cases that go to court are ownership rights and timeliness, things like that. We do not have comprehensive bans of the sort that have been described in other countries. Most property claims are dictated by the law of the state of the United States where the dispute is happening. And most of those states have relatively short limitations periods. And this is what happened to most litigations in the period right around the Washington Conference. Most were resolved because courts determined that the claims were too old. This is a case that took place in my home city of Boston. This is a painting by Oskar Kokoschka that was owned by a man named Oskar Reichel. And I cite this because I think the MFA did a wonderful job, consistent with the Washington Principles, of showing its work as to why it believed sincerely that this was not a forced sale. But ultimately, the case was decided because the claimant asserted her rights, more than 3 years went past, and that's the limitations period, and that's the end of it. This changed in 2016 with the passage of the Holocaust Expropriated Art Recovery Act, the HERE Act. This harmonized the statute of limitations, the limitations period, to bring a claim for Nazi-era claims at 6 years nationwide throughout the United States. It did a number of other things, but it relied on extensive findings about the comprehensive scope of looting and things like that. And so that has tabled to some extent the conversation about limitations periods. It hasn't eliminated it entirely. There are still some catch-up provisions, and it's not dispositive of all claims. But, why do claims arise? Ultimately, if you look across them comprehensively, it's what claimants have, or what owners have, by the way, owners who, in many instances, initiate court action to resolve a dispute that they think is clouding their property and their ability to sell it. And it's these principles of justice and fairness we've heard already today. Think about an object, think about the history of an object, look at what's happening in Ukraine, think about the things those people are leaving behind. And is the passage of time relevant to whether they belong to them or whether they left them fairly or under just circumstances? These are harder questions. I'll go back for a second, relevant to Italy. This is a case that was also decided on a different concept about the passage of time in New York, but this was a painting that was sold by a family in Italy in the period of the anti-Semitic laws we heard about this morning. But ultimately the courts concluded that the family had waited too long to bring the claim as a matter of what we call equity, not as a strict time limitation. And this is a much more flexible concept known as laches, which is quite often successful in defending against claims of art. Even if a claim is not literally barred, which is something that our legal system does allow to be extended if the claimant couldn't discover the claim for some period of time, it might still be too late because of a failure to be proactive. Relevant to private collections, we heard about Portrait of Wally. This was a customs case. So for those of you with collections, loaning collections, this painting was seized while on loan because it had not obtained federal immunity from seizure. And so any artwork, any personal property that's brought into the United States has potential exposure for customs seizure, which has happened in a few instances, not just this. And I think it's also worth looking at, again, this is hard to do quickly, how these concepts of what sort of diligence a claimant ought to have done are analyzed. This is a painting that was owned by Liz Taylor, the actress, and the heirs of a woman named Margareta Mautner came forward and sued her in 2004 because Mautner had lost this painting in the Nazi era. And they lost because the court ruled that when the painting was consigned to Sotheby's in 1990, that put the heirs on what we call constructive notice. They should have known that this painting was out there and where it was, and so too much time had gone by. I'm not sure that would come out the same today. I think courts have evolved a little bit on that, although ironically, the result might be the same because the availability of information is so much more sophisticated. In 1990, we're talking literally about examining auction catalogs, which is not something most people do. Again, in terms of the evolving perspective, this is one of the few instances where litigation has gone to the point of judgment in favor of the claimants, and it concerns the heirs of Fritz Grünbaum, who filled out one of the property inventories we saw an example of in 1938, and the circumstances of what happened thereafter are quite murky. The family sued unsuccessfully, or was sued about another drawing about 10 years ago, and lost on this same concept of laches. In this case, decided more recently, the court looked more critically at the provenance of the dealer in Bern, who described how the collection had come to him in 1953. So these things do evolve over time. These are just some resources for those interesting. The one on the left is my book, but I think less selfishly, the one on the right, which came out last year, is a nice overview of what's happening in lots of different places, some of which were contributed by people in the room. Just to draw it to a close, the title of our panel is Litigation or Negotiated Solutions, and it's not really an either or in the United States. Litigation leads to negotiations. Negotiations can avoid litigation, and they're both an important part of the system. I was involved briefly in the case against the University of Oklahoma for the Pissarro painting by Leonie Meyer. I represented the dealer who was the son of the dealer who had sold it in New York in the 50s. And this happens a lot in the United States because there was a lot of art that came into the United States in the post-war market. And one of the reasons this is laying dormant is those works went into private collections and were donated to museums maybe a few decades later, came to sale a few decades later. The role of the art market is very important. But that's a case where a lot of public pressure, a lot of back and forth led to a negotiation and a resolution. Now she tried to upend that last year unsuccessfully, but it's really not an either or. It's a continuum as I see it. It's an ongoing push-pull. I haven't talked really at all about the sovereign immunity cases. We don't have time for that. But it's at the end of the day, if you have a contested right, your options are to head out into the street, with brickbats, or to go to an impartial judge, and that's what we do. And these are the issues, some of the issues that we fight over. So thanks very much.
Thank you, Nicholas, and thank you to all the distinguished guests. Are there any questions from the audience? Please.
I'm just wondering, because you showed the military government law 59, and although our session is post-98, I would like to seize the opportunity to ask two experts, why does the London Declaration of January 1943 play obviously not a role in any of these considerations? I always wondered, I never understood. Please help me.
Well, it is only a declaration and is nothing more than a statement of intent. So it was never actually enacted in any law, but it really put the Germans on notice, or the Axis powers on notice, that any sort of pilfering was going to be dealt with. And I think the Allied powers were quite clear about that from 1943 onwards. But it never became, or never had, the formal status of law or enacted in any way.
I think the answer is similar in the United States. And the fact is, the extent to which military government law 59 should be read to determine the property rights is unsettled. I mean, courts have struggled with that concept, even with what is obviously deemed a military law. I think courts have looked at the London Declaration more like the Washington Principles in terms of kind of an aspirational focus.
And the other thing about the 43 Declaration, it only applied to occupied territories, not domestically to Germany as well.
We have 2 minutes left, so I would like to ask you, maybe Sabine already answered. Was very interesting, seeing the different perspective and the different solutions each country has adopted. So just in 2 words, what would you say about your own country and the system adopted could be valuable and adaptable, and also for other countries, like Italy, for instance, and what instead could be improved or changed?
Well, I think we'd like some more claims. I mean, I think the process that we've tried to adopt, that we have adopted, has been as transparent as possible and as speedy as possible. But the fact remains, we've been very quiet for the last 3 or 4 years, and we've only just now had a claim come before the panel again. And so we'd like more work to do to see where our processes might be failing and where they could be improved.
Well, Sabine already said that Austria is working very well. And
yeah, of course, there's always place for improvement, but I think it would be too detailed to this issue in Austria or for Austria.
Thank you very much. The topic is so interesting, and your interventions are interesting as well, that I would keep you for the entire day, but I have to, there are so many panelists and speakers to listen, so thank you very much to you all, and
thank you.
And I give the floor to Pierre Valentin.
Yes, thank you very much, Eleonora, for this interesting panel, and to all you four panelists. I would now like to ask Pierre to gather his speakers and to set up the stage. Thank you. The following panel is about the art market's perspective, the importance of provenance.
How do you want a mic?
Yes, I prefer to be there.
Yes. Apologies for the interruption. I am thrilled to be the moderator of our second panel of the day. The title of our panel is The Importance of Provenance, the Art Market's Perspective. And I would like to introduce our illustrious panelists. Dottoressa Giovanna Bertazzoni, who is Vice Chairman of the 20th and 21st Century Department at Christie's. Madame Elisabeth Royer, who is an art dealer and the director of an endowment fund known as ARM, A-R-M, that stands for Art Restitution Memory. 15 years ago, Madame Royer founded HARP Europe. HARP stands for the Holocaust Art Restitution Project. And on my left, Avvocato Giuseppe Calabi, probably the best art lawyer in Italy and the managing partner of CBM and Partners in Milan. There is an empty chair. Dr. Johannes Nathan was meant to be with us today, but for reasons beyond his control, he's unable to come. He sends his sincere apologies. Now, I propose to address two parts of the challenge facing both families looking for Nazi-looted art and collectors who inadvertently acquired Nazi-looted art in good faith. The first part is investigation. By investigation, I mean the search for information that will shine a light over whether there is a stain on an artwork or not. The second part is resolution. By resolution, I mean finding an acceptable solution, acceptable to, on the one hand, the family of the party dispossessed during the Nazi era, and on the other hand, the collector who bought the art in good faith for its fair market value. Let's start with investigation. Giuseppe, the search for information assumes having access to data. And we know that auction houses and dealers are generally quite reticent to provide provenance data. There are legal reasons for that, but also commercial reasons. Can you elaborate?
Sure. Thank you, Pierre. Yes. Legal, it's not just a matter of being cooperative or not being cooperative, but the legal reasons for being reticent about disclosing data is called GDPR, the General Data Protection Regulation of the European Union, which entered into force which was enacted in 2016. Because provenance data are personal data. We don't have to, it's impossible to avoid, this is not an assumption, this is a fact, giving the very broad definition of personal data, which includes, covers any information regarding an identified or identifiable natural person. And the disclosure of personal data is an operation which involves the processing of personal data. A first question that would arise is that frequently provenance data refer to deceased person. So are data related to deceased person covered by the GDPR legal framework? Apparently not, because recital 27 of the regulation says that very clearly that this regulation does not apply to the personal data of a deceased person. However, member states may provide for rules regarding the processing of personal data of deceased person. And here, lawyers start to be involved because this, however, has been applied differently in European member states. For instance, in Italy, it is possible, this is what Italian law provides, that family members exercise the right that may have belonged to the deceased holder of a certain personal information. In the UK, as far as I know, this is not possible. So a deceased person does not, well, the heirs or the descendant of a deceased person cannot claim anything related to the data of the deceased person. Now, in order to process personal data, you have to follow very clear rules. I mean, you need the consent of the data holder, data subject, and the consent must be given for a specific purpose. So there are, clauses that you have to, boxes that you have to tick in. I opt in for any use of my data. I mean, this is not really, in my view, very much in compliance with European law and with the national laws. So if it is if there's no consent, and based on my experience, very rarely auction companies or dealers request a consent to disclose personal data that may have to deal with provenance. I mean, I've never seen such a clause. And the other possibility to lawfully process personal data is whether the processing is necessary for compliance with legal obligations to which the data controller is subject. But there's no legal obligation that would impose, at least in my country, I mean, I'm speaking about Italy, to a potential claimant any data regarding to provenance, provided that this is a personal data. Or if the information, the disclosure is necessary to protect the legitimate interest pursued by the data controller. So given this legal framework, there are legal issues here. What about data regarding looted art? I mean, there is just one time in which the word Holocaust is mentioned in the GDPR, and this is recital 158, which allows processing with respect to the use for archiving purposes. I just read you three lines, and this refers to information related to the political behavior under formal totalitarian state regimes, genocide, crimes against humanity, in particular the Holocaust or war crimes. But clearly this would not be applicable to the art business. So just a last remark, the European Union is considering setting up a meta-database collecting all data established on provenance of cultural property. And the policy is that provenance data should be exchanged on as freely as possible, in particular cross-border. But here we are in the domain of policy, and this has not been implemented yet.
Thank you, Giuseppe. Giovanna, would you say that the auction houses are more open today to disclosing provenance information for research purposes?
I would say yes. And so the premise to, clearly I'm talking today on behalf of Christie's, but I would say that auction houses in general very much feel now as part of the research community. So that's the first thing that I want to say. So on the one side, the data is now digitally organized, auction catalogs, auction records, all the layers of information we've gathered in decades of offering, selling works of art are being digitally organized with the express aim of making it transparent, making this information available, readable, understandable, not only to us, but all the whole community of research that I mentioned before. All the people who are here today, all the people who work with us, all the people that actually feel they need to access it. And we're investing in this research. This is the main point. There is an investment and a dual aspect. We're investing monetarily, we're creating positions, we are enhancing our restitution research department, but also culturally. Within the departments, I am part of the department, I'm a specialist, I'm an art historian to begin with. The culture has changed dramatically in the past 25 years, since I joined. The people we hire, the people that we want to involve, the people that work with us are all committed to looking at the provenance in a different way, in focusing obsessing on gaps of provenance, on what we call the sensitive database. We not only the catalogers that start the process, so we select people also with this frame of mind, art historians who then become catalogers, who then become specialists, who form the basis of our cohorts of people working at Christie's. They all work with this culture, and I'm sure this is the case for other auction houses. What we have is actually de facto the biggest restitution department in the business. It's a global department. We have neuralgic centers and strategic centers in London, New York, Paris, and we constantly share information. We constantly try to work like this. This is on the one side. On the other, and I want to acknowledge this, and I really come here today. Today has been actually, already the morning has been a lot of mea culpa. Mea culpa with hope, let's put it like this. So I also will say my mea culpa to you, Elizabeth, because we've been preparing together, so I know exactly how you feel. And many of you here, this is not enough, okay? It's not enough what we're doing. It's not enough the amount of information we're sharing. It's not enough the research we're doing. I don't want to not have hope. I absolutely do. I think this cultural shift, this direction of travel that we at Christie's and all our colleagues in other auction houses are undertaking is palpable, is there. So there is a shift that is, and actually we'll talk about the major shift that happened later on with events that just happened 3 weeks ago. This said, GDPR is an obstacle. Is a problem, is hampering us. The amount, the volume of works that everyday artworks come through us is clearly an issue. We do commit to dedicate the same amount of time, and Sarah Dunn, who's here today, an amazing colleague of mine, who's the head of the Restitution Department in London, knows it, to the small object and the multi-million object, because the problem is there, and it's not only an ethical problem. It will always be a commercial problem. That's the endeavor. The reality is not always like this, but that's the direction of travel.
Thank you, Giovanna. Elizabeth, can you tell us about a case where your investigations have led to a positive outcome?
Yes. It was a painting by Léger. I'm going to show you the photograph, not the other one, yes. It was a painting with Léger, and it was a very long and complex process to prove that the painting, illegally exhibited on the walls of the Minneapolis Institute, was the exact same painting that was stolen in 1940 to Alphonse Kahn House. So the difficulty that you talk about the French archive of the dealer's book, the painting has some titles. When Henri Daniel Kahnweiler, the German dealer, bought the painting by Fernand Léger, it was titled La Ville vue d'en haut, and he bought from the Galerie Simon. 4 years later, Alphonse Kahn purchased the painting with another title, Les Toits, from the Galerie Simon. In end of October 1940, Alphonse Kahn mansion in Saint-Germain-en-Laye is invaded by the Nazis, and the content of the house entirely seized, about 2,500 works of art. After, of course, there was in 42 an administrateur provisoire who make a sale in 42, through the auctioneer Georges Blond at the Hôtel Drouot, some of the little artworks from the Kahn collection are being auctioned at the fourth sale of the Jewish Kahn. The title of the sale was Sale of the Jewish Kahn, among which the same painting appear with another title, Usine. Louise Léris purchased the painting at this sale for the Galerie Louise Léris in Paris. When Daniel-Henri Kahnweiler came back after the war as the director of the Galerie Léris, he organized the loan of a painting for an exhibition in 1948, I think, and in Fribourg-en-Brisgau, and the painting was titled Les Toits. and there is no mention of the collection of Alphonse Kahn. So after Kurt Valentin bought the painting in 1949, an American collectioner, and it was a gift to the Minneapolis Museum. As you understand, one of the big problems was the situation that we have 5 different titles, and it was very difficult to prove that La Vue vue d'en haut, Les Toits, Usine, Fumée sur les Toits was the same painting because we had no access to the book. One of the key elements of archive, it was that was obtained during my research, was the copy of the inventory book of the Galerie Louise Léris. The piece of archive, very confidential and private, was proving 100% that it was indeed the Minneapolis painting which was purchased in 1942 under the title Les Toits by Louise Léris. So tracing the history of a painting is particularly difficult due to the fact of the name change and due to facts as well that sometimes you have more versions. In this list done by the Nazi, there is of the looted paintings from Alphonse Kahn, there is the number 1137, an oil on paper, Fumée sur les Toits, the same title, the same artist, but it was a sketch. So Alphonse Kahn owned as well the sketch on the painting, which was on the list of the Nazi. But the other painting, the Minneapolis one, was not on the list. After the war, there was a list in 1946 with Kahn claim some paintings of which he had no photo and no invoices. And we have to know that all the German lists are most of the time incomplete. So it was 10 years to prove at the time that it was the right painting.
Elizabeth. Let's now turn to resolution. The hypothetical scenario is this. Mrs. A bought a painting in good faith for its fair market value. Mr. B claims that the painting was wrongly dispossessed from his family during the Nazi era, and it's the same painting. What's the solution? Giuseppe, from a legal perspective, what are the rights of each party?
Yeah, thank you, Pierre. This is a very interesting question. Art restitution claims give rise to territorial issues, as has already been pointed out this morning. So what is the applicable law? And laws are different from one country to another. Whether it's the contract law or it's the law of the place where the work is located, the so-called lex re site. And so these are issues that art lawyers involved in restitution claims always have to deal with. I would like to cite 2 cases. One, it's an American case. I'm not an American lawyer, but I think this is an internationally interesting case. And the other one is an Italian case. The first one is a case that had the heirs of Mr. Cassirer against the Kingdom of Spain. So Mr. A and Mr. B could apply very well to this very specific case. We know this case was tried in America, and there are here colleagues from the US that were involved in this case, so certainly the information I will give is very superficial, but we don't have much time. But I would like to talk about this case, because in this case, it was found that there were, so it involved a painting by Pissarro in Rue Saint-Honoré, après-midi, effet de pluie. In 2019, the US District Court, Ninth Circuit, I think, held that the claim by Cassirer could not be, had to be rejected. And although there were very hot red flags that would identify that the purchase of this painting by the Baron Thyssen-Bornemisza could have noticed labels that would indicate, parts of labels that would indicate that the painting came from the Cassirer Gallery, a very renowned gallerist in Berlin. However, and I would just like to read the second last sentence of this very long opinion. So the issue here that was argued by the Kingdom of Spain is that they had acquired, well, regardless of all, the provenance issues, that they had acquired a good title because the Kingdom of Spain had possessed this painting for over 6 years, which is the time prescribed by Spanish law for what we call usucaption or adverse possession, as it is called in legal English terms. And this is what the court held. However, the court has no alternative but to apply Spanish law, and it cannot force the Kingdom of Spain to comply with its moral commitments. And here there is a specific, expressed, but a specific reference to, implied reference to the Washington Principles. So I know that this case now is pending before the Supreme Court, and we'll see what is going to be the next chapter of this case. But here, the court could not but apply, this is what they said, but could not but apply Spanish law. And in Italy, the situation would be exactly the same. So under Italian law, a prolonged public possession of an artwork would create a valid title, regardless of whether or not the work had a murky provenance. I mean, even if the buyer is in bad faith, this is what the Italian Civil Code very clearly says, and Italian courts would find it very hard to deviate from this ground rule. I mean, as a lawyer, I hope that this may change in the future, but to be practical, I think it would be very hard to argue that soft law principles could prevail over provisions in the Civil Code. Another case tried by the Court of Milan where an auction company was involved. I mean, they received in consignment an item that was then sent to London to be examined. It came out that this object was most likely the result of a forced sale in Germany. So the auction company disclosed this information to the consignor. The consignor requested the restitution of the work that they, had, and it was just deposited. I mean, it was in custody. A consignment agreement had not been signed yet because the work had to be examined, reviewed before the consignment agreement. So they requested a restitution, and the auction company said, no, we don't intend to give it back to you. Please sue us. I mean, we'd like to have a court say something about it, which is a common situation. People who work in auction companies frequently, they know what I'm talking about here. And so the Court of Milan said, and the defendant said, well, there is this issue in the UK, there is a committee, maybe we should consult this committee. And but the plaintiff, the claimant, said, no, we want it back. And the Court of Milan said, well, English law would not be the applicable law here, and therefore the item has to be returned to the owner, and that was, and the auction company could not but to comply with this court order. So solutions vary from country to country, and it's probably very difficult to find a uniform solution. Certainly, lawyers should, work in order to find a just and fair solution to these cases. But it's hard, especially in countries like Italy, Spain. I don't know France, but I'm talking about Italy. Italy is not very, as we have heard this morning, is not very sensitive to this issue. Unfortunately, I would add.
Thank you, Giuseppe. And you mentioned the Katharina case.
Yes.
It's a very important case, and we'll come back to that this afternoon. Elizabeth, in our example, what advice would you give Mr. B, who claims that the painting was wrongly dispossessed during the Nazi era?
Alors, the first thing, the most important thing, is to listen to the family and ask all the relevant questions and try to understand the whole situation. And you have to understand that all the situation of restitution of material assets is very emotional, and for the families and the heirs. And it's not just a question of possession, but or money, it's first about memory and ties to a very painful past. So the assets, such as artworks, are a very real compensation for their immense loss. So what you can try to do is to bring justice. So, of course, I always ask the genealogy to know if all the heirs, to make the verification of all the heirs. And sometimes I ask a notary or a genealogist to make the verification if there is not another heirs. And we ask as well if the family has documentation. It could be a notebook, an address book where we can find the name of a dealer, a photograph, a memory, but sometimes they have nothing. But every document could be very important. The third step is to go into my archive. And those archives have been a major priority in my life since 1996, when the Hector Feliciano book was published. And I have spent all this year to enrich my documentation in every possible way. I digitalize most of the archive of the Quai d'Orsay on the recuperation artistique, and we have archive from the notary, from banks, from the real estate in France between 1940 and 1945, and all the catalogue raisonné during 20 years. We add all the provenance we find. We have as well a very big base de données on the actor on the art market between 1933 and 1945. And after, of course, we use the database, the public archive. We have friends in museums, sometimes auction house, sometimes, and we try to complete and to find the painting. Of course, you have seen ERR list, but sometimes it was stolen by, without any list, just the name of the artist, with no title, with no dimension, and we have to find with the catalogue raisonné and the experience and our database which painting it could be. And sometimes we choose 10 paintings, you know, and you make the verification of the provenance of the 10 paintings, and sometimes we are lucky and we find the work. And of course, it's very important as well that the family, the heirs, has one demand and not fight together until they recover one work of art. So I work alongside with the families and share all my personal files on a confidential base, which is very important for me. And the result of my discovery are shared and put in a file with a description of what we hope to find. Looting and claiming in a strong and demanding commitment, which include a personal and emotional dimension. And we accompany the heirs throughout of this long and complicated process. And of course, we always try to make a settlement before going to court. And I want to finish to say that it's what I tell to the heirs. Contrary to what many people say now, claiming artworks hasn't fundamentally changed. Institutions, government, individuals, but however, I believe that new jurisprudence, new cases, forced people to retrieve and return artworks of art.
Giovanna, do you think that the auction houses can be part of the solution? Is there an example you can share with us?
Yes, I do.
Good.
I think I do, of course. I think Christie's and the art market at large can be part of the resolution of claims because we do help bring our experience and expertise to the table as intermediaries. This is what we do. We are negotiators. We have decades, centuries of expertise. In this case, intermediaries between a current owner and a problematic artwork and the claimant. So we have that experience and we work alongside, inspired by the Washington Principles. All the people that are in the restitution department, and especially Mark Porter, who was in Washington and is our leader in the sense he's the chairman of Christie's Americas, are formed to think like this. So we commit to offer a safe, legally and commercially environment where these companies can find a solution. Not only because of the research which we just mentioned and that endeavor, but because we have legal framework around it, because we have people like Giuseppe that help us outside, because we have a community of people that really accompany us in the process of finding solutions. So what happens for instance, when a red flag emerges or there is a gap or really actually a real problem is emerging in the process of cataloging a work of art? As Elizabeth said, we try to be as, in a good sense, aggressive as possible in gathering all the information we can. And we are pretty efficient nowadays, because remember, our main problem is also that we work in deadlines that are incredibly tight. I think that one thing that has changed, for instance, is our ability to stop and take stock much more than we used to have a sense that, okay, we don't necessarily need to have a commercial impulse to go to auction or to conclude a sale. This is always going to be a problem. We have to sort out this problem and sort out it very cleanly, very transparently. And the idea that the problem will always remain if we don't find the solution is what leads us in the communication with the owner in this moment that you mentioned, Elizabeth, very delicate, very emotional, of telling an owner who bought something in good faith, so he's going to be totally traumatized themselves to having been part of the process. And we have to understand also the frame of mind of the person that finds themselves owning unwittingly this work of art. And so we need to understand also that frame of mind to come to a resolution. And being cultural mediators means that as well. So on the one side, we have the claims of the victims, which is real, paramount, and of absolute importance, and very clear to us. For all also the psychological implications that we mentioned before, the trauma of that it's not only about that work of art, having been through being dispossessed, not having your house anymore, and how can we not relate? We're seeing everything that is happening in Ukraine now, so we're relating to this absolutely dramatic moment when families that were happily living in the houses with their works of art and having concerts and being the center of the intelligentsia of a certain place were dispossessed and taken away. And On the other side, we have someone who ended up with this work of art and didn't know about it. So we need to gather the information. We need to understand exactly from the present owner everything we can have. We have to accompany them in the process of wanting to find a solution. And I would say that very, very often recently we've come to very conclusive solutions. We have some examples, for instance, that we can mention. Thank you. This is La Mousmée. This is a Van Gogh that we sold a year ago in London on the 1st of March of 2021. And it's splendid work. It's the second most important work of art by Van Gogh on paper that was ever sold. And it's a girl in Arles that he encountered, and in this incredibly intense final years of his life, 2 final years of his life, he depicted. So we knew that it had belonged to the Hirschlands, a family from Hessen, who then fled to America. What we found out, actually, it's exactly how it happened. And all the provenance that had been recorded before our sale was faulty, had an enormous lacunae. And it was great in a month that we could communicate with the heirs, find the right way that things happen, have their words, really record their happiness because the things had been recorded and for the first time was presented properly. So that's one of the examples that we lived recently. Another Van Gogh that we sold this time in November in New York as part of the Cox collection, you probably remember it. This is actually now more important that in terms of the result than the Mousmée that we just sold. This we had to come to an agreement between the Cox family, the owners who unwittingly and unknowingly had purchased this work, and two sets of families of heirs who had actually been dispossessed because he had been basically looted twice. And again, it was done in good time. Luckily, we had won this collection in March, and the sale was in November. So it was a process that was done with time, with full information, with the specialists involved, and it was such a joy to be able then to bring it to auction with the parties agreed and to have such a great result. This I wanted to share with you because I just showed 2 items that actually were multi-million dollar items, and going back to what I said before, and going back to the general dichotomy and aporia, if you want to use a word coming from Greece, the impossibility of finding a solution that we have. How can we dedicate time to everything? We don't have this time, we don't have the resources, we want to. But this was a little casket that actually belonged to the Goldschmidt Rothschild and was seized by the Nazi authorities. And it was estimated 4,000 to 6,000 pounds. It sold for 16,000 pounds. It's a lot of money in any way. I mean, I have a sense of money. I haven't lost it in selling multi-million dollar things. And still, it's not the amount of money that we generally think about. And yet, time was dedicated to this object. There was a resolution, and we could offer it, and it sold very well. And this is not the case. This was not the case, not even 5 years ago. So this is why I have a hope, because there are more resources that allow us to dedicate time to these kind of objects, and that's why we chose it, to show it that it's not necessarily only objects like this, which is the final point I wanted to make, that get our attention. So why is this work, to me, really a watershed? And it is a watershed for restitution, as everybody here in this room probably knows, also in giving me hope that a lot is changing, not necessarily only because of the framework of works and decisions that actually pull us forward, but because this is culturally, I think, a very important moment. So this is now the record prize, world record prize for Franz Marc. Franz Marc was one of the main artists of the Blaue Reiter, and sadly died in 1916 in Verdun in the First War, blown to pieces, really, by a bomb that destroyed everything. There is not even a place where we can go and, I mean, yes, there is a tomb, but his remains were completely lost by the violence of the explosion. So he painted the foxes. This is unbelievable picture. It has, to me, a level of like tenderness and he's one of the best works, his masterpieces, and probably, I always thought also it was a self-portrait, because you have this tour de force of cubism, but at the same time, really a sort of like cubism made more human, because of his identification with animals and this panism that, he believed in. A man who believed in peace, who died in the war, and anyway, created this tour de force in 1913. In 1916, he dies. The work goes to his widow, Maria Mark, and she sells it to Walden, and actually this is documented by, this is actually the two of them. This is Franz and Maria, just before he died. He was also an incredibly elegant man. The photos of him with Kandinsky, with the other fellow, Blaue Reiter, are always showing him tall, beautiful, really a huge loss. We wonder how much more he could have painted. On the back of the foxes, there is this Der Sturm label. He was the dealer who helped the Blaue Reiters and sold most of them. And he sold it to the two sets of collectors before it ended up in the hands of the couple that is at the center of the story that I'm telling you. Because in 1928, these beautiful people, Else and Kurt Gravi from Berlin, bought the foxes, rightfully, in 1928, okay? And he was Jewish, she was not. She was the widow of another Jewish man, so she was, just to show you how integrated, as we all know, German society was at the time. They had two kids, Wolfgang and Peter, and they led a beautiful life in Berlin, as I described before. He was a banker, an entrepreneur, made a lot of money, and spent it in culture, like many of this family. Had a salon, and the foxes was his pièce de résistance, in his collection. He really believed in the picture. They all loved it. And as Elizabeth said before, talking about pictures is never talking about any other asset. This is memories. Give a price to memories. It's impossible, It's so difficult to compensate because it's memories, it's pictures that were around these people when they were having dinners and their family celebrations. This is what makes everything so emotional and our job so delicate and relevant. Anyway, in 38, immediately after Kristallnacht, his business in 35 is Aryanized. He slowly loses everything, all his assets, and in 38, the day after Kristallnacht, he is taken to a camp near Berlin. Actually, he's there only for 3 weeks, which is enough to, as we can imagine, completely traumatize him. He leaves, and he understands immediately he has to leave quickly and try to find refuge somewhere else. So he leaves with the 10 marks that were mentioned before that he was allowed to live with. Through Belgium, he goes to Chile. And in Chile, he joins actually relatives of the first husband of Else, who had already recovered there. And only a year later, after a very turbulent trip, as you can imagine, Else is able to join him with the children. And I find this photo so moving because this is them reunited, okay? Husband and wife and the children are finally all together in Chile, penniless at this point, okay? And the only thing that he manages to do is to recover, through the help of friends and everybody else, the foxes, okay? He recovered Die Füchse, let's go back to the picture, and he gets it back to New York. And at this point, against any intention, against every fiber of his body, he has to sell it because they don't have a penny. And so he decides to go to New York, gathers money, final money that he can get from family, friends in Chile, goes to New York to sell it, and he offers it first, through the help of a dealer, to Alfred Bach, that you all know. He is the director at the MoMA, the founder of the MoMA, the person who's putting together the most important museum of modern art in the world. And to me, an icon, but in this case, he made a big mistake because the Foxes, he had paid in 1928 the equivalent of $3,000 Gravi. And he decides that he has a reserve, which is 1,250, and Bar offers only 800. So that doesn't happen. He sells it to another collector. The sale is actually accepted, but he's written to everybody, and it's actually in good faith, and it's a couple of Jewish collectors in California who wanted to help them. And it happens in America, okay? So these are all very important points in terms of legislation to understand why this restitution happened. Because subsequently the painting ended up in 1962 in the museum in Düsseldorf, and just before Christmas, now, this year in 2021, the city of Düsseldorf decided to restitute it to the heirs of Gravi. And it's the first time that this happens outside of Nazi Germany, and actually in a sale that wasn't contested, but it was under duress. We have a lot of documentation that says, I'm selling it because I'm desperate. So we salute this. We think it's a watershed. It gives us hope that this is happening. It changes a lot. It changes a lot also about what we sold in the past. It actually catalyzes a reflection and a self-reflection that is going to be very interesting for us to undertake, but we're willing to do it. So it was really an important moment, and it's what gives me a sense that we're going forward.
Thank you, Giovanna. Thank you very much. Thank you, Giuseppe. Thank you, Elizabeth. Thank you, Giovanna. We have time for one question. Well, we don't have time, but we will invite one question or two questions.
Olaf Osman again. I think besides the picture that Giuseppe painted for us, I think that all the other developments created are, in my mind, a bit too positive, because we mix up two things. The last case mentioned with the Foxes is a decision by the Commission in Germany, not under the German law, not under any law. It's a soft law decision. And the soft law decisions, we saw development in the Netherlands, we saw it in Germany, that there are positive developments, but some of us here in the room attended Washington. And the reason for Washington have been two things in my mind. The first thing is that we have failed terribly with restitution in the after-war period. That's one thing. The second thing is we realized that the present legal systems in the after-war period and the present one today are not able to deal properly with this problem. We knew it. We knew exactly what happens if people go to court, and unfortunately I have to disagree with the opinion that you will have success with most of the cases in France as well, because it's the same situation as we have in Italy and we have in Germany and we have in the United States. So we didn't made it to a change in law. So we still we count some progress in the soft law area as legal developments, and they don't are. So I have to explain to my clients that in court, and this brings us to my question to Christie's, because what is the reason why Christie's is involved and has an interest in it, besides the business? It's simply that they have to transfer a proper, complete and safe title to the new owner. That's the reason why they do this. And by doing this, my simply suggestion for anyone who comes involved as a claimant or somebody who thinks that something happens, try to register. Simply try to register. Go to Lost RTE and start a registration process for two things. One is, this is the best check you can get if you have a proper proof, a prima facie proof, let's say it like this. And the second one is, that's the only thing in the moment that can really stop sales. Because no auction house will touch a painting that's registered. And by this, I think that's the only opportunity, even for small auction houses. It's, yeah, we speak with Christie's and Sotheby's, the two big ones. There are some more who handle the cases like this, but there are a lot of small auction houses who don't do. The only thing they do is, if they see a red flag in a register, they return it to the consignor. That's what happens. Or in some cases, they are not even able to identify the painting, and though they cannot identify the provenance and sell it. It happens all day. So for my suggestion is, but what about the knowledge of the auction houses? That's still my concern, because we started with some ideas about rights of the former owners and things like this. But how about publishing more information about provenances of the past, and to make it more comparable with information that are registered in some other register?
Thank you. You want to address that, but really quickly?
No, it's difficult to do very
I know.
So first of all, I understand your frustration. I just need to be a little bit more positive than in general, because I think we need to look at our endeavors with a little bit of hope. I disagree that we only look at these matters because we want to pass on an object with clarity of title. Yes and no. No, there is also pursuit of justice that inspires us, and all of us, we do abide to Washington. And that is true, okay? Culturally, it's very important. There is a shift, and it's fundamental. There is a willingness to do that, not only commercially, but because it's ethically the right thing to do, okay? So we endeavor to do that. We try to have as much provenance. All our archives are now digitized and are available as much as we can. We didn't used to, and this is where you're right, to be so thorough in provenance. We now are better, miles better, but we didn't research the same way, even when I started. You know, this is, as I said, is part of a cultural shift. We're getting there, and we endeavor to get there to satisfy your needs and everybody's needs here. We're not there yet. That's how I started, you know, and I know that. I'm aware of it. I think the intention is important now, though, and it's not only commercial. That's my point today. There is a willingness to pursue justice. The Gravis gave us the mark because they felt this. We had this intention. It was profoundly there as an ethical commitment.
Thank you. We have to stop here. Very interesting. I wish we had more time. Lunch is being served upstairs. For those who are watching us online, we will resume the conference at 2, well, what does it say in the program? 1:45, so in 45 minutes. Thank you, and bon appétit.
Grazie.
Voi a posto. Vediamola.
Prova, prova. Okay, fine.
Shall I go? Thank you, everybody, for being back at the conference in time. We are now resuming our works. My name is Luigi Macioce. I am one of the partners of Boyes, Schiller and Flexner, Italy. We have a team focusing in assets, family asset protection, trust and estates, including our collection, not to mention the splendid work that our partners in the US are doing for supporting the Cassirer family before the Supreme Court. But before moving to our panels of discussion, I would like to introduce you to Caroline Christoph Bakargiev. Caroline is a curator, researcher, and scholar. She's the director of Castello di Rivoli Museo d'Arte Contemporanea and Fondazione Francesco Federico Cerruti. And Caroline is going to give us a testimony of a perfect, proactive, efficient approach of what a museum can do in facing a big issue like finding that one of the pieces is Nazi-looted. So I leave the floor to Caroline. Thank you.
Thank you very much for this kind and very generous introduction. I'm happy to be here. Thank you for inviting me. Before we enter into the story of this wonderful painting, through which story we understand the many intertwined stories of human beings, and against the backdrop of war and its subsequent consequences, I'd like to just mention that I feel a bit like a fish out of water because I'm what you call a contemporaneista. I was the director of Documenta 13 in Kassel in Germany in 2012, the second and only woman to direct it. And therefore, my general daily life is not spent dealing with restitution cases. So please pardon any lack of knowledge of what are the current and urgent issues in your field. I am indeed the director of the Castello di Rivoli, Museo d'Arte Contemporanea, which is in itself not a contemporary building. It's a building from the 18th century, Juvarra. And in recent years, in 2016, I began to work with a team of art historians on the collection of Francesco Federico Cerruti that I will tell you about, which ultimately resolved in the opening of the Villa Cerruti as our third building in May of 2019. Of course, in 2020, it closed with COVID and so forth, and just recently has been reopened, and to which I invite you. The curious thing is that years prior to this issue of the Jacopo del Selaio painting, a friend of mine, a very good friend of mine called Lynn Rother, who is someone that you know, I think, in your field, very, very much, I believe. We were both Getty scholars in Los Angeles, and we were sitting by the pool in the little place where Getty scholars sleep and wake up in the morning and have breakfast. And we were talking quite a lot about the issue of restitution from a more broader perspective. In fact, being from contemporary art, I often think of this phase of cultural history as part of a much longer and much bigger issue, which starts in prehistory and ends in the long, long, long future. So I'm always interested in what was before. So before 1936, when this painting was bought, and what will happen after, 1,000 years from now. That's the way that artists who are alive actually think. So this is the story, and I'm glad, very glad, that some people speak of it in Italy as a kind of watershed moment, because it was very amicably resolved. So this is Castello di Rivoli. This is the small little villa that nearby, it's about 400 meters from the Castello, Cerutti built on a piece of land he bought while the Castello was just a ruin, was not a museum, in 1960. And in 1965, it was completed as a house outside of town. Cerutti was a bookbinder. He came from a very poor family of bookbinders. His father, Giuseppe Cerutti, who was born in the late 1800s, came to work for Paravia in Torino when Cerutti, who was born in 1922, was just a small baby. The house didn't look like this, but we decided not to, well, I have to tell you what happened. So this is Cerutti in 1957, when he's going to the United States, and for the first time, and he will bring back the technique to perfect bind to Italy. So he'll do in Italy what Penguin did in the UK, which is to make a way to make books available democratically through glue and cutting the back of them and not sewing them. What's interesting is that Cerutti, who never met Grete Heinz, who is a wonderful woman who lives in California, he never met her, but it's more or less the same age. So he died in 2015, on the 15th of July, and I was entrusted with this problem of the collection as a whole in January 2016, when an estate lawyer came and said, well, it says that the whole collection and the whole property of this collector, who was extremely reserved, Cerutti, needs to go and be entrusted through a comodato and managed by the closest museum. And I said, well, where is the house? And it's 400 meters from here. Well, why didn't he write Castello di Rivoli? And then now that I know him through his papers and through all the knowledge that one has over years, I understand that he would have written the closest museum. So I have so many stories that I could tell you about both him and about Grete Heinz. But this is the room where you see the last painting that he bought at auction was the little Jeune Fille aux Fleurs by Renoir. But as you see, there are many books in the collection. We decided to not take the collection out, also because it was not in his wishes, but we restored all the works, studied all the works. 89 art historians worked on the catalog, on the general catalog, which has just come out with Umberto Alemandi. And so in those years, we worked on restoring, renovating, putting in the climate control, the security and everything, and turning it into basically a house museum, which is our third building. Given that we are a contemporary art museum, for us it was important that we were collecting the collector. So I often see collectors as people that I could collect. Being a contemporary art person, I think they have very strong personalities and they are key to understanding our contemporary times, our times of archiving and of digital, our times of YouTube where we see Pasolini together with a film made yesterday and so forth. So the personality of the collector is very much interesting to us as a contemporary art museum, even though the works that are in the collection may be of many, many periods of history. He was very close to Maurizio Fagiolo dell'Arco and very interested in De Chirico. He has probably the largest collection, private collection of pre-1927 De Chiricos probably in the world, including the Saluto degli Argonauti Partenti, the first one of 1921, where De Chirico refuses the contemporary world and says, basta, I will go to the Renaissance given that you've blown up Europe. with World War I, and that causes, of course, the break between the Quirico and the Surrealists and so forth. And in this room, which is a very special room, which is where our story will start today, this is a tower. In the tower, there was a tower in the house. There still is a tower. You saw it in the first picture. In this tower, there is a tower room, and this room was the room that Cerutti thought he would die in. By the way, he only slept one night, they say, maybe 2 nights in this house. So it was already a museum just for himself. He didn't fly by air. He only took 1 plane, I think, in his life. And he was very, very local. So he had a lot of people that were around him and that would bring paintings and works, or that would, from Sarti to Carlo Orsi to many, many people that he would trust and who purchased things for him. But it was a very precise collection. It is a very precise collection. On the other side of that room, which was supposed to be the passage to the afterlife, remember we are in Torino, and one of the 40 rules, the Book of the Dead is in the Museum of Egyptology in Torino. So, of course, the passage to the afterlife is very important. On the wall, near the window, on this top floor, which has a Portuguese Renaissance bed, beautiful works by Starnina, so many wonderful artists in the room, is this painting. And this is the story of this painting today. So, I've told you what Rivoli is. I've told you a lot about Cerutti. Now, in 2016, we started working on this research on the works, and also parallel doing all the conservation work on the furniture, the paintings, and the books. But I forgot to say, his collection of rare books is perhaps one of the most beautiful in Europe, at least. Miriam Foot did the entries for that, for the catalogue Raisonner, together with other people, because of his being a binder of democratic books, so perfect binding. He obviously, his other side was collecting rare books, and we have, for example, the Pneurotomachia Polyphili, which was bound for Jean Grelier. We have 3 books that were bound for Jean Grelier. We have the Ortelius Theatrum Orbis, which was bound for Cosimo Terzo de' Medici as a gift for someone. We have quite a number of books that are important more for their bindings than for, it's not a collection of books based on I want the first edition of, it's more about the bindings. So we had lots of papers, and Fabio Cafagna, one of the art historians working with us, received boxes of papers also from a former secretary of his. And researching these papers, and also the art historian who was writing the entry for this part of the catalogue noticed something which he thought was similar to a painting by Jacopo del Selaio that was in the Zeri archives, where most art historians in Italy go. And then he also found a Sueda photograph of a painting. And there was a letter that was addressed to Mr. Luzzeti. Now, who is Mr. Luzzeti? He's an art dealer in Tuscany, who we discover had bought the painting in 1985 at an auction, at a Christie's auction. Therefore, in a period when the provenance studies were not done so egregiously as they are today, as we heard this morning by Christie's, also because we're speaking pre-internet, and research just has become a millionfold now compared to before because of the digitalization of the world. It's not that we are better people, it's that the world has changed, science has changed, everything has changed with people scanning, and of course the internet searches that we can do today. So, speaking with Lynn Rother, now Mr. Cerutti bought this painting from Mr. Luzzeti, presumably around 1987, so Luzzeti kept it for 2 years, and had no knowledge of this having, as was told this morning, and at that time of the letter that we found that was not in his papers, but in a kind of cross-referencing of different archives of papers. It was a letter from 2007, so Cerutti was already like 85, and I spoke very closely with an assistant of his who knew everything about the history of the collection, and there was no knowledge about this passage. So some things along the way, somebody must have put away this letter and never shown it to Cerutti, because Cerutti was incredibly in good faith. He was always, I mean, the persons who were taking care of his collection had no knowledge. He was already dead, so I couldn't ask him the question. He died in July 2015. But he was such a generous man, you know, giving money every year to Médecins Sans Frontières, to this, to that, and the others. So I'm sure that he had no knowledge of this. So what we did was, with collegial advice from my good friend, Lynn Rother, and with a lawyer, of course, the lawyer of the Cerutti Foundation, because in the meantime, the museum manages the collection, and we have it, I don't know how you say, on a kind of a long-term or permanent loan. But there is a chairman, there was a chairman, which was the younger sister of Cerutti, Andreina Cerutti, who just died a month ago. And she died more or less at the same age that her brother had died in 2015. So we, with the lawyers of the Pedersoli Mario Napoli, we write as foundation, but supported by the museum, we write to the Holocaust Claims Processing Office the following letter. I'm just being really detailed because I thought it could be interesting, and you gave me all this time, like an enormous amount of time. So, thank you. So we just write out of the blue on the 16th of October, 2018. Dear sirs, we write on behalf of Fondazione Francesco Cerutti per l'Arte with registered office in Italy, blah, blah, blah. And we refer to your letter dated January 3rd, 2007, through which you informed Mr. Luzzeti that the painting Madonna and Child attributed to Jacopo del Solaio belonged to the Unger family. Now I will tell you why we are talking about Unger and not Gustav Arendts. It's because Anne Arendts, one of the two daughters of Gustav Arendts. Gustav Arendts was born in 1867 and died in 1936, just a few months after buying this painting from the St. Lucas Gallery in Vienna. So the two sisters, Lisa and Anne Arendts, they receive the collection. It gets divided, and Anne gets 60 paintings. And she's married to Friedrich Unger. So basically the heirs are now called Unger. And Friedrich Unger, who obviously loved his wife very much, really searched for many, many, many years. He dies well before her. He dies in, let me just check because I'm not that good at memories. He dies in 1954, which is interesting because it's like 2 years before Cerutti goes to America and brings perfect binding to Italy, after which he binds 50 million phone books for 50 years, and every single book that's paperback in the entire country, more or less. Never married and never had children. So Anne Arendts, who was married with Friedrich Unger already, but let me tell you something, let me stop that for a second, and after I finish reading the letter, I want to tell you something about the painting, because we are talking about art here. So we get to talk about a little bit about the incredible quality of the works that we're talking about. So we were at the word Unger family before it was confiscated by the Nazis during Second World War. We assume that such letter was sent to Mr. Luzzeti, most likely in recent years, to the art collector, Mr. Francesco Federico Cerutti, because we found it in these papers of another person, because we collected all the papers and cross-referenced them. So, both unaware about its long and troubled history. Mr. Cerutti had left his prestigious collection of works of art that consists of numerous sculptural and pictorial works that go through the history of art from the Middle Ages to today, ancient books, precious ligatures, furniture and furnishings to Fondazione Francesco Federico Cerutti per l'Arte, which, in order to respect the testamentary will of the collector to protect, enhance, and offer to the community his artworks, has reached an agreement with the Castello di Rivoli Museum of Contemporary Art, which will soon exhibit to the public the entire collection in its new house museum. It's been, by the way, put under a vincolo di collezione, which means that there's no way in the world it can ever be sold, because nothing individually can be taken out of it. And it's therefore entrusted as a museum open to the public. Fondazione, among the artworks of the collection, there is a painting that can reasonably be referred to the painting you referred to, although the letter U on the back of the table, meaning tavola, is not present. Why? Because in that letter of 2007, there was an asking if Luzzeti, if there was a U on the back. This is because the U was Unger family, because all of the works that were in Paris, which we'll get to, and which were taken by the ERR and so forth, were taken to Germany. And one crate, number 116, was lost in the process. So whether it stayed in France, God knows what. Through the American forces, all the paintings, the 60-2, were sent to the Unger, Friedrich and Anne Unger's home in Berkeley, where they installed them, except for the 2 that never got to Germany even, most probably, and therefore didn't have the U on the back of it, which is another mystery that I hope all you people who deal with provenance studies, even though it's not provenance, but it would be very interesting to understand who stole that crate, because that crate has 2 paintings in it. One is the Selaio, this, and the other is the Tintoretto, the Holy Family, which has never been found. It's in the arts register, loss register, but it has not yet been recovered. So we're convinced, Fondazione is convinced that Cerutti would have been pleased to establish a constructive dialogue with you and clarify the respective rights on the painting, and to this purpose it has instructed us to reply to your letter, which was found by our client only recently among the deceased assets, aimed to inform you about its intention to find an amicable solution for the destination of the painting that might take into account both the rights of the Unger heirs, in respect of which we wait to examine the supporting documentation, as well as the public aims of the foundation and the museum. We remain at your disposal. Now, I have to say, the lawyers worked, Rebecca Friedman, who's a wonderful lawyer at the Holocaust Claims Processing Office, worked with the Studio Napoli very efficiently, and this was all resolved by mid-2020. But I, who always work in contemporary art, somehow believe that the things that people do when they're alive, and they're sometimes not written down in papers, so you don't find, it's the oral history of conversations that actually occur between one artist and another, between a collector and an artist and so forth, are very important. So I will tell you one story, which is my phone call with Grete Heinz, which I think did it, actually, because I just believe in human relations a lot. And I think what I told her was, your mother and father lost it once, you know, the painting of your grandfather he bought. It's in a public museum. It can't be sold unless it's given back to you, and it will go into an auction, and who knows where it'll end up, in Saudi Arabia, in Russia, God knows where, who knows. do you want this painting to be lost twice? Francesco Federico Ceruti loved it. He put it next to the bed where he thought he would die. Shall it be lost twice, or shall it be lost only once? And she's a wonderful woman, and she agreed that it should be lost only once. So we should make an agreement, find an agreement. So the story of the painting now, because it's a very interesting work. But before the story, something about this work. This work has been variously attributed to different artists. How much time? 1 minute? Oh, I didn't have a lot of time. Okay, well then I'm going to summarize. I thought I had 45 minutes. I'm going to summarize then. So the painting was attributed to Raffaello del Garda when it was bought. And then it was taken for restoration to the Accademia der Bildende Kunst and so forth, attributed to Jacopo del Selaio, and was that name until it appeared basically on the market in the 70s as a Botticini. So it's a very it has many characteristics which I would have told you why it's a Jacopo del Selaio and not Botticini, and neither Raffaello del Garda, but we won't go into those. But it's very interesting and unique because it has San Giovanni and the two angels, and the little boy is a sculpture in a way. It's a painting of a sculpture, and the sculpture is in the Bargello in Florence. It's by another artist, and I would have told you how the whole story of the inspiration that Jacopo del Selaio had, which brought him to this painting. It's not in a tremendously good shape in the sense that it's been marouflaged because of a certain number of issues. But what we did in the end was we got an estimate on the value, and the family got an estimate on the value, and we just made an average, and that was it. And we paid compensation to the heirs. The heirs are Grete, who was the daughter of the two, but also the heirs, Heinz, 3 brothers, 1 sister, 2 brothers, who were the daughters of another person. Okay, I got her here. Just a minute. We have to get it right. So Grete marries Heinz, and she has 2 children, and so the children are the heirs together with her. So in the end, what was resolved without any court. This was the back. I wanted to tell you all about the back, but maybe we can do another conversation. And here we have the families, Gustav Ahrens with Friedrich Unger and Gita and all the other relatives, and also little Anne is, Grete is the little one. She had the painting in her, that's Anne, she was really looking for it, the mother of Grete, for many, many years until she died in the mid-90s. So it all falls into nothing until in the mid-90s. But Grete remembers, this is the Sueda picture that we used, that was giving us the idea that it was the correct one. This was the first request in '49 from America after many attempts. By the way, the family was not treated well by the French, I must say, even prior to the Vichy and to the invasion by the Germans that then sequestered the paintings. But the French government was absolutely not helpful. After the paintings arrived in Paris in '39, they tried very hard to get them out into the US. They fled to the US in advance of the paintings. And there was always one excuse, another excuse, another excuse. You can't get them because you're not French citizens. You can't be a French citizen because you haven't stayed 3 years in France and whatever. So they struggled well before, and they lost the paintings twice. This painting and the others, they lost once in Vienna because right after the Anschluss, he was arrested and spent 3 weeks in Dachau, then was released paying money, and then they were allowed to go away paying money. And then they went to France, and then the story I told you. But what I wanted to end on was that there was one more thing that they asked us, and it's another funny story, very quick, but they asked us for copies of the painting, and 3 were supposed to be the full size, and 3 were supposed to be half size for a certain number of relatives. Grete remembers having breakfast with this painting in the breakfast room before she was 8 years old when they had to leave Vienna. I was terrified. As a person in art, I don't want fakes to be around. So I was saying, I can't make copies. I mean, that would be terrible. Then in 100 years, there'll be 6 Jacopo del Celayos running around. And then they wrote to me, the lawyer wrote to me, said, no, Carolyn, they just want photographic prints. So I said, okay, fine. So this is Grete today in Berkeley with her Jacopo del Celaio, which is a digital print in the era of digital art. So there we go. And that's the story. Do we take questions, or is that no time? Okay.
Thank you very much, Caroline, for a beautiful and lively presentation. Beautiful and lively presentation, much appreciated. I am now going to introduce I think it's our 3rd panel, called Fair and Just Solutions, a Matter of Justice. And it's with great pleasure that I introduce the moderator, Tilbury Hodge, who happens to be a lawyer working in the same firm as I do, Constantine Cannon. And I will let Till introduce his panel. Thank you, Till.
Can you hear me? Yeah? Excellent. Good. Delighted to be here, and equally or even more delighted to have to have the privilege of introducing our panel, which will focus on the claimant side of the story. So I have on my far left Anne Weber, who is the founder and co-chair of the Commission for Looted Art in Europe, and who has, over the years, represented many claimants and helped them in their cases, as well as having represented their interests in policy terms vis-à-vis governments, including the Italian government. Then I have Jutta von Falkenhausen on my left. Jutta is a lawyer in Berlin, and one of her clients is the estate of Max Liebermann, the famous German impressionist. And she will talk about that. And of course, speaking about claimant's interest, what comes to mind is Max Liebermann's famous remark when sort of talked about the prospect of the Nazis taking over power in Germany. I cannot eat quite as much as I would like to be sick. So that's probably to just put it in the context of the sort of claimant side view of things here. Now, but we can obviously all agree on that. On my far right, we have Stephen Zack, who is a partner at Boyce Schiller Flexner, and in Miami. And Steve's firm is the one that is representing, and Steve is representing personally, the heirs to Lily Cassira, who was mentioned beforehand, and will be able to add his great experience to this panel. And then to my right here is Felix de Mares Oyens, who is the president of the BH Breslauer Foundation, and also formerly an employee or representative of Christie, so has additional great art market experience. So with all that in mind, are we ready to go on the presentation? I would like to invite the panel to share with us, as a first point of call, their personal experience in dealing with artworks and other collectibles subject to spoliation in Italy and more broadly Southern Europe, and in particular to give us your assessment regarding the chances of recovering and or finding fair and just solutions in those territories. Now, Anne, I think you're first. Yeah.
Okay, so, okay, thank you. I think that to answer that question very briefly, ironically, you stand much more chance today of recovering a work of art in a private collection in Italy than one in a public collection. And our experience of trying to recover looted works of art in public collections, both state and municipal in Italy, is dismal. It's a record of almost complete failure over a period of 20 years, except for one painting which we recovered by accident, and I'll tell you about that. But let me first show you the 3 looted works of art, which are still today in Italian public collections. So this is a Vincenzo Foppa, Annunciation, which is in the Museo Civico di Crema. Do you want to go forward? This Zenale, which is in the Pinacoteca di Brera in Milan, a Madonna and Child. And then this, not that one, then let's go forward. And this one, which is Alessandro Moretto, Portrait of Federico Martinengo, which is in the Museo in Abano Terme. And if we just keep with them for the moment, thanks. So both the first 2 come from the same looted collection, the Gentili di Giuseppe collection, which numbered over 70 paintings, which was seized in Paris in March 1941 and sold at auction at the Hotel Drouot in Paris in April 1941. The Moretto, the last one you see, was seized in Vienna by the Gestapo in February 1944 and comes from the Priester collection. And over a period of 20 years, we've made recurrent efforts to recover all 3 paintings. And I should say that all 3 of them have been published by the museums. They've all been published with an accurate and comprehensive provenance, showing that they belong to the Gentili di Giuseppe or to the Priester collection. There's no denial that they once belonged to those collections, nor that they were looted. But that's not the issue. The issue is the Italian museums consider that they have no obligation to restitute, and they view that issue through a solely legal prism. And if I give you the example of this one, the Moretto here, because the explanation is the same with all the paintings, Abano Terme has repeatedly said to us that it acquired the painting in good faith and has no reason to negotiate any settlement, let alone a fair and just one. The recurrent theme in all 3 cases is the same, that the institutions acquired the works in good faith and have legal title, that the paintings are part of the patrimonio pubblico or public heritage, which the institutions have a duty to keep intact, and that because the works were acquired in good faith, they have a responsibility to abide by the principles of good public administration and not return them. We have, however, by accident or good luck, recovered another painting, which is the Romanino, which, if you go back, I think, this one, which was also in the Brera in Milan and also from the Gentili di Giuseppe collection and sold in France in April 1941, which also since 2001 the Brera had refused to return. But in 2011, the Brera made the mistake, fortunate for us, of lending it to a small museum in Tallahassee in Florida, which, inexperienced in these things, forgot to fill out the immunity from seizure forms. So we were able to have it seized by the US State Attorney in November 2011. And 2 months later, in February 2012, a US federal judge ordered it be returned to the family, and the Italian government decided not to fight the case. So, and if I can just, before I finish, two more points that I want to point, two more paintings that I want to mention, which are affected by the lack of access to a fair and just solution in Italy. And I'm going to refer to two paintings from the Fritz and Louise Gutmann collection, both of which Simon Goodman, who many of you will know, who's with us on a video link, has asked me to mention. So one of these is this Veronese, which was taken in Paris in 1940. And the next one, which is a Brouwer, thank you very much, which was taken in 1942 in Holland. They both, as I say, they reflect another side of the lack of refusal to provide fair and just solutions, because what that means is that nobody has any incentive to provide information, which is what Giuseppe was talking about earlier. Simon traced the Veronese to a gallery in Rome, where it was in the 1980s, but the gallery has been unwilling and unable to provide any information about it. And the Brouwer has been published a couple of times as in a private collection in Italy, but similarly, Simon has been unable to obtain any further information in order to locate it. So these are just two additional aspects of the unwillingness to provide fair and just solutions. And I should add, if anyone knows where the Veronese and the Brouwer are, please let me or Simon know.
Thank you so much. And Jutta, over to you.
As Till mentioned, I represent the heirs of Max Liebermann. Max Liebermann was not only a famous painter, but also an avid art collector. He owned many beautiful pieces of particularly 19th century works, including this Monsieur Arnaud on horseback by Edouard Manet. He had bought it in 1913, and it hung in his country house for many, many years. There are pictures showing Max Liebermann in front of this painting. Max Liebermann died on February 8, 1935. He was survived by his wife Martha and his daughter, her husband, and a young daughter. His daughter and her family emigrated to the United States in December 1938. Martha Liebermann stayed behind, and when she realized she had to get out, it was too late. She committed suicide in March 1943 when the Gestapo was about to take her from her home. Martha Liebermann sold the painting, which you see, to the Tannhauser Gallery in Berlin in April 1936. The Tannhauser Gallery sold it on to Walter Scharf, a Jewish manufacturer of playing cards, who later emigrated to Egypt. And in 1939, Walter Scharf sold the painting to Carlo Grassi, an Italian industrialist, and who later, in 1958, his wife donated it to the Galleria d'Arte Moderna in Milano. That's where the painting still is today. Under German law and practice, German law and practice under the Washington Principles, the sale of the painting in 1936 in Berlin by a Jewish person persecuted by the Nazis would be considered a forced sale or sale under duress. A German museum, faced with the facts which I've just pointed out, would clearly feel the obligation, the moral obligation, and under Washington, the quasi-legal obligation to restitute or to find a solution with the heirs. Now this painting is in Italy. And in 2011, the Liebermann estate for the first time wrote to the Galleria d'Arte Moderna and asked to help in looking at the provenance and pointed out we have a provenance problem here. They didn't get a response. We tried again a few months later or a year later. I referred to my letter and didn't get a response. Now, 2 years ago, I tried again, and finally I got a response with the not quite complete provenance the Milan gallery had researched so far, and with sort of complete, I'm sorry to say, complete lack of recognition of what this meant. Basically, as Anne was saying, after 2 years of increasingly good correspondence, basically we heard, yes, it was acquired in good faith. Neither Milan nor anyone here has anything to do with it. This might be the case, but still we are dealing with a painting that would be considered looted art under the terminology of the Washington Principles. And we need to find a way to talk about this, to acknowledge this provenance, and to find a way to resolve this. And I must say, I'm very glad that sort of in the preparation of this conference, the GAM seemed to understand more of the necessity to talk. And I'm very glad that Paola Zatti is here today and approached me and said, we want to talk, and so I think we will do that. And maybe that might be a piece of very good news after this conference.
You want to mention the...
I'll mention it later on if we have time.
Excellent, okay. So over to you, Steve.
Well, first of all, I want to thank you for the opportunity to speak today in what is truly one of the most beautiful rooms I've ever seen. I woke up today, and being from Miami and surrounded by water, I wasn't sure exactly where I was, and then realized that I was also in a fabulous city and had the opportunity to address the issues we're talking about today. I've been told that I have 10 minutes, and this case was filed 20 years ago, and the act of theft was over 100 years ago, and this case is one that is unique in the sense that there is no dispute whose painting it was. Matter of fact, we have a photograph, I don't know if it's here or not, that's actually the painting that was displayed, there it is, in the living room. That's Lily Kassir's living room while living in Germany. So there was no question it was hers. It was actually given to the Kassir family by Pissarro. The Kassir Gallery in Germany was one of the most famous galleries in Europe, and actually was one of the galleries that first promoted the Impressionists. So there is a likelihood that you're going to find paintings that have a provenance in the Kassir Gallery when you are looking at these paintings. So there's no dispute about that. There's no dispute that Lily had to sell the painting for $360 to the Nazis to save her life, period. And the sisters that did not do that died in concentration camps. So all these things are undisputed, and it's still taken 100 years for justice. Can you imagine if there was any dispute, how much longer it would take? And justice denied is also justice delayed. And that is one of the real problems with the cases that you've heard about today. I'm not going to go into the black letter law, which I believe everybody in this room knows about the Washington Principles. But I do want to talk to you about things that you haven't heard before in these previous conversations that you need to think about. And that is why the Kassir family should be successful ultimately, no matter what happens. We just argued in the United States Supreme Court certiorari about 2 weeks ago. And those of you who practice in the United States know how difficult it is for the United States Supreme Court to grant cert on any matter. So the fact that they did after the Ninth Circuit ruled against us and after the trial judge ruled against us, which is a story in itself, which we'll talk about when we have more time, that they granted cert was amazing. And we feel very comfortable with the fact that the law as it exists really requires us to win under any circumstances that you haven't heard about today. Well, number one, this painting alighted itself in California for a period of time, and we truly believe California law should apply. We've already talked about choice of law being one of the principal questions here. Under California law, there is no statute of limitations for theft. And it's that simple. You know, we were talking about how long it would take me to discuss this with you, and I said it's a 2-minute conversation. The Bible says, thou shalt not steal. And that should be the beginning and the end of the conversation here. Why it takes so long for these cases being argued by brilliant lawyers to not begin and end very quickly in a case like this, where there is no dispute about the facts, is extremely troubling to me. The other issue that you keep hearing about is statute of limitations. Every statute of limitations in every country begins with notice. You cannot have the statute to begin to run without notice. Now, part of notice is holding something open and in an obvious way. The painting was owned by Baron Thiessen, and he liked it so much he showed it in his bedroom. So unless you were invited to his bedroom to see the painting, there's no reason to believe that the statute should have begun to run. So that's another point that needs to be addressed. So let's talk about the fact that Spanish law should apply. Some people, as was argued here, well, under Spanish law, you have a theory of encubrador, which means an aider and abettor in the United States. And the fact is that what we have here, and I can discuss it as much time as we have in the future or privately, we have absolute willful ignorance. And there is a concept of willful ignorance that has not been mentioned here. This was very difficult to figure out the provenance. All you had to do was take the painting and turn it over and see the stamps that had been removed, or the stamps that were on there to know about the provenance of this painting. We also should emphasize that Pissarro happens to be one of the painters that Hitler had a particular desire to own, because he wanted to eradicate any evidence of Jewish culture or Jewish painters, and Pissarro was one of them. So just the fact that it was a Pissarro painting in itself should have been noticed. I have many, many, many red flags that would have been obvious to anyone, and any one of those red flags would mean that this painting should be returned to its rightful owner.
Felix, I'll put on your slide next.
My father, a Dutch classicist, wed his first Jewish but Protestant wife, Agathe Breslauer, in Berlin during the second year of the Great War. A year later, their daughter Nina, my half-sister, was born in The Hague. Marriage did not last, and in 1925, Agathe remarried her second husband, 44-year-old Ernst Zalman, who was a textile manufacturer in Swabia. On their estate, together they formed the so-called Erlenhof collection, named after the house, of rather conventional, fine and applied art. At the end of 1935, Nuremberg racial laws, and particularly virulent Nazism in Reutlingen, forced the couple to flee by train and without delay to their second home in Florence, Villino La Pace in the Viale Machiavelli. They had to leave behind the factory, their fast cars, and the private airplane she had piloted herself. And apparently almost all pictures, sculpture, books, and other objects of art, which were forcibly sold through the notorious interventions of the dealer Julius Böhler and the Munich auction house Weinmüller in order to pay the nefarious Reichsfluchtsteuer. Just a few of those lots have since been located and restituted or compensated. But only in recent times has it become clear to what extent other artistic possessions awaited the Zalmans' arrival in Florence. Thanks to the researches of Almut Goldhahn, 57 photographs of 44 artworks belonging to the Zalmans have been identified in the photo archive of the Kunsthistorisches Institute in Florence. These images were given to the Institute by the Zalmans, apparently at various stages, notably in 1928 and 1937, as a useful historical record of their property, mostly, but not all, at Florence. So far, 4 of the 44 works have been located, 2 in private hands, a cassone with Carmen Thyssen-Bonamissa in Madrid, and a Limoges plaque of the crucifixion, now considered of somewhat doubtful authenticity, sold at Sotheby's Paris in 2015. And 2 others in the inventory of the Musée National Récupération of the French state, recovered just after the end of World War II in Germany, in order to be restituted one day to private ownership in France or foreign ownership that once went through France. Namely, Madonna da Latte, do you have another picture? That's it. Formerly attributed to Defendente Ferrari, and another cassone, back, painted with a scene of the siege of Carthage by the so-called Anghiari master. The latter 2 works went through the Parisian art trade in the early 1940s and ended up as gifts by their German buyers to Hermann Göring in Berchtesgaden. They now form the subject of our restitution claims with the Mission de recherche et de restitution des biens culturels spoliés entre 1933 et 1945 of the French Ministry of Culture, also known as the Mission Zivy. Thus, it seems clear that the Zalmans were able to take these works, and perhaps others, with them to Nice in 1938, after Mussolini decreed his racial laws and expelled foreign Jews from Italy. In fact, Katharina Hüls-Valenti has discovered export applications. There is until now no evidence that any Zalman art property was spoliated in or by Italy, and none has so far been found in Italian collections, be they institutional or private. In Nice, they lived at 3 addresses from October 1938 until August 1945, when they moved to Paris. In 1939 and the early 1940s, Ernst Zalman was interned by Vichy in 3 concentration camps in the south of France. In August 1940, Agathe suffered a vicious attack in their Nice villa, Cimerose. At the beginning of her exile, she could continue to receive some income from the United States. Vichy and the Italian occupying authorities demanded annual proof of sufficient income for continued residence. And it is at these points that the Zalmans may have been obliged to sell works of art under duress, if they were not spoliated altogether. 1946, Ernst died. As a result of the treatments and deprivations suffered in the camps. In 1948, Agathe applied for French nationality. In 1949, she returned to Swabia and succeeded to repossess their estate and factory. There she was planning to house child refugees through the United Nations, but she took her own life in 1951. My sister, who survived the war in Switzerland, then took up her mother's restitution claims and attempted to extend them to the works of art. A task that I continue with the help of the Berlin lawyers, von Trotz to Solz-Lamek, and their researchers in Germany and Italy.
Thank you, Felix. Thank you, Felix. Let's approach the issue of fair and just solutions. And the question we were wondering, or that I wanted to put to the panel was, is there anything particularly Italian or Southern European in terms of interpreting what fair and just solution is taken to mean? And what impact, if any, does that interpretation have on your particular claims or the claimants you represent? Anne, do you want to start?
Sure. I mean, I think it's interesting that neither Spain, Portugal, nor Italy restitute, nor have any commitment to it. I mean, I don't think you can. There are lots of other countries that don't either, but if you're talking about Southern Europe, I think there is a group of countries that don't. I think it's also pertinent that the Art Loss Register only has, in terms of dealers and auction houses that check with them. There are only 6 auction houses in Italy that check with them, none in Spain and 1 in Portugal. So I think it reflects the lack of interest in due diligence, whether it's stolen or looted works of art. And just in terms of the impact on claimants, I would say that for claimants it means there's no solution until the law is changed, or in any of these countries, and a continuing feeling of injustice. In the case of the Gentili family, the representative heir, if you like, Lionel Salem, who's now 85, who's a very distinguished French theoretical chemist, and who's solved problems in molecular chemistry that most of us wouldn't even know existed, has found this problem completely insoluble and thinks that it's his children and grandchildren that will resolve it. And in the case of the Priester paintings, the heirs there just don't understand that over the last 15 years, as one of them wrote to me, they said, we've been able to locate several of our missing paintings in a number of other countries, some in the hands of private owners, some with auction houses, and the usual scenario was that there was no obligation to return, but we've always received a positive response and a willingness to reach a settlement or restitution. But that's not the case in Italy, where we've had a very rigid and inflexible response. And so Italy lags behind. So I think that as Jutta said, we need to find a way to talk about it. We need to find a way to move this agenda forward. And I hope that in the course of this session, we can do that and talk about what ways we can think of to advance this, so that we're not sitting here in 20 years' time, those of us who are still going, saying, well, what are we going to do about it?
Jutta, do you want to add?
Yes, I mean, maybe just following up on that, it really seems that it's not a question of typically Italian fair and just solution, but the step before. The step before, sort of you were discussing it earlier, the finding out, the acknowledging, I mean, other countries have done this. It's not a question of Italians being guilty of most of these things. Yes, we have heard about the Italian story, but it's about tainted paintings that ended up in Italy or went through Italy, and where other countries, which were not perpetrator countries, like the UK, like the Netherlands, have done a lot to acknowledge that it's not a problem of the actors, but it's a problem the paintings have. And we have to look at them and sort of find a way that brings closure to the paintings and to the heirs.
Thank you, Jutta. Steve, do you let me broaden the scope just
to a little bit, right? Beyond Italy.
Spanish.
But I think there are universal principles here, frankly, that apply to this situation. And I do want to emphasize, this is not just about Nazis, and we could limit it to Nazis. I happen to be a Cuban American, and I came from Cuba in 1961. And I can tell you that when Castro came in and took our family's art, he didn't pay for it. He still owns it. And someday that'll be decided by somebody. It'll be a very interesting case. for a lawyer to talk about a looted painting that is then re-looted by another looter. But that will be determined someday. What's happening now in Uzbekistan and is also going to result in a lot of litigation at some point in the future. So I think how we handle this in principle is something that we should all be able to agree on. At the very least, acknowledge that it's not your painting, that it is owned by somebody else. It is amazing to me that we have had no offer of settlement even to say, all right, you know, let us display it in our museum and we'll put a plaque underneath that says it's yours. That'd be a start. And it seems to me that you have the Cora Declaration that, you know, decided without dispute whose painting it is, the kingdom acknowledges it. Why don't we at least agree when a painting is owned by somebody else, even though you may think that you don't have to pay for it, that it is not yours? I think that's a good beginning. And I don't think it should take 100 years to do it. And I don't think it should take a lawsuit for 20 years. And we're handling this in a way that most other law, we're fortunate that we can afford to do this. But imagine how much it costs or how few law firms are willing to do it, rightfully so, to just say that we're going to spend 20 years seeking justice. It shouldn't take that long.
It's a great point. Thank you, Steve. Any other concrete measures of what can be done, in particular with this Italian stroke Southern European context?
Well, I've
Something which may be pertinent to this. You mentioned about our negotiations. About 15 years ago, we began negotiations with the then Italian government in order to enable restitution. And I have to say that they agreed, the Italian government agreed, and these are their words, that it was morally indefensible on their part to recover artworks looted from Italy, which they had been doing and continue to do, by taking advantage of other countries' commitment to restitution, and at the same time not to return such Nazi-looted artworks as were in their collections. They thought it was an unacceptable double standard, and I quote, that the only legally and morally acceptable way out for Italy is to change our laws. So, and we did begin drafting a law with them. The government was very committed to it. We started drafting a law with them. They wanted to, and again a quote, to put Italy on a legal footing with other countries which have positively tackled the restitution issue. The government then fell, it changed, that commitment didn't continue. But I think that it shows that it needs to come from the top. I think that's where the attention needs to be focused. And I hope that this conference is going to do its bit to raise attention publicly about that.
Thanks, Anne. Felix, do you want to?
Yeah, I've nothing really to, on this score of the Italian and Spanish exception that relates to the Zalman case. But I have two very brief general observations from my experience as a bibliographer. Both Italy and Spain are signatories to the Washington Conference principles. Any attempt to restitution may be complicated by particularly draconian export laws in both countries. The state in both countries, and to a lesser extent in France, is used to declare important art in private hands as national treasure, and thus manipulate their transfer and price.
Thank you. Jutta, your sort of outlook?
My outlook, just to comment on that, this is one of the good things about the new cultural good laws in Germany, which did make a specific exemption to that looted art being returned is not subject to export restrictions. Outlook, I don't know, this restitution committee was mentioned today. Maybe someone here in the room can revitalize that committee and make it aware of the cases we have been discussing and sort of move it forward together with whoever is responsible in the government.
Just to pick up that point, if I may, I wondered whether, I mean, we now have a network of European restitution committees. Tony Baumgartner, you're a part of that. I wondered whether the European restitution committees could invite representatives from the Italian government to the next meeting of the network. And because I think awareness needs to be raised. And if they understand the way other countries are dealing with it, perhaps that will also help in making a bit of progress in this.
I've often wondered why the Human Rights Convention of the United Nations doesn't apply in part here. We had enough issues to deal with without raising it, but there's a lot of brilliant lawyers in this room and watching that might decide to use that as another reason for having their property returned. Isn't it a human right not to have someone come in and steal your property? It would seem to me that it would. So, pardon me?
European Union has such a.
European Union?
Oh, yeah.
Right.
Yeah. Oh,
well,
yeah.
I think that's still, as far as I know.
On the grounds of human rights, you can appeal.
Right, and I'm thinking Italy is part of that convention.
I think at this point, perhaps if we still have a minute or two left, it would be good to open the discussion to the floor. And 1 minute, one question. Giuseppe has. Yes. Is there a microphone for Giuseppe? Or?
You're the next.
Can we have 2 questions? Okay, perhaps Giuseppe and Imke Gielen.
Well, thank you. Yes, as an Italian lawyer, I actually feel pretty embarrassed and, if not outraged, of how poor Italy and little Italy has done, and what the position of the Italian institutions of the government has been. But I think that the time has really come to call for a change of the existing laws. I mean, we have a minister today who has proven to be quite sensitive about reform issues. We have a new head of the legal department within the Italian government, the Italian Ministry of Culture. So I think that an effort should be collectively done to make the laws change and to arrive to a very simple principles, as you have pointed out, that looted art or art that was sold in a kind of a murky situation during those years should be returned without any consideration to, especially if the owner is a public institution. This is unacceptable, totally unacceptable. And I think you should, as international lawyers or, people involved in the art world should really speak out loud and make your voice being heard. Thank you.
Thank you, Giuseppe. There's a final question, Imke Gielen, and then I think we'll...
Thank you, Imke Gielen. I don't have a question, just on the Restitution Committee in Italy. As I said before, we were in contact with them, so I still have, I think, like an email address. Maybe that is helpful. And I think one can also find it online. There's a certain person dealing with it, and they made a positive decision in the case. As you know, it's different from yours, but still, and afterwards, the general attorney deleted the painting from the National Register. So, I mean, there has been some precedent before, so I try to give you the email information on this chairman of this, or this contact for this Italian Restitution Committee, and maybe in return somebody can give me a contact for the Carmen Thyssen-Bornemisza collection, as Felix de Marz-Owen said, that one of the Cassone paintings from the Saumann collection is today with not the Thyssen-Bornemisza and not the Spain government. It still belongs to Carmen Thyssen-Bornemisza, and nobody answers our letters and emails. So if anybody has any contact that responds for Carmen Thyssen-Bornemisza collection, that would be very helpful to me, to Mr. de Marz-Owens in our office.
Thank you very much. So thanks to the whole panel, Anne Weber, Jutta von Falkenhausen, Felix de Marz-Oyers, and Steve Zack.
Thank you very much. This was a really interesting panel. Rather shocking stories. I had a thought actually as I was hearing Anne and Jutta speaking. You're all familiar with the International Council of Museums, which has as its mission to promote ethical rules amongst museums around the world. And it just so happens that the current president of ICOM is an Italian called Alberto Garlandini. It might be interesting to approach Mr. Garlandini and tell him about the situation, because it seems to me that ICOM should be doing something about this. Now, I'm very happy to introduce our fourth panel for the day. The title of the panel is Provenance Research, Methods and Field Reports. And the moderator is Dr. Fürstmeister, who we have heard from earlier. I will hand over the microphone to him. Thank you.
And in order to save time, I might as well start right away while the other technical preparations are taking place here. So, I'm very welcome, and we are witnessing a great or very interesting, definitely, development from the morning until now. And since we still have a minute until the preparations are being done, I'll just try to say or provide a comment, because we, as a group in this room, and probably also in the Zoom audience, are what you may call the middle level of professionals. We have the top level of governments, of people who write laws. We don't write them. We have to operate with the given situation. And we are also, because this is a legal and art history jumelage of sorts, we have different perspectives, and one that I think that is really important is information, or information uncovering, and so on and so forth. This is what can art history contribute to solving the problem. That's the key mission of this panel. But also, if I say middle level, that means who is the enforcement agency for the Washington Principles or the Terezin Declaration? We are lacking the enforcement of what has been morally already achieved and resumed. And this is, I think, the point which is very hard to tackle with, because it's above our pay grades. But this is where this discussion leads to and is moving on. So I'm very happy now to very quickly introduce our panel and our speakers. This is about provenance research, methods and field reports. And I would like to insist on, we are in the field of art and art history, yes, but it's always about information, about ownership, about properties, entities of an artifact, and how this can be uncovered, processed. And this is a discussion that was very different 10 or 15 years ago. We now have the digital world that is related to information, and this also plays a role. We have agreed to have a short round of papers, of 4 papers, so we're not going to continue this conversation style, rather it's 4 people talking one after the other, and it is, I have the sequence reversed as in the program. So it's Emily Ebbinghaus on the far right who is going to start from the Art Laws Register in London, and she will have a short paper, and then we'll continue the round. And it's my ambition to be as fast and expedient so we can have a discussion with the audience in the room. So Emily, please go ahead.
Thank you very much. No. we go. Right, I think Caroline mentioned earlier that one of the reasons why we're still looking for Nazi-looted art today is not that we're much better than the people before us, but that we have sources available today that simply weren't around in the last 10, 20 years. And I wanted to give you a few examples of those resources because that's very much what we do at the Art Loss Register. We look at the digitally available resources. And I'm going to take you through this case of a coin pendant that we were asked to research for a private collector who wanted to give it to an exhibition on loan, and before that wanted to make sure that there was not an issue with the provenance. And in a way, unfortunately, we matched this pendant with this registration on the Linz database, which is a database that is available since 2008 and is run by the Deutsches Historisches Museum, and it basically presents objects that were acquired by the Nazis for Hitler's museum project in Linz. And I don't know if you can read, but at the bottom of this registration, it says that the previous owner of this pendant was Alphonse Rothschild in Vienna. So that obviously is a big red flag, a Jewish collection, and so we researched this work further and came across it in another database run by the Deutsches Historisches Museum, the database for the Munich Central Collecting Point, available online since 2009. That is based on records put together by the monuments men after the war when they inventorized objects that ran through the Central Collecting Point in Munich. And you can unfortunately see, not very well, but you can see the little inventory card. And importantly, on the back of this inventory card, it said that our pendant was sent back to Austria in 1948. Unfortunately, that doesn't necessarily mean that it was also given back to the Rothschild family in 1948. This is what we call the principle of external restitutions, where works were returned to the countries where they had been taken from, and it was then up to the countries to return them to their private owners, if they could be identified. Now, for Austria, since 2017, another resource has become available digitally, and that's the Zentraldepot. These are basically cards that look at specifically objects looted from Viennese Jewish collections after March 1938 that were then dispersed to various museums, including the Linz Museum Project. And again, in these cards, we found our coin pendant, and we found that indeed it had been taken from the collection of Alphonse Rothschild, and we also found that it was in the Linz collection, and most importantly, we were able to see that it had been returned to the Rothschild family in 1948. So this was a case where we were able to clear the provenance of a work for the period of 1933 to 45, and therefore the object could go on exhibition with a cleared provenance. These are just 3 examples of the resources we have available today. I have listed many other resources. I think today the problem is almost more knowing which resources to check when and how to check them. You can see police records, Nazi-looted art records. For example, we've talked about the Lost Art database earlier, the Getty Provenance Index for auction sales, but also image databases that don't have a focus on Nazi-looted art, like the Fondazione Zeri or RKD images. So all of these are resources that at the Art Loss Register we check when you request a certificate, but most of them are also available for free and publicly to anyone who is interested in researching objects. Why is this important? I just wanted to finish by briefly mentioning 2 examples. The first is Pissarro's Cueillette de Pois, which some of you might know was seized when it was on exhibition loan in France, and it had belonged to an American collector. It was seized as Nazi-looted art on the exhibition and then returned to the Jewish owners, the descendants of Simon Bauer, and recently sold. And this very public seizure, in a way, could have been, of course, prevented had immunity from seizure been requested. But before you request immunity from seizure, of course, you have to look at the provenance of an artwork. And if that provenance can be cleared and it can be established that it is a safe work, as far as that is possible to say, then that makes a work easier movable and therefore also attractive for various exhibitions. Similarly, if we look at sales of artworks, this is a painting by Max Liebermann that the ALR identified as Nazi-looted art in 2018. And it was from the family of Dagobert David, represented by Anne Weber. A solution was found for this artwork and it was sold at Van Ham in 2018 in Cologne. And it was sold for more than double the estimate. And I think that is not only due to the fact that it's a beautiful painting, but also that it had a really interesting, sad, but also in a way happily resolved story to tell, which increased the interest in the work and therefore at the end of the day, the value. And with that, I'm going to hand over to the next panelist.
Thank you. So it's my pleasure after this very, let's say, first broader overview, that's the idea of introducing you to the opportunities and possibilities of doing research. Now we're going to switch to Christian Huema, who is more, if I can say so, from the art market perspective, or art market studies to be more precise, that has seen quite a research in the last decade. So we have related but independent of provenance research, we have also art market research as a proper entity, and you will give us some insight into this, which is very important. Thank you.
Christian, and thank you for the invitation. As mentioned already, I don't consider myself so much a provenance researcher, but I'm mostly concerned with research infrastructure and figuring out how we can best serve scholarship in various ways. I want to focus here on the big data or biggish data that we have today, and I don't know how to get forward here actually with the, And by preparing that, I had to look back just 15 years ago when I was organizing a small conference at the Getty Research Institute, and it was called Nazi-Era Provenance Research, Archival Sources and Electronic Access. And this was in 2008, and you still have to bear in mind that there was not so much around back then. It was really when it kind of started. It was 10 years after the Washington Principles that were quoted so much, and I think it's not so much known that there is also a clause in the Washington Principles that relevant records and archives should be open and accessible, and I think that's a very important point, and that's what we have been working on globally, I would say, in various ways. In 2008, we had like the beginnings of the Munich Central Collecting cards, digitized the cultural plunder of Einsatzstabsreichsleiter Rosenberg in Paris, Sonderauftrag Linz, confiscation inventory, all these databases started back then. And at the Getty, we had the question, what can we actually contribute as a rather rich institution with rich archival holdings and a record of provenance research? Now, what came out of this search for an appropriate project is something that some of you may know or use even. It was called German Sales, originally in a phase 1, 1930 to 1945, an attempt to digitize all still available auction catalogs from the Nazi era in the German-speaking world, so to say. And it seems easy, but it was quite a challenge because in general, our documents for research are scattered in many different libraries, archives worldwide. I just show you the partners for this German sales project. There were almost 40 libraries in Germany, Austria, Switzerland involved to work on this. So first of all, there had to be a database on the bibliography. It was not even known which library owns which catalogs. And then every single catalog had to be scanned in Heidelberg. It turned out there were about 3,000 catalogs around for this 15 years period. And this made 200,000 pages of scanned documents. And that's what it looks in the web presentation at the Heidelberg Library. You can skim through this catalog. This is a very famous example from the Fischer sale in 1937 in Lucerne. You see marked here also a famous Van Gogh self-portrait. At the Provenance Index, where I worked back then at the Getty, we put it even a step further, because what you get from digitizing, and digitizing is such a word that says so much and nothing, because it can be just a PDF online, but how do you research that? And it can be structured data that can be used so much more. And we put a huge effort into editing, first of all, the OCR text document that came from the Heidelberg scanning process into this production database. You see the record as it looks in the production database of the Provenance Index. It was enriched and enhanced with additional information, with controlled vocabularies like an artist authority that you can better search on certain things. It has prices in it that are usually not in the auction catalog, at least not printed. You have to get them elsewhere from annotated copies, from published records, and all of this has been at least partially been put into this record. You also see the buyer now mentioned at the auction, Wertheim, and you also have a buyer authority for that. So it has been enhanced, it has been enriched, and in the end, a huge resource, I think, came out of it. German Sales 1 has, I said, 3,000 catalogs, almost 250,000 records of transactions on auction in the German-speaking countries. Then there was a second phase, because it was always seen that it should also consider the market before that period. And altogether, it's about, you have available 9,000 auction catalogs from Germany, Austria, Switzerland, and this number is not correct anymore. Today it's rather 1 million database records in the Provenance Index to search on. So it's biggish data, and this is just one database we have, as I said, or as has been mentioned by Amelie before. There are many more, but it has also been indicated that, here is the search page of the Provenance Index. It has also been indicated that these databases are rather silos. You have to know where you have to look at. You need an enormous amount of expertise to research them, and they don't talk to each other. So I think in the future, the big challenge will be, how can we publish our data in a way that it is machine readable, that it can be linked up in the semantic web. The technology is there, the conceptual framework has been developed, and so I think it's in the making. And just one more point, because we also have another issue in provenance research within art history. In art history, provenance research has not a very good standing. We have a few professorships now, but it was a long way. And one reason is, and I'm reading here this quote from Anne Igonet, so many passions in such small spaces, so many epic tales compressed into such dry lists. So this is what provenance looks in catalogs in museums, also in our catalogs at the Belvedere. These are lists, and a transaction very often is nothing more than a semicolon. It's a small sign that indicates that something happens here in the lives of people. So can we do better? Obviously, Hollywood has seen that there is a huge potential, that people want to indulge or learn about these stories. Obviously not all in that is scholarly solid, but we also have to think about how do we tell our stories with data, and this was still something that I wrote into the vision for the Provenance Index before I left, because it's a too big a project to handle. But you see that you can research not only with the Provenance Index the lineage of individual works of art, but also the aggregate behavior of agents in the market, shifting tastes and values, and the flow of cultural objects through time and space. That's the vision. We have the data, we just have not published it and made it available in a way that we can fulfill that. The Getty converts now, remodels the Provenance Index to go into this direction, and I think we have to follow also. Now I'm working at a museum museum at the Belvedere, our collections databases also need to be structured data and published in this linked open data paradigm. And I'll finish in a second, just what you can then do. You can visualize, of course, the data. I talked about the flow of cultural objects. This is a project started with mapping Titian, but you can map paintings, and obviously you learn not that much if you map only one painting, but if you map thousands of individual things, whether it's objects or people, and this is a network diagram taken from the Provenance Index with 230,000 agents working in the European art market in the early 19th century, then you may discover new stories. You may see agents that have not been represented in art history so far. And I come back with a final image with the Time Machine project, because Time Machine Venice is also a huge project that ideally from the vision goes into this direction, and wanted to expand to a Time Machine Europe. So I don't know, have I been too long now?
No, that's fine. Perfect, great. Now, because I think we need this, and we also need this, let's say, dealing with tracking informations. This is, I think this is, we talked about the restitution side too. This is also relevant. That's maybe the result of the final out. This is putting into practice information, and this is the real world. But this is, in a sense, also we are on the level of fundamental research, which is also important. So time is fine. Now I have the very great pleasure to introduce, I don't need to introduce Katharina Hüls-Valenti, because she had the great idea of doing this, what I would call a bridge building event, which is a bridge building event. It's a little bit Germany, Italy, but it's also among the disciplines. So without further ado, please go.
Thank you. Yeah, so I'm now going to talk just for a few minutes about the actual practical provenance research, and yeah, what Christian has already said, there's so many actors on the art market, so I'm going to focus on that. And as we have seen in the previous panels, artworks often pass through various hands. They cross borders, they take unexpected ways due to the movements or activities of one individual, of one art dealer, or one individual who had to fly a country. So in the process of retracing a provenance, various actors become associated to an artwork's ownership history. Collectors, art dealers, mediators, even diplomats or politicians. At present, these individuals often raise questions, and we're having difficulties identifying them. Sometimes there's just one name in a provenance which raises doubt, one gallery or collection label, we have heard about this earlier, on the reverse of a painting, or one document in a paper trail that connects an artwork to a sensitive name. Over the past years, and Christian has mentioned this, project commenced to shed light on the vast numbers of actors that have been in some ways associated with Nazi looting activities in Europe, aiming to reconstruct dealer networks, business activities, and of course the artworks involved. So for instance, the Technical University of Berlin, in collaboration with the Institut National d'Histoire de l'Art in Paris, currently runs a very interesting project about actors of the French art market under German occupation. I'm now going to illustrate why an in-depth analysis of the Italian art market and its actors would be of great benefit to the day-to-day provenance research. So what we see here is an export permission which was issued at the Austrian Monuments Office in Vienna in summer 1938. We can understand from this document that a certain Benno Geiger shipped 4 artworks from Vienna to Milan. We also have the recipient, the shipping company Fratelli Gondrand, and a short description of the artworks. We can identify a painting with the title Rape of Europe. Another one is called Venetian Folk Festival, probably Il Carnevale. Then there's a drawing of a girl, and the 4th work depicts the finding of the Holy Cross. Geiger also assigned values to each artwork. Someone seemed to have amended them. What is missing, though, is the artist, which makes the identification of the artworks and their provenance very difficult. Now, why does this document worry me? The first reason is the name of the applicant, Benno Geiger. To some of us, this name won't be new. Some might know him because we are in Venice, and Benno Geiger was raised and spent most of his life here. In fact, his letter estate is preserved by the Fondazione Giorgio Cini, and he is still today known for his important translations of Italian literature, as well as his publications in the art historical field, for example, on the late Baroque painter Alessandro Magnasco. But to others, and this is where we get to the topic, his name might ring a bell because he has been associated with illicit art trading and Nazi looting activities, both in Austria and Italy. For instance, immediately after World War II, the Art Looting Investigation Unit, the special task force created by the US government, investigated Benno Geiger's role in the Nazi art trade. And more recently, his name has appeared a few times in publications about Jewish expropriations in Vienna. And in fact, about the same time when Geiger applied for the export permission to Milan, he handed in 2 other export requests. As we can see, I hope you can see it, their destination was not Milan, but instead the Nazi headquarters in Munich, where the listed artworks were to become part of Adolf Hitler's private collection. Research has shown that those 2 export permissions consisted of Jewish-owned artworks which Geiger had helped to identify and expropriate from Jewish art collectors in Vienna. The 60 watercolors were a result of the so-called Altaktion, the comprehensive Nazi grab of artworks by the artists Rudolf and Jakob von Alt, and the 3 Waldmüller paintings originated from the very famous Bloch-Bauer collection. Hence, if the 2 out of 3 export permissions consisted of expropriated artworks, I find it legitimate to pose the question if the artworks for Milan had the same provenance as the other ones. And if so, where did they end up? Just to outline one starting point for further research, we heard about this earlier today, the historic documents in the Uffici Esportazioni, the export offices in Milan, could help identifying the artworks in question. Because Italian export offices at that time often documented incoming and exiting artworks with photographs. Hence, if the shipping company declared the freight in Milan, documents might reveal more information on the identity of the artworks and subsequently could lead and allow a reconstruction of their ownership history. Now we stay with Geiger's activity, but we fast forward to 1944 in Florence. To the end of the war, properties in Florence and its surroundings were subject to looting both by fascists and the Germans. Daria Braska has spoken about this earlier today. In July 1944, Germans occupied the Villa Landau-Finali. We can see parts of the villa here, and the owner, as Daria has said, was French, so he was considered enemy property at that time in Italy, and its precious art collection was transported to Bolzano. Once arrived there, the collection was inventoried by the German art protection squad, the Kunstschutz, and then sent on to one of the art deposits in the Alps. After the war, parts of the collection were recovered by the Allies, but comparisons of the inventories revealed that a considerable number of artworks was still missing. To this regard, historic documents from the Italian Office for the Recovery of Artworks lead us again to Benno Geiger. In this letter from 1947, the former superintendent of Florence, Giovanni Poggi, please don't read the whole document, but just points out that Benno Geiger had assisted the Germans as art expert in the seizure of the Landau-Finali collection and presumes that Geiger himself could be in possession of some of the missing objects. The theory that Geiger might have taken some objects with him to Venice was further supported by the fact that the Italian police had recently found valuable books in Geiger's home in Venice, which had been looted from another Florentine art collection about the same time as the Villa Finali. So now, for time reasons, we want to keep it short. This is just a short and narrow insight of Geiger's activities. But I hope it became clear that such documents call for further research. So to go back to the greater picture, at the current state of affairs, actors like Benno Geiger and other art dealers who did business in Italy or were Italians, still raise many questions in regard to their involvement in Nazi art trading and looting activities. And subsequently, art objects with any connection to such individuals require a careful revision of the provenance. Particularly because after the war, many of these actors continued undisturbed their dealing activities and could have potentially sold stolen objects. Hence, the Italian art market of those years needs further investigation. It needs to be clarified who and to what extent did business with the Nazis, both in and outside of Italy. And in addition to what we've heard earlier from Daria Brasca and Bianca Gaudenzi, we must comprehend as well which role the art market played during expropriation processes under fascist rule in Italian cities.
Thank you very much. And you are bringing You don't need this, no? The important issue of complicity, which we didn't mention before. So that's another point here. So it is my great pleasure now to move, because this is not moving, because we also stay within the topic of art market, because Donata Levi, we were granted the possibility to do something at the Villa Vigoni on the fascist art market, which was a very new topic 2 years ago or 3 years ago. And I'm very glad to have you here. You're professor at Udine, and we did the Transcode AA project together. And so, please.
Thank you. Thank you to you and to the organizer for this invitation. In the HERA project, which was mentioned just now by Christian, in the HERA project on the circulation of cultural assets in the Thank you. In the HERA project on the circulation of cultural assets in the Alpe Adria region in the 20th century, some members of the Italian team, Daria Brasca and Elena Franchi, have focused on the fate of Jewish assets. Some results are already available in the source edition entitled Contested Space, Contested Heritage, edited by Michael Wedekind and by me, and published online in open access, and soon also available in a print edition. Other results will soon be published in 2 months, within May 2022, in the proceedings of 2 conferences organized by the Transcult AA project and edited by Christian and by Barbara Morovec. The online source edition collects archival documents both on confiscation and on restitutions of Jewish cultural assets, seen according to that transnational perspective that the tormented geography of those territories necessarily require. Within this framework, provenance research has obviously played an important role and occasionally produced some specific results. But the reconstruction of itineraries and shifts in ownership of artworks was mainly instrumental to a new understanding of transfer processes as a whole, that is, to their motives, to their circumstances, to the juxtaposed authorities which prompted them, and to mechanisms of power, to the trajectories of objects and of peoples, and to their long-term consequences. For us, as historians and as art historians, provenance research is one of the tools we have on our desk in order to investigate the meaning of cultural assets within a community, within a nation, or on a political or cultural chessboard. Cultural objects easily undergo processes leading to semantical occupation, resemantization, and reinterpretation. Indeed, we have seen how some objects became pawns or hostages. Many were simply considered commercial assets, or indeed worthless or provocative representations of a repudiated past. All come to be loaded with sentiments, emotions, and feelings. However, neither the wider topics of circulation of artworks and transfer processes nor provenance research as such are strongly present in the agenda of the Italian art historians, both academic and museum people. As regards Jewish assets in particular, an important effort was made in accordance with the Washington Declaration with the appointment of the Anselmi Commission, the parliamentary commission which also Bianca Gaudenzi mentioned this morning. Its task was to investigate the acquisition of the assets of Jewish citizens by public and private bodies before and during World War II. A huge enterprise which unfortunately has not affected art historical research at all. And this despite favorable premises which could have paved the path. On one side, the Commission collected a certain amount of documents from the archives of some local superintendent offices, thus highlighting the importance of this kind of documentation. On the other, it frankly acknowledged in its conclusions that much was still to be done and that many grey zones still remained in the panorama of Jewish dispossessions. One may wonder whether this grey zone could also be extended to the presence of Jewish cultural objects in the Italian museums and institutions. At the end, this presence was excluded, but simply because there was no evidence of it among the documents of Rodolfo Sivieri, the so-called Italian 007 of art. On the contrary, today we know that museums can still hold a few surprises in store, literally in their stores. And that, however, there are many different ways through which an owner can be dispossessed of his art belongings. Not only confiscations, but also forced sales, strong pushing for voluntary donations, and so on. As a matter of fact, my impression is that provenance research in general here in Italy is at a very low ebb. Quite recently, in the summer of 2020, the working group which was also mentioned this morning, the working group on restitution, was appointed by the Ministry of Culture. Bianca Gaudenzi is expert consultant, also member of this working group, and obviously surely knows better than me, but this group, headed by Alessandra Barbuto, is working hard, but, and this is important to say, without budget. And the budget is important because archival research, which is crucial in provenance research, has to be done in Vienna, in the archives of Vienna, in the Bundesdenkmalamt, in the State Archives of Vienna, and in Germany. And also, and maybe, first of all, research has to be done systematically in the archives of the Superintendenze and of the museum, a most precious but fragmented repository of national memory. The Superior Council of Cultural Assets, an advisory body of the Ministry of Culture, has recently advanced the proposal of a systematic census of this archival documentation and on the creation of a documentary system in order to reconstruct and recompose in a unitary and integrated framework all the activities that have involved the cultural heritage in its broadest sense. Protection, conservation, but also in these papers, acquisitions, exports, monitoring of private collection and monitoring of the art market. I trust this could be very helpful for provenance research as well. Yet, at the same time, I am not confident about the acceptance of this proposal by the ministry. Anyway, what impresses me after working within an international project like Transkult AA is the intense commitment of large teams of scholars to the subject of provenance, the existence of powerful and well-organized national and or collective actions, and the consequent development of also of refined research methodologies. All this happens abroad, but it strongly contrasts with the lack of systematic and concrete initiatives on the Italian side. Network and freely accessible, also simple to use databases are indispensable steps in order to fill this gap. But before this, there must be political will, and this is another story. Thank you.
Yes. Thank you very much. I'm very happy because I'm also very grateful to the four speakers because we are on time. That means we have 15 minutes. I don't think if any other panel managed that. So I want to engage with the discussion with you on this very topic here. And I want to add one specific thing because I invite questions, and that is we have been talking about information gathering, collecting, processing also. This is what the task of this panel was. But there is another dimension here that also needs to be in our heads, and that is the moment you provide data, the moment you publish them, they can be accessed and worked worldwide from very different perspectives. That is the task of sitting in a black cave with a flashlight looking around. The databases are the flashlight. They uncover fates. They make it possible for descendants to identify things. So this is a work that is I would like to call this crowdsourcing information or crowdfunding information. The moment museums publish their works online, it becomes accessible. You can work with the information and all the other databases you showed too. So this is something beyond what we can steer or control because it's the information that is out. And this is another dimension that I believe is powerful and to have in mind. Having said that, is that a raised hand? Please go ahead. Yes, first question. I don't see the person, or please say your name.
Hi, the person is Mara van Tolle. You know me well. I had a question to Christian, actually, regarding the data autobahn or the data motorway, which has been in the talk since 2017, since you introduced it. And you said it's in the making. Is that the thing that it's in the making? I mean, the question is there not enough funding or is there not enough people working on it? That was my first question. Second question is, if our firm, for example, has gathered so much data that even our own systems are failing to cope with it, what do we do with it? How can we make them public?
Oh, okay. For the latter, but please start first.
The first question I can only perhaps address from the Getty Research Institute side. So this remodel of the Getty Provenance Index into linked open data has been started in 2016 or 17 and was supposed to be a 3-year project and has still not been finished and made public, but it's very far, I gather, and it should be out very soon. And obviously this needs to be adopted by many other institutions, and I'm a little bit frightened if it takes so much resources and energy for the Getty, although they had to convert 2 million data records into this new data model, which involved a huge amount of data cleanup and so on. I'm afraid that smaller institutions with less funds will need much longer or can address the issue only later, but linked data is a huge issue in the digital humanities, and it's on the way, I'm saying, because it's conceptually worked out and thought through, and the big institutions are dealing with it, mostly in the Anglo-American world. And I have now at the Belvedere a huge interest that the Getty shows us how we can convert the provenances that we have in our collections databases into structured data, into this, converted into this data model, so that it connects automatically with the source documents that are published in the Getty Provenance Index, for example. So there are these possibilities. It's just not, it's not available yet. It will come, I'm sure, but perhaps I'm too optimistic.
Yeah, and the second question, I mean, this is also a question, I believe, to the Atlas Register, because they have growing data numbers every day, every second, I assume. And I wonder, where is Maike Hopp, because she's the digital person, I don't see her right now, but I have most confidence into information technology, into data processing. I learned mechanical typewriting when I was a student. So I have seen so much development. If this continues, you don't worry about storage, server, hosting, and anything that means is, we don't have to worry about the technical. I have complete faith in possibilities of storage, accessibility, all this. This is not our problem, not. We have other problems that some of you also, or we also encountered in projects. This is getting to archival documents and making institutional repositories talk and available and accessible. This is the much bigger, it's not the storage. So that would be my short, anything to add?
We need also maintenance of systems.
Yes.
This is
okay, sure.
For temporary projects,
yes.
This is always a problem.
Yes, and Donata, and I also really like it very much that you speak about the funding issue, because I would like to boil it down to there either is funding, then there is research, or there is no funding, then there is no research. It's as simple as that. This is my experience. I mean, look at, that was my morning introduction, 2008. Money is being made available, research starts and happens. Before, not. So it's stupid, it's very simple. So if money can solve the problem, then I wonder why we don't get more money. But that's another issue. But you wanted to say something. No? Okay. So, any other? Yes,
Not
please.
the money person.
Yes, next question, microphone, first row.
I do agree with you, Kristen, that it's very difficult because sometimes this working in silo, as you said, I liked it, this idea, like adventuring in these databases is incredibly cumbersome and complex. I think we also not only need money, but a new generation of specialists and researchers, because it's a lot to do with the new generation. They are digitally savvy in a way that, I don't want to say that we're old in this room, but, they're younger and faster and quicker, and they have a DNA to research, an attitude to research that we don't, So that's actually also what is changing, a lot. But we need to guide them. I think people like you need to guide them in how to avoid these silos. That's essential because it really makes research faster. And so I think that we need more workshops, classes almost on how to do research, practical.
Yeah, it's obviously an issue, and it's an issue in any institution. I even have it at home at the Belvedere that is very hard to even hire people for a collections database that brings in the art historical knowledge that you need when you want to publish collections data, but also brings in the best practice experience with how you prepare data and how you publish data. And these people are already out there. Sometimes my successor at the Provenance Index really has it all, but they are rare still, but I think it will develop fast. The digital humanities, digital art history world is growing very fast, and there will be more and more people that can help us out with expertise.
Yeah. Next question, Elisabeth Royer. Yes. S'il vous plaît.
Why it's so difficult to get in with small institutions sometimes, or big museum, the photograph of the painting and the photograph of the back of the painting. Before the big data, all these should be visible in internet.
It's funny because I think I made a, sorry that I jump in here right away, because I'm such an advocate of open collections and open data, and I managed in my institution at the Belvedere that you can download pictures in print quality for free, and often also the backs, because I believe that this is the easiest thing that a museum can do for images where there is no copyright anymore to provide access to high-resolution images of the work, because it owns, it belongs to the world, it belongs to the taxpayer in Austria. There is no reason why we are entitled to hold information like that back. I'm completely convinced, but then we are still, I think, the only museum in Austria who does it, and I cannot understand it, because for me it's what museums should do.
I think if I may bring in the market angle there, I think with COVID we have seen a massive change in how auction catalogues work today, and we see a definite change of reverses being put up in the initial cataloging, which, for example, makes my work much easier, because I don't have to ask every time for the reverse when I want to check an item. Quite often it is now published online. However, that is not true for every auction house, and it's certainly, unfortunately, not true for the auction houses that we work with in Italy. So there is a movement there, I think, to make information available to the collectors who want to buy these works and who are interested in them, but it is still a work in progress as well.
And I mean, it's the back of the photographs. I mean, the museums, they are also, let's say, within their own hierarchies. They have ministries above them, they have provisions, they have regulations. You are, let's say, I think our podium is also speaking from the privileged position of the pure researchers, which is always easier to do and to say, because we have nothing to lose or to gain. There is, as far as I can understand museum policies and museum administrations, they will not easily cooperate with Google in order to do that. This would be possible. There is Google Arts and Culture. You could do this. I don't see there are no legal restrictions, but there are all, let's say, concerns behind. So.
First of all, you don't need Google to publish your collection. Every museum has their collection in a way online, but just with tiny little images, and you cannot download them. This is a policy decision to make them downloadable in print quality. You don't have to ask the curator, you just take it. It's so easy. And the one thing why they always say they don't do it, because they make some money with reproduction rights, but I know it from several big museums, the income from reproduction rights is so small that to administer the rights issue costs the museum more than the income is. So it's completely, I cannot get it.
Yeah, this would be a step, but also making more archival material available, I think, would be also relevant.
Yeah, I just wanted to go back for a moment to Italy, because I think if we're talking about big data, we have to bear in mind that in Italy, and I'm speaking for museums, but also for archives, we are far behind. I mean, we're not even speaking about digitalization yet. I think we're speaking about getting to know what we have in a museum's collection, what we have in an archive. For example, import-export documents, they do exist, but they're not accessible in many, many cities. And these offices, they're not even aware of what they have. They look at me and they ask, why would you want to see an export permission request from 1938? They are not aware of the topic. And they often respond to me, we don't have the stuff, we don't have the time, we don't have the money to make those documents accessible, or to just show them to you. So I think for Italy, we really have to think smaller, and also for the museums or for collections, we very often don't know what kind of artworks, or we cannot Google the entire collection of one random museum in Italy, because they don't make it online. They maybe don't even have a website, or just a really simple website. So I think there are really many questions if we're doing research, and as you said, the Italian auction houses too, there's really often an open end, because we don't even get to see the documents, the documentation. We don't even get to understand
whether this artwork is in that collection or not.
Yeah. And I think there's one good example because we also would need the archivists in this room here. Yeah. I mean, providing inventories. There is WGA, Wiedergutmachungsakten in Germany, so it's the post-war restitution files. If they are inventoried and you could search online just for the names, you don't need anything else, you don't need the contents of the file, but only to be able to find the names is a major step forward, and it speeds up processes like much, much shorter. So, please.
In defense of superintendents, but it's not always. It's an issue of ill will. But I have to say, from the Italian point of view, superintendents suffer of a lack of staff, which is dramatic. And I mean, we have no archivists in the archives of the superintendents. We have no officers. I mean, it's really a big problem, a big issue, which has to do with archives, but with protection of art heritage at a whole. And at the same time, I know, we all know that sometimes the archives are closed because also of a sort of jealousy for the documents. But anyway, there is this, I mean, this big issue that is a lack of staff.
Yes, but I mean, but I think this is already an achievement if we agree as a panel that we realize the borders, we realize the obstacles, and maybe we have some ideas how to overcome them. But some of those obstacles are too big because they require funding, money, staff. All the things we cannot provide, we can only provide smart thinking. And I think we have portrayed the idea that this is basically possible. And with saying that and no further questions in the room, I think, what? Daria?
The project.
Oh.
It was a,
yes, please go ahead. I think we do. Okay. So who is going to talk? Oh, you are going to talk about this.
no,
Okay, yes?
Great, thank you. Nick O'Donnell again. Hearing you talk, I wonder your thoughts on connecting all the things you're talking about to younger people. And by that I mean, I'm no longer a young man, but when I was, I worked at an art museum, and I did a lot of these things. And this was almost 30 years ago. And if I'd known, or this had happened by then when I was a younger undergraduate, I would have done it for free. And assuming the best intentions and good faith of everybody in all these museums, which people can quarrel about, but let's think optimistically. You know, is there a way for the experts to connect to the aspiring students, you know, the art history students now? A lot of these things are hard. A lot of objects have dead ends, but a lot of objects are staring right at you if somebody just starts to connect the dots. And that's, you know, progress is obviously, you know, better than none. I'm just curious what you think. Thank you.
Yeah, that's a major challenge, and as far as possible, we try to cope with it. So we do have first-year students, freshmen, and we hire them as wissenschaftliche Hilfskräfte, studentische Hilfskräfte, whatever is appropriate in their ranking there, to work on projects. So they, without having even touched previous ordinary art history, they jump right into data processing and transcribing object card files and things like this. So it is out there, and it is happening in a number of places, and this is very important because we need many more well-trained people to do this. So there's work ahead of us. So, and yes, and I think the idea was to show that this has just been published, made available, launched.
It's just, I mean, a byproduct in some way, a product of Transcult AA, and which was edited, published by me and by Daria Brasca, and it's also a lockdown product. And we had material about the fate of synagogues and Judaica in the Alpe-Adria region. We took in consideration 4 cases: Trieste, which is maybe the most important because of the importance of the community, and Opatia, Rijeka, and Gorizia. And I mean, we did a sort of history of the synagogues and of these synagogues and of their contents during the 20th century. And it was thought for a general public. I think HERA required to have also a more general diffusion, not only scholarly, not only scholarship, but also a different relationship with the public. So we tried to do this sort of website in order to diffuse the stories relating to these 3 synagogues and to those who cared for them. Thank you.
Yeah, thank you very much. And and now we're rushing for the coffee break.
Thank you very much. Really, really interesting panel. Thank you. It's now time for a tea break or coffee break for those who need a bit of, energy. And it's a short one. We'll come back ideally in 15 minutes. For those who are listening online, we're back, say, 4:20. Thank you.
Okay, we want to restart? Everyone, if you can just please sit down, we are going to resume now. So we will now start with our last panel of the day, Doing the Right Thing, Nazi-Looted Art in Private Collections, moderated by Luigi Mattioce. Luigi, the stage is yours. Thank you.
Thank you. So thank you for enduring until now. I am assuring you that this is one of the most interesting panels because it goes to the core of our entire conference, which is doing the right thing. Again, doing with what is right is a philosophical concept in se, and we are, among lawyers and professional and art experts, so what is right is a very difficult question to raise. Starting from my far left, we have Richard Aronowitz. Richard is an author of several novels and an expert on German expressionism and restitution. Until very recently, he was the head of restitution for Sotheby's London. He has one additional motive to be here because his mother came from a family of Polish-German Jews, and she was persecuted during the Holocaust. Friederike von Brühl, she is a partner with K&L Gates Berlin office. She covers a broad range of experience from transactional advice to copyright, IP, and IT litigation. And again, she has an additional hint to be here because she has a master in art history. So with the double qualification, obviously, she has one additional boost and motive for being here. On my right, we have Isabel von Klitzing. Sorry for the pronunciation. Isabel is an art lawyer, and she spent her entire career in the issue of finding the provenance research and art consulting. This is the name of her firm. She founded in 2012. Before doing that, she was a senior researcher at Sotheby's, London. So again, Isabel is a very passionate art lawyer for this very matter. I don't have to introduce once again Pierre, although Pierre is a star art lawyer. He also teaches at Sotheby's Institute, Christie's Education, and is a business school in Beirut, Lebanon. So, he has a number of reasons for being here. I will leave the floor to both Isabel and Pierre. They are presenting some slides named after the importance of a provenance research and negotiated solution.
Where's the gadget?
Yeah.
The clicker. Yep.
Thank you, Luigi. In the next 20 minutes or so, Isabel and I will focus on the following hypothetical scenario. A private collector inherited artworks acquired during the between the 1930s and the 1990s at public auction and from high-profile or high-end art dealers. Say that our collector hires an art advisor who alerts him to the fact that many of his artworks are listed on the database known as Lost RDE, which is, one of the top, one of the key databases where Nazi looted art is recorded. Our collector is at first surprised. He's never heard of lost RDE. Then he's angry. Then he becomes depressed because far too much time has passed since these artworks were acquired. There's no claim outstanding against the auction houses or the dealers from whom they were bought. And so what is he meant to do? This is a classic case, and it illustrates what we have discussed already at length, the tension between, on the one hand, the collector who has cared for artworks for a long period of time, having inherited them or acquired them in good faith, and on the other hand, the family of the owner wrongly dispossessed during the Nazi era, who in this case registered those artworks on Lost Art DE. Now, the Jewish family may have a life legal ownership claim, or the collector may have a rock-solid defense against such ownership claim. Irrespective of the legal position, the collector and the Jewish family may take the view that they have no interest in spending years in court. And let's recall that the 2009 Terezin Declaration on Holocaust-era assets that followed on from the Washington Conference principles of 1998 specifically provides, and I quote, "Private institutions and individuals, not just public institutions, are encouraged to achieve just and fair solutions, with due regard to privacy rules and regulations." Now, that's an important point, and we'll come back to that, because there are fundamental differences between a public institution and a private collection. Private collectors have legitimate claims to privacy, dictated by family relations. One branch of the family doesn't want the other branch to know what they have. Physical security, insurance, and taxation. Some do not always declare what they have. And the potential interference from the state. We've heard that in Italy, for example, the state has the power to list artworks as national patrimony. The risk, now, our experience is that privacy is often one of the principal drivers behind the decision collectors make to undertake a private and confidential review of their collection. The risk, if they do not, is that they consign an artwork for sale. The artwork is published, for example, in an auction catalogue. That results in an ownership claim. The sale cannot proceed, and the dispute falls in the public domain. That's bad for the collector, and that's bad for the artwork. At this point, I'd like to introduce the concept of an audit. By audit, I mean a systematic review of the provenance of artworks with one objective: identifying red flag names in the provenance, suggesting that the artwork may have been unlawfully appropriated during the Nazi era, or looking to fill in gaps in the provenance for the period 1933 to 1945. Now, what motivates collectors to audit their collection? Well, first of all, if the collector plans to transfer his collection to the next generation, he or she might not relish the thought of transferring problematic artworks to the children. If the collector wants to consign artworks for sale, again, as I said just now, the risk is that the artworks may end up being the subject of a claim with the risk of bad publicity. And the same risks presides over a loan or a gift of the art collection to a public institution. The reputation of industrial families has been tarnished by their association with the Nazi regime. Now, some have sought to set the record straight by telling the story as honestly and openly as they can. There have been books published by certain families basically telling the story of their Nazi past. And for some families, in that situation, it can be good PR to be seen to check the family's art collection and if any artwork looted by the Nazis is found, to be seen to return it to the family from whom it was taken. And then there are collectors who simply take the ethical view that they can't live with having in their collection artworks that were stolen or unlawfully dispossessed, shall we say, during the Nazi era. Now, before you start an audit, there are a few things to consider. The first thing is agree the purpose of the audit. What are you actually doing? And on this slide there are two examples, one from the Metropolitan Museum in New York, and the other one is Isabel and I drafted it until, the three of us, when we started auditing a private collection. We'll come to that in a moment. What is the scope of the audit? It's important to agree that in advance and to record it in writing. Are you going to audit the entire collection, or are you going to focus on certain elements of the collection? It could be by reference to value. I mean, very low value artworks generally have no provenance and are almost impossible to research. So you might decide, okay, let's not focus on that. It could be by reference to collecting category. By way of example, ceramics and works on paper are generally don't have a provenance. So you might say, why bother with those? We're going to waste our time. Or obviously date. There's no point in researching works that were created after 1945. It would be important to estimate the number of artworks to be audited because that will dictate the size or how you design your audit team and also the likely cost of the audit and the timeline. A few more things to bear in mind. Who are the stakeholders? In other words, the parties interested in the audit and the outcome of it. It could be, it would generally be family members. And if it's an extended family, it might make sense to identify, who within the family are the stakeholders as far as the audit is concerned. It could be a board of trustees, especially if the collection is in a legal structure. If the family runs a business, the leaders of the business might also be stakeholders. And questions you will want to ask yourselves are, are they aligned, these stakeholders, behind the audit and its objectives? Are they in agreement with the potential solutions that are being proposed? Next point is selecting the auditors. The choice is typically between insiders, i.e. stakeholders, or outsiders, i.e. independent advisors. What we have found that works for us has been a team of insiders and outsiders, a combination of provenance researchers, lawyers, art experts, and if the audit is in the public domain, PR specialists. I promise you they will be needed. Because conveying the message in the right way is almost as important as carrying the audit itself. And of course, if the collection has a an in-house curator, it is essential that he or she should be part of the team. Access to data and to the artwork are essential in order for the provenance researchers to do their job. I mean, I thought, no, this is not the right one. Okay, something has gone wrong. Anyway, it doesn't matter. Well, it will matter. Okay, there's a couple of slides that have gone. What I wanted to show you is the back of a painting with lots of labels, but we've seen backs of paintings before, so that's fine. Confidentiality, I mean, that's a key issue for private collectors, and the question is, will you keep the audit confidential, or is it in the family's interest to disclose the fact of the audit and maybe other aspects of it? Documenting the audit, that's also important because provenance research has value. If you can show a clean provenance for an artwork, its value is enhanced. The same applies if you can plug a gap in the provenance between 1933 and 1945. Importantly, if the credibility of the audit is ever challenged, you want to be able to show what you've done, how, why, and what did you conclude. The next question is, that's not on the slide, but who will make the hard decisions as the audit progresses? If artworks looted by the Nazis are discovered, then assuming the decision is to find a just and fair solution, who will make the decision? Who will make that decision? And what the just and fair solution might look like in each individual case. Planning the audit, color coding, unfortunately, for some reason the slide has disappeared. This is an important question because if you audit a large number of artworks, you need to decide how you will organize them. In past audits, we have adopted a color coding methodology, and I wanted to show you a pie chart with works in the different categories, being green for artworks where we conclude that there's no issue, red where we conclude that there is a big issue and it's a candidate for restitution. Generally, we find that most artworks fall into the amber category. Why? Because there isn't enough information on these artworks to be able to make a decision either way. You will want to keep the data secured. That's important too, and you need to think about that in advance, not just the family archives, but also the provenance research itself. And we've worked with IT specialists to come up with a system that will keep the data safe. And then legal privilege. All the confidentiality agreements in the world will not protect you against the risk that, especially in countries like the UK and the US, if there is litigation, you might need to disclose in court documentation that you're not very comfortable disclosing. For example, the advice you were given and whether or not you acted on that advice. Now, legal privilege protects the confidentiality of most communications between lawyers and their clients. And in the event of litigation, the law accepts that such communication can remain private, which is why when you put together your audit team, you might want to retain an outside lawyer and to channel sensitive communications through him or her. And now I'd like to invite Isabel to tell you more about a private collection we have been audited in the last 6 years. Isabel.
Thanks, Pierre. I'm now going to show you the first example of a restituted work from the Rudolf August Oetker collection. In this case, the history of the company itself has been published in the first instance, and as a next logical step, the company decided to have their art collection audited. The audit of this private collection is, at least in Germany, a great exception and will hopefully serve as an example for other private collectors. For confidentiality reasons, we can in many cases not reveal any details of the objects we are working on, but this example is already in the public domain. So on the slide you see a painting by Hans Thoma, Frühling im Gebirge, Dancing Children, acquired at auction in 1954 by Rudolf August Oetker. On the right-hand side, you see the cover of the auction catalogue from 1954. The painting is very large and very heavy, as you can see from the measurements, and it's oil on plaster on canvas. It was created in 1874, together with 6 other wall panels of a seasonal circle to decorate the garden hall of a villa in Frankfurt am Main. At the beginning of the 20th century, Albert and Hedwig Ullmann acquired the villa together with all 7 wall paintings. They were distinguished art collectors and amassed a significant collection. Albert Ullmann died in 1912 and left behind his widow and their 2 sons. After the Nazis came to power in 1933, they were persecuted because of their Jewish origin. In spring 1938, Hedwig Ullmann emigrated via Italy. One of her sons lived in Milan, to Australia. She was able to take a great part of her belongings with her to Melbourne. Other artworks were sent to Arthur Kaufmann in London, a refugee dealer from Frankfurt, and sold on behalf of the family during and mainly after the war in the 1950s and 60s. The Thoma paintings, however, were sold in Germany prior to Hedwig Ullmann's departure. The motivation of the sale might have been the size and weight of the paintings and that there were 7 of them. On that slide, you see 4 of the wall panels standing on the floor in the villa in Frankfurt after having been dismantled in the 1930s, and our painting is the second on the right. Hedwig Ullmann consigned the panels to Galerie Heinemann in Munich, who acquired them in September 1938 for 35,000 Reichsmark. In November of the same year, Friedrich Zinkgraf, a long-time employee of the gallery, took over the art dealership when it was Arianized by the Nazis. Our Thoma painting was part of the business assets. It remained unsold, possibly again due to its size and weight. Zinkgraf died in 1954, and the Thoma was sold as part of his estate sale at Roman Ketterer in Munich. On this photo, you can see our painting hanging on the wall during the auction. Next slide. This is an extract of the text of the auction catalog from 1954, mentioning that Albert Ullmann acquired the house in Frankfurt, which means including the wall paintings. Hedwig Ullmann died in Australia in 1945, and her heirs listed the work on lostart.de. In the course of investigating the collection, we matched our Thoma painting with the piece listed online. Following further research, the Ullmann heirs have been contacted and a final settlement was reached. The painting was returned to the Ullmann heirs and is now part of the collection of the Historical Museum in Frankfurt. Pierre is now going to talk about this and other potential solutions.
So what can negotiated solutions look like? The first thing to say is that each situation is unique and must be considered on its own merits. It's a balancing act. In the case of the Thoma, sorry, the slide is missing, something went wrong. In the case of the Thoma, I wanted to show you a slide with the facts, a list of the facts that led the family to the decision that the painting should be returned to the Ullmann family. One of the key factors there was the fact that Mrs. Ullmann had sold the painting in Germany during the Nazi era. She was Jewish, she escaped. It wasn't clear, 100% clear that she had collected the sale proceeds. We found out that other collectors in possession of Ullmann property were returning the property to the Ullmann family, and so the Oetkers decided to follow those examples. Options we have personal experience of. One is selling the artwork and sharing sale proceeds with the heirs. I can't show you the next slide, but the next slide, basically, there were two next slides. One, to show that artworks that are restituted can reach very high prices at auction. And a painting by Max Liebermann. There's a famous painting by Max Liebermann, Horses on a Beach. I think the auction estimates were 350 to 500,000 pounds, and it sold for a record price of 1.7 million pounds. And there are many examples like that, as I'm sure Giovanna and Richard would attest. Second option is to keep the art and compensate the heirs financially. Third option is to return the artwork to the heirs with or without a payment of a sum of money by the heirs. That can be justified sometimes if there is clear evidence that the family, the original owner, sold the artwork, received at a fair market value, and collected the sale proceeds. The idea is, should they receive the price twice? And finally, putting the decision on hold. That is where there isn't enough information available to be able to make a decision, but the hope is that more information will become available later. I will now hand over to Isabel again, who will give you a real-life example of an item for which financial compensation was paid to the heirs. That was their preference, and the item was retained by the private collector.
So this is our second example. It's a windmill cup by Tobias Kicklinger, created at the beginning of the 17th century. Drinking from this cup can make you very drunk, since you have to empty it in one go, as it cannot stand on its foot, and you have to drink it while the wings of the windmill are still turning. On the right-hand side, you can see the entry for the cup on lostart.de. This entry has been deleted in the meantime, but I will explain that shortly. The cup was once part of the large collection of Henry and Emma Butke. The couple was also from Jewish origin. Henry was a banker. He died in 1928 and was survived by Emma. Here you can see them, two images of the couple and the Butke Palais, which is in Hamburg and was acquired by the couple in 1900. Following the death of Emma Butke in 1937, her art collection was sold by the organized Jewish auction house of Paul Graupe in Berlin in October 1937. The Butke heirs were deprived of the proceeds of the sale. Here on the slide is the cover of the catalog and an image of the windmill cup. The windmill cup was sold to Theodor Fischer Luzern. The auction house was also mentioned in the last panel. In this case, the sale protocol has survived in the Landesarchiv in Berlin. In 2009, it was acquired in good faith through our client from a Swiss dealer at TEFAF in Maastricht. The only provenance given was Swiss private collection, and the cup had not been recorded on lostart.de at that point. The entry was made only in 2011. As Pierre already mentioned, our client decided in this case to do a deal, taking in consideration all facts and circumstances just mentioned. The Rudolf August Oetker collection paid financial compensation to the Butke heirs and kept the silver cup. It was ensured that the relevant entry on Lost Art was removed, and in this case, our client decided not to claim against the seller. However, this could have been an option, depending on the applicable law, the terms of the sale and purchase contract, and of course, the relevant limitation rules.
We're close to the end. Now, on the right-hand side, you see a painting by Karl Spitzweg called The Echsenmeister, which is another painting in relation to which a resolution or a settlement was made. The issue there is the importance of identifying who are the rightful heirs. And in that case, the situation was that the Oetker collection wanted to return this painting to the family of Leo Bendel, the owner from whom it was taken. The question was, who within the descendants of Leo Bendel should it be returned to? when Leo Bendel died in a concentration camp, his estate passed to his wife. They had no children, and the family tree was rather complex. It took us several years to obtain the documentation from the German courts confirming to whom the painting should be returned. Isabel?
Just to add that this was our second example to show what kind of record prices paintings can fetch with a clear provenance. So now I'm coming almost to the end. Well, Pierre already mentioned potential PR work. It's always hard to find a balance between the need for privacy, discretion and security of a private collection and the desire to reassure public opinion that the audit is conducted seriously and professionally is challenging, and one should bear in mind that privacy does not necessarily mean secrecy. If a private collection decides to go public in regard to the audit and its results, management of the press is an integral part, since any restitution-related topics are typically attracting a lot of media attention. From our experience, it helps enormously to have a PR specialist in the audit team, Pierre said that already, to decide, for example, when is a good moment to go public. In a large institution, this might be a member of the press department. In the case of the Rudolf August Oetker collection, it had been decided at the outset not to go immediately public in order to start the research process in peace and to avoid to be put under time pressure in regard to potential results. The strategy had to be adjusted when a French journalist published an article about potentially dubious provenances of silver items from the collection that were part of an exhibition in Toulouse in 2016. Due to the excellent work of the head of press and his team, any further press covering the auditing process has received a very positive media echo. And I think if you look at these two headlines, it becomes very clear. It's from La très mystérieuse collection Oetker to Oetker is showing the world what to do with Nazi-looted art. So what are the key takeaways of our presentation? We encourage you to take a proactive approach to remove any cloud hanging above your collection. This will also create a good climate when it comes to negotiations with potential claimants, and if an issue is spotted and resolved, the value of the asset can increase. The audit should be tailor-made to align your objectives. It should be mapped out at the start, including an estimated timeline and costs. It is crucial that all stakeholders are fully understanding the implications of the many possible outcomes if a work in the collection is found to have been unlawfully dispossessed, in order to decide on the best course of action. Find the best balance for your collection between the need for discretion and the desire to reassure public opinion that the audit is conducted seriously and professionally. Also remember that it becomes much easier for potential claimants to locate a lost work if there's more information out about the works in your collection. And last but not least, the fate of artworks within the same collection can be very different, and most of these cases are not black and white. Facts and context for each case need to be considered in a very differentiated manner. You should, however, make sure that any decisions taken on different artworks are as consistent as possible and comply with your internal guidelines. Thank you very much.
Thank you very much. Thank you, Isabel and Pierre, for giving us some brilliant example of experience, so real life experience. Now, coming to the same approach, which is problem-solving approach. Richard, say that I am an Italian collector, whether famous or not, Mr. Epifanio Agnelli Mazzanti Viendalmare. And I have a huge collection, and I want to sell a piece of my collection. I have some doubts about the provenance, although my Italian lawyer is telling me, I mean, go ahead, no worries, because you had it for more than 20 years and there is no dispute about the ownership. I want to sell the piece, and I come to you and ask how about it? What would be your real-life suggestion to me?
Well, my first suggestion would be to understand more fully what the doubts are, how serious these doubts are, what flavor they have. Are they doubts purely to do with 1933 to 45 ownership issues? And if they turn out to be legitimate doubts and the work was in fact lost or sold under duress, I don't think any auction house of note or any major dealer would be willing to offer the work without remedying the taint, if the taint was still unresolved. So whatever the legal situation of the current owner, it's very hard for someone like me to recommend hiding behind the law. We have in the auction houses and in the art trade internationally the remedy, the tool of the Washington Principles, which, as we've discussed today, aren't strictly legal remedy. They're a moral, ethical remedy to solve historical wrongs from 80 or so years ago. So one thing I wouldn't recommend at all is to hide behind the law, which is, I guess, the case, as we've heard today, is the position of many institutions around the world. That's certainly something we would never recommend in the art trade. Don't hide behind the law if you have a piece with a problem.
And I mean, would you suggest to go public as per one of the possibilities shown by Isabelle and Pierre with a PR agency or something else?
It's not traditionally how I would have worked at Sotheby's. I mean, much of what we did in the restitution department there was generally quite below the radar. We got on with our fine-toothed comb approach through thousands of lots a year, from £2,000 up to 20 million, looking for those very unresolved 1933 issues. We discovered probably tens per year, and some would turn out after further scrutiny to be works that were actually returned after World War II through the efforts of the monuments men and women and others. Others remained until this day unresolved. And it was very rare in my experience, talking from this sort of European end of the operation, that a private collector would either try and hide behind the law or wouldn't understand the issues at hand and try and resolve them with our guidance and input. And the input wasn't just me and my team and Lucian in New York, but it was also very much with the expert departments, who of course usually have the first relationship with the current owner.
Thank you, Richard. Frederic, I mean, I am the same guy. My doubts are bleaker now because I discovered that my piece is registered in the German Lost Art database. And I know that you are a big supporter of the Lost Art database, and you have used in your, personal experience as a lawyer. So what will be your approach to me, what I should do? I mean, from your perspective, I come to you and ask what you believe it's the right thing to do now.
Okay, yeah, thanks. That's an important question for collectors worldwide. Yes, on a very basic level, to give you background on it from the perspective of a lawyer practicing in Germany, and maybe for those of you who have not worked with this database in practice yet, it's a database hosted in Germany by the German Lost Art Foundation that, as we've heard several times today, that documents Nazi-looted art and also other cultural property losses for this particular critical time frame between 1933 and 1945. The idea behind this database is threefold. It's, on the one hand, it's bringing transparency into the art market for Nazi-looted art, into the art market and the art world in general. It's secondly about incentivizing further research for those objects that are not well documented. And last but not least, it is about encouraging the negotiation of fair and just solutions. So with this background, this database has really changed the market, I believe we can say. It is a very important part of the due diligence of every decent auction house, of every decent dealer, of anyone wishing to act in good faith in the art market. And the fact of an item being registered in this database is by no doubt a red flag. So it is impossible, basically, to sell this in the ordinary market, an item that is registered in this database. Now, coming to your collector, with this very interesting last name, what would I recommend him? Well, first thing I would tell him is, obviously, you have a problem. You cannot ignore this problem. You have to do something about it, and you have to find out more about it in order to determine the right strategy. So what do you do to find out more about it? The first thing you do is you reach out to those who have registered this item on the Lost Art database, and you ask them to provide evidence that supports this registration. Then you review this evidence carefully together with your advisors, and then based on that you will see where you stand. Is this a document that is an item that is well documented, or is it a work that might need further research? So if it's a clear-cut case of Nazi loot that is well documented, you can enter into negotiations right away, negotiate a fair and just solution, find a solution with those who have registered this item. If it's not documented in a very detailed manner, you might need further research. And what you should be aware of is that on purpose, the threshold for registering items in this database is not, after all, not very high. It is a plausibility check that happens. The plausibility check is maybe a bit stricter or stronger than it used to be in the early days of this database. However, it is still on purpose that you can register items where there is a suspicion, but where there is no certainty at all. As we all know, it is part of the problem that these items are very often not well documented, so we need to acknowledge that, and one of the ideas of this database is to encourage further research. So you will find many items in here where there is not much more than a suspicion and where there is not much documentation at all. So now, coming to a practical case to share with you a recent experience from my own practice, and in fact this was a case that Isabel and I have worked on together for a number of years until very recently. This was actually a collector who was very much in the same situation like your Italian collector, Luigi. It's not an Italian one, another international collector who realized that there was a work from his collection in this database. It was a painting by Max Liebermann, a small painting showing a woman hanging up laundry, typical sujet for Max Liebermann. And in fact, when we reviewed the evidence that the registrants had shared with us, we realized very quickly that this work was not well documented at all. There was very poor documentation, and in fact there was a provenance gap between 1931 and the 1980s. And in this entire time frame, there was basically nothing we knew where the work had been and what had happened to it. What was clear, however, from the outcome was that in 1931, the work had belonged to a family who, in the years thereafter, suffered terribly, a terrible story of flight and loss and everything we know from in these typical circumstances from family histories. So this is where we stood at the beginning, and the collector we advised took a position that I would very much encourage collectors to take in circumstances like this. I would also encourage the Italian collector in your example to take if it turns out that the work in this case is poorly documented. He said, I don't want to have Nazi looted art in my collection. I realized there is a work in my collection that is in this database. It's poorly documented. I need to find out more, and I need to fund research in order to identify the truth. And this is what we embarked on. Isabel and I helped him. Isabel did the provenance research. I covered the legal part. We also had another team member in our team, Sibylle Groß, who covered the family research angle, because that was an important component in this research as well. Well, there were many research avenues with dead ends, but ultimately, based on Isabel's research strategy, it turned out that this particular work by Max Liebermann had not been looted by the Nazis. The family who owned it had to flee Germany. They went to Switzerland, then to France, and finally to San Francisco. And in fact, the work went to San Francisco as well. It was saved for the family, and it even remained in the family until the 1980s, very likely until the early 1980s. So you might wonder now, why was it then registered in the Lost Art database? As sometimes in situations like these, there was a family situation where there had been a divorce, so some parts of the family lost contact with the other parts of the family, and those who registered it were not in contact with the divorced wife who had received back then the work. So that's why the information about this work simply got lost within the family, and that's why this work ended up in the Lost Art database without any bad faith, but it was just in there for lack of knowledge. And with this provenance research project, we were able to find this out and to identify these circumstances. So in the end, based on this provenance research project and on the information we obtained here, we were able to have the Lost Art entry deleted. As a side effect, 2 other items were removed from the Lost Art database as well, because they shared exactly the same story as this work. And the Liebermann work we worked about is now in the fully acknowledged in our client's collection and exhibited in a museum in northern Germany.
Nice. So that was an happy ending.
It was, in a way, a happy end. I mean, what is kind of the lessons learned? What is the takeaway from this story? I would say it should really encourage collectors, not to hide away, not to remain silent, not to accept provenance gaps at all. Ultimately, it won't help anyone if there's a lack of information, if there's uncertainty. No one has any benefit from it. And a provenance gap is something one needs to face, one needs to embrace, go about it, find out the truth. It's to the benefit of everyone, ultimately, to have transparency and historical truth.
Thank you, Frederic. So basically, the message to the private collectors is not to hide your head under the sand. If you have doubts, try to come clean. At least you engage in a research, and you want to know more, because it does not benefit you and your collection, but the global system and also the art world. I'm conscious about time. However, I would encourage 1 or 2 questions. Yes, I have 2, so that's it. Please. Thank you. Say your name and the question.
I'm Mara van Tochtolli from Berlin. I totally agree with Federica about this approach, especially not only for moral reasons, but also for financial reasons, because in the end, a work that is listed is unmarketable. So when you hide, you cannot sell the work, which is not the point. I mean, you want to think about maybe also your children. Do you want to leave them looted art in their collection? Which would be a shame and I think burdensome for the family as well. And the second point is, I also totally agree, you have to do the research. That's the only task that really remains for both sides. And I also had a case where a painting was registered, And it turned out that actually it was taken out of Germany to the UK. Then the wife of the deceased Jewish persecuted person remarried in the 50s and sold the painting for a large sum, I think, with some London art dealer. And we could find out, we went to the dealer and actually saw her name, but with the remarried surname. So we were able to actually clear the painting by researching in London, and the case was cleared. And the family said that they were very disappointed, but in the end, simply there was someone who registered all the works belonging to a collection with a looted, well, as you say, they might have been looted. But what I don't agree is that it's really easy to register works. It was definitely for a long time. I think it's not anymore. I mean, when you are representing heirs and your clients are heirs of the former victims, there is quite a high threshold right now. I think because of all this trouble with the database, and it was that it was in the front lines for basically registering every work. But I think they are kind of a bit more cautious about this, like in the last 2 years, I would say.
I mean, that's why I said that the threshold is a bit higher now than it used to be in the early days. So as a background, for those of you who are not familiar with the situation in Germany, in 2015, the highest administrative court in Germany has spoken and has made a decision about this, because there were many collectors who criticized this database, the Lost Art Foundation, because they said our works should not be registered in there. They are, you know, there's maybe the provenance is open, but we do not agree that this collection should be able to register our work in there, because it's not sufficient evidence there that it should be registered. And so the highest administrative court in Germany made a decision that the German Lost Art Foundation has free discretion in defining the criteria for this database, and that therefore the practice of the German Lost Art Foundation is fine. Thus, I believe the debate has calmed down a bit. At the same time, I believe that these litigations, and there are still some litigations pending, have kind of made the German Lost Art Foundation more sensitive about these issues, and they have also understood more and more the perspective of the collectors that the threshold cannot be zero. Yeah, there needs to be a plausibility check. But what is a plausibility check? You know, you can put the level here and you could put it there. So I agree that they have strengthened their efforts, but even though it might be a bit more difficult now, those works that are still in the database from the early days might not have made the same hurdles, you know, and might not have had the same plausibility check than those that are registered today. So you will have a number of items there that have not really made a plausibility check in the sense of today, others that are more recent, and all in all, you have a huge number of works in this database that have not been really checked in detail yet, and that's the point of this database. And I believe, and I think so, the case that Isabel and I did together shows the mechanisms of this database of encouraging research. It really does work, because those collectors concerned realize that, well, they have an issue and they must do something about it. Mm.
Thank you. Our last question, so make it count.
I just wanted, Imke Gier, just wanted to raise one point for discussion or a question maybe to Pierre. The question of deleting lost art search request after a settlement has been found. I mean, there are two ways how to deal with this after a settlement has been found, in particular with a private collector, is delete the search request, the lost art entry, or make a remark that a settlement has been found. And I personally prefer that it stays inside, that the entry is not deleted, so it still shows for transparency reasons what was once there. I know that many private collectors, of course, wish, and then we follow the wish that it's completely deleted. But I really, want to question, especially then we have maybe cases like these, a little bit different, that in 20 years, again, nobody still remembers that there was a settlement, and then maybe the next generation comes again and says, oh, we're claiming this because everybody forgot that there was already a settlement 20 years ago. So, because that now sometimes happens that families don't know what happened in the 50s, it's registered today, and now they find out, oh, we already had a settlement in the 1950s. And so I really want to have your thoughts. I mean, I think I can imagine why the current holders want the lost art entry deleted, but sometimes I really don't know if it's really also for their benefit, the right decision.
Thank you. My point of view is that once the information is out, so you have to manage the information. And in the digital world, the information will remain out forever, even if you delete from the database. So,
but I mean, I absolutely agree with you. I just want to add that I think the possibility to say restituted or settled or these alternatives, I think they have been introduced only maybe 2 or 3 years ago.
Yeah.
So some of our cases, they're already older than that. And then the second thing is that you have to see what the owner or the current possessor prefers to do. It's
Richard.
Yeah, no, I agree.
One thing I would say is that as researchers in our field complain constantly about a lack of paper trail, deleting a registration from lost art seems a sort of backward step from a researcher's perspective. Because we complain so much about a lack of access to documentation. If you then delete the registration, it's another deletion of something you could use in future.
We have a very, very last hand raised, so.
I think just to add to this, the art loss register in a way could be the solution to this problem because it's not a public database, but it is a way to leave a paper trail that would make, and we have the status restituted on our database, so that would be a possibility for collectors who don't want public information out there after a settlement to make sure that a paper trail is left in a source and that can be checked later.
Thank you.
Given you're familiar with both, would you say the thresholds are higher with the Art Loss Register database than Lost Art? Or is that hard for you to answer?
Really hard for me to answer. I think the thresholds are probably similar to some extent. I guess the Art Loss Register has the advantage that it is a closed database, which allows us to basically add works as a red flag, works where we at least are encouraged to ask for a reverse, for example, and to use our registrations as an inspiration to research a work, but where in the end we as employees then have the responsibility to decide whether this is a problematic case or not.
But don't you also have a larger research team at the Art Loss Register? I believe so.
Yeah, I mean, we are.
You have more. I think you have more staff that is working on these research and rather than Lost Art. I think so. Yeah. So I think it is. My impression would be that there is a bit more research done.
So thank you, everybody. I believe that Pierre is to wrap up with the conclusions here.
Yes, thank you, Luigi. This is the end of our conference. I hope you have found it useful, interesting, exciting, and that you will take some of it away with you. It leaves me to thank our amazing speakers. Our generous sponsors, Boris Schiller, Flexner, Konstantin Cannon, Stone, Hague Fleming, and DH Office. Thank you to the Ateneo Veneto for hosting us in this beautiful room. Thank you to our patrons. Thank you, Katja von Sprenger, who's been our amazing administrator. Thank you to our translators, and thank you all for coming and being here. Two final announcements. The conference has been recorded. I hope it has been, and you should be able to watch it on the website of the Ateneo Veneto and also on YouTube. And Mara Wantuch, who is in the audience, has told me, for those who are interested, that she has reserved a table for dinner tonight for 25 people. Dinner is at 7:30, and the restaurant is called Antica Trattoria Posta Vecchia. If you have no plans for dinner, you're very welcome to join her. Thank you, and have a good evening and a great weekend.